Under section 9. This is section 37. The order was passed under section 9. 17. Only 1 day left. You are not upgrading. Let it be as is. Very well, we'll upgrade above the death references. Very well. This will, tomorrow it will appear above the death references after the applications are over, including the windows. Thank you. Yes, you give a slip. Better keep a record. Otherwise, if we forget, then item 39 টা কালকে এই জায়গায় থাকবে। অ্যাপ্লিকেশন গুলো শেষ হবে ডেথ রেফারেন্সের উপরে। Yes.
Yesterday, Lordship, regarding the receiver,
Yes.
Lordships, one Barcam hotel Barcam restaurant, Lordships, it is mentioned only Barcam restaurant, hotel is omitted. I have already served the copy.
Achha, in some places of the order, we found restaurant come bar. In some other places, hotel is introduced. Hotel we often call restaurants as hotel in Bengali, so we are not sure.
Hotel bar come restaurant.
The license mentions hotel bar come restaurant.
Yes, Lordship.
Very well.
Already.
It to be mentioned in correction.
They don't have any objection.
Very well.
Lordship, obliged.
Call on the list. Yes, Mr. Chair. Oh, we have put it. Yes, section 5 you said was disposed of. It was never disposed of. That is the difficulty. But directions were given, appeal was admitted. So we'll just record one more line that deemed to have been allowed. By our order dated July 30, 2025, we had passed directions on the premise that the application for condonation of delay had been allowed previously. What is that? Can 1 not 3? Can 1. Full stop, next para. However, from the previous orders, we find that although the appeal was admitted on February 22, 2024, no order was passed at any point of time disposing CRAN 1 of 2024, which is the application for condonation of delay. Full stop, however, since, in view of the formal admission of the appeal, it is deemed that the said application was allowed, we hereby formally record an order to the effect that CRAN 1 of 2024 has been disposed of. Otherwise, this will remain as pending in the list, in the CIS. Yes, Mr. Chaudhary.
With pertains to that, the Alipurduar matter of.
Oh, yes, yes. You wanted a status report or?
Milord, we have given that, Milord. We have submitted the last day before yesterday, Milord.
Yes.
We have seen.
এটা একটু খুলে দিন তো। খামটা রাখুন একটু। Have you gone through this? আপনি দেখেছেন এটা? কি আপনাদের কি বক্তব্য?
আমি বলছি যে WPL
এটা তো এর বেশি আমাদের ডিসক্লোজ ওরা আপনাদেরও ডিসক্লোজ করবে না, তার কারণ হচ্ছে এটা তো ইনভেস্টিগেশন চলছে এখনো। এটা দেখে মনে হচ্ছে ইনভেস্টিগেশন কিন্তু ফুল সুইং চলছে, কেন ওরা আপ টু রোমান 9 যেটা দিয়েছে দেখুন, স্টেপস নিচ্ছে এবং রিজনও দিয়েছে ওরা যে সিজার অফ রিমেনিং বেল বন্ডসটা এখনো ফর সিগনেচার, সেটার জন্য স্পেসিমেন সিগনেচার কালেক্ট করবে। আমরা একটা এক্সপেকটেশন জ্ঞাপন করে এটা ইয়ে করে দিচ্ছি। এটা তো আপনাদের ইনভেস্টিগেশন হচ্ছিল না বলে সেই জন্য রিট পিটিশনটা ফাইল করেছেন। রিট পিটিশনটা কিসের বিরুদ্ধে ফাইল করেছেন? না সেটা তো দেখুন, আমরা সেটা আপনাদের এক্সোনারেট করতে, বাবাকে এক্সোনারেট করতে পারবো না এখান থেকে। সেটা ক্রিমিনাল ইনভেস্টিগেশন চলছে, সেটা চলবে। না না না, সেটা সেটা ফাইনাল রিলিফ ইনভেস্টিগেশনের পরেই সেটা হতে পারে, সেটা দিতে পারবো না,
My lord, your lordship,
সেটা দেওয়া যাবে না। আমরা বলবো যে ইনভেস্টিগেশনটা যাতে তাড়াতাড়ি শেষ হয়। এখানে ওরা নাম্বারও ডিসক্লোজ করেছেন, পিএস কেস নাম্বারগুলো, আপনারা সেটা ফলো আপ করতে পারেন। ক্রিমিনাল কোর্টে দরকার হলে আপনাদের রাইট আছে ডিফেক্ট কমপ্লেন্ট হিসেবে অ্যাকশন নেওয়ার, যদি পার্টিকুলার সেকশন কিছু না দেয় বা কিছু না ইয়ে করে।
that is
ম্যাজিস্ট্রেটের
the learned single judge's order, my lord, 17/10/2023.
ইয়েস।
They can approach to the relevant jurisdictional court for their grievance.
না এটা ক্রিমিনাল কোর্ট নয় তো, এটা জাস্ট রিট পিটিশন, শুধু দেখবে ওরা ইনভেস্টিগেশন চালু করছে কিনা। আপনাদের যেটা গ্রিভান্স সেটা রিট কোর্ট বলেছেন, ঠিক বলেছেন, জুরিসডিকশনাল কোর্টেই আপনাদের যেতে হবে। আমরা পেন্ডিং রেখেছিলাম ওরা অ্যাটল কিছু করছেন কিনা সেটা দেখার জন্য।
Exactly.
কি সিআইডির কাছে রয়েছে ইনভেস্টিগেশন, হ্যাঁ। কি জন্যে, কি জন্য?
But who are owner, I mean?
ওনারা মিন্স হু, কে, কারা কারা? কে আপনার বিরুদ্ধে মামলাটা কে করছে বাবার বিরুদ্ধে? কাউকে তো মামলা করতে হবে। সিভিল মামলা কেউ না করলে হয় না। কেন আপনাদের বিরুদ্ধে ওদের কি গ্রিভেন্স, আপনাদের সঙ্গে কি ওদের এনমিটি? হঠাৎ আপনাকে চুজ করবে, এটা আপনার একটা প্যারানোয়া হয়ে গেছে, এটা প্যারানোয়া। আপনি কোনো স্পেশাল নন, আপনার বাবা কিছু স্পেশাল নন যে আপনাদের বিরুদ্ধে অ্যাকশন নেবে। কোনো মোটিভ আছে সেটার করার? কোর্ট, পুলিশ, সিআইডি সবাই আপনাদের এগেনস্টে কেন? সেটা তো কয়েকজন লোক করেছে, সেটা কোর্ট বা পুলিশ কেন করতে যাবে? তাদের কি দায় পড়েছে? তাদের কাজ নেই খেয়ে দে?
মা, রিক্সা রাখতো দিদি।
না, সিআইডি ইনভেস্টিগেশন হচ্ছে, দিস ইজ সাফিসিয়েন্ট, সরি। সেটা আপনারা ক্রিমিনাল কোর্টে জুরিসডিকশনাল কোর্টেই নিতে হবে, সে পয়েন্ট রিট কোর্ট সেটা করতে হবে না। আর এই স্টেজে আর ক্যান ফাইন হবে। দ্য ম্যাটার ওয়াজ, একটার পর একটা কেস আপনারা করছেন, আপনারা করছেন। কে মেরে ফেলবে, কেন মেরে ফেলবে, এটা কি প্যারানয়্যা বলে? কে মারবে, কেন মারবে বলুন, একজনের নাম বলুন। কেন? আপনি কি স্পেশাল, আপনি কি পলিটিক্যাল এটা? আপনার বিরুদ্ধে স্টেট, এক সেকেন্ড, আপনার বিরুদ্ধে স্টেট কেন দাঁড়িয়েছে? আপনি কি স্পেশাল? এক লাইনে বলুন আপনি কেন স্পেশাল? কেন আপনার বিরুদ্ধে করবে, পার্টিকুলারলি আপনাদের চুজ করবে কেন? সারা অথরিটি সবাই আপনার বিরুদ্ধে কেন থাকবে, কি করেছেন আপনি? এই যে দুর্নীতির বিরুদ্ধে আওয়াজ ওঠানোটা না ফ্যাশনেবল করে ফেলবেন না, হ্যাঁ। একটা দুর্নীতি থাকতে হয় যার বিরুদ্ধে আওয়াজটা ওঠে। দুর্নীতি আমরা কোনো দেখতে পাচ্ছি না যে আপনাকে টার্গেট করার জন্য কোনো মোটিভ আছে। সব অথরিটি, আপনি বলছেন যে ল্যান্ড রেকর্ডসের যারা অথরিটি ল্যান্ড, তারাও আপনার বিরুদ্ধে, পুলিশ আপনার বিরুদ্ধে, সে একটা কারণ দেখান কেন? আলিপুরদুয়ার কোর্ট আপনার বিরুদ্ধে, একটা কারণ দেখান কেন? আপনারা কেন স্পেশাল, আপনাদের বিরুদ্ধে কেন? তাহলে মোটিভটা কি আপনাদের বিরুদ্ধে হওয়ার? আমরা শুনেছি আর না। We have heard the appellant appearing in person and through his daughter. Pushed up. আপনারা ইন পার্সন অ্যাপিয়ার করছেন মানে এই নয় যে আপনারা যা খুশি। আপনি হাতটা সরান, কারোর কাছে হাত জোর করবেন না জীবনে, হাতটা ঠিক করুন। এটা হাত জোর করার জায়গা না। আমরা কিছু, আমরাও, আপনি যেন স্পেশাল নন আমরাও স্পেশাল নই। কোর্টটা হাত জোর করার জায়গা না। আমাদের এটা চাকরি, কনস্টিটিউশনে আপনারা আমাদের পাওয়ার দিয়েছেন, এখানে ওই জন্য আমরা অ্যাডজুডিকেট করছি, আপনারা ওখানে আছেন। আপনি এখানে থাকতে পারছেন, আমি ওখানে থাকতে পারতাম। হাত জোর করছেন কেন? হাত জোর করে কি লাভ হয়? আমরা কি দেবতা? আমরা আমাদের কাছে যা মেটেরিয়াল আছে তার উপর অবজেক্টিভলি বিচার করি। যেরকম আপনি স্পেশাল নন, আমরাও স্পেশাল। কোনোদিন কোনো কোর্টের কাছে হাত জোর করবেন না, রিকোয়েস্ট আপনাকে কারোর কাছেই করবেন না। আচ্ছা, আমাদের শুনেছি তো আপনাদের, এবার অর্ডার দিই আমরা, আমাদের তো রাইট আছে অর্ডারটা তো, আর আমরা অর্ডার দিচ্ছি, আমরা স্যাটিসফাইড নই। আপনাদের কি ধারণা এতক্ষণে আমাদের দেখে এই ধারণা হচ্ছে আপনারা যদি বলে চলেন বা চিৎকার করে চলেন তাহলে আমাদের জাজমেন্ট চেঞ্জ হবে? আপনারা আজ আজ পর্যন্ত যা রিলিফ দিয়েছি আপনাদের, সেটা আমাদের মতে এই রিট পিটিশনের পক্ষে সাফিসিয়েন্ট। আর যদি কিছু রিলিফ হয় সেটা আপনাকে ক্রিমিনাল কোর্টে চাইতে হবে, এখানে নয়। The petitioner appearing in person with the leave of court along with his daughter submit that there has been a pogrom, POGROM, এই বানান, against them by all authorities. Full stop. It is submitted that the said fact is apparent from multiple cases being lodged against the appellant. Full stop. Next para. It is submitted that since the appellant's signature has been forged in several cases, comma, it is evident that there is a uh, clique, CLIQE, operating against the appellant. Full stop. Next para. However, comma, on repeated queries, comma, the appellant or his daughter are unable to convince us as to any particular motive why they are being targeted by all authorities, comma, including the courts, comma, the land revenue authorities, as well as the police. Full stop. Next para. From the report filed before us, which was circulated to the appellant, comma, it is evident that sufficient steps are being taken in respect of the investigation regarding the multiple allegations of forgery of the signature of the appellant before various authorities. Full stop.
The report submitted by the state.
We have not said that report has been submitted by the appellant. You have not followed us. Next para. We also find that this investigation has since been handed over to the CID by the direction of this court. Full stop. Next para. Subsequently, comma, one Inspector Sudeep Kumar Pradhan, comma, DDI, Darjeeling DD, comma, CID, West Bengal, has been designated as the investigating officer, full stop. In paragraph number 4 and its subclauses, comma, of the report, the various steps taken pursuant to such investigation have been clearly stated. Full stop. The reasons for pendency have also been identified. Full stop. Next para. By the order which has been impugned before this court, comma, the learned single judge merely granted liberty to the appellant to approach the appropriate jurisdictional authorities with their grievance, if any. Full stop. Next para. We are satisfied sufficiently that the CID has been handed over the investigation and is undertaking the same at present. Full stop. Any observation that we make, comma, sitting within the limited jurisdiction of an intra-court appeal, comma, might prejudice the investigation either way. Full stop. Next para. In any event, comma, it is always open to the appellant to approach the appropriate magistrate or the criminal court in the event there is any grievance regarding the proper conduct of the investigation. Full stop. Next para. Thus, comma, we do not find any illegality as such in the impugned order and or any further necessity to keep the appeal pending. Full stop. Next para. The substantive purpose of keeping the appeal pending before us was to know as to whether any steps are being taken in the investigation on the basis of the complaints lodged by the appellant, comma, regarding which we have expressed our satisfaction above till date. Full stop. However, comma, we make it clear that the CID shall make all efforts to conclude the investigation and file charge sheet as expeditiously as possible, comma, preferably within 1 month from date. Full stop. Next para. This observation, we make this observation since it is evident that the petitioner and his daughter and his family, comma, including his daughter, are suffering immeasurably and unnecessarily due to the pendency of the investigation. Full stop. Next para. With the above observations, comma, MAT 9 of 2024 is disposed of along with all connected pending applications.
Can it be 1 month then?
2 months.
Fine.
1 month is too short. 2 months. 2 months.
Then
Next. Hmm. 2 months. হ্যাঁ। Next. Yes.
Item number 4 ballot, I am representing state ballot along with this.
This is the SC/ST Act, that matter?
Yes, ballot. But I am holding the certified case diary ballot as super ballot, original case diary like with the trial is in Wales.
Yes, you said that, yes.
Told ballot. Today itself ballot date is fixed for PW 20.
There are total, number 46 witnesses.
Yes, ballot, but 46 is not required ballot, more 12 to 13 as per the version of the IO ballot, more 12 to 13 is
How
required.
soon can the investigation be closed? How soon can the investigation, the trial be closed? Approximately? Reasonable period? Let us hear him on the bill. Even then, we'll consider that, definitely we'll consider that. How many have been examined till date?
Till date 26 ballot. Today is also autopsy surgery is.
That you said on the, yesterday you said. We have recorded that also. This is 19. Not 26.
Two copies have not been, I cannot get this effect of it.
Yes, 19 are there. Mr. Chakraborty, are you sure there are 26?
Has been examined today with the
Ballot.
24th and 25th witnesses.
Yes.
We'll record your submission on that.
Yes, ballot. This is the order sheet ballot. I took kindly.
24, 29. Yes. Mr. Shokar, what is your case? Bill? How long are you in custody? Trial is on the verge of completion. 300 days. Wait for 3-4 months. Date of?
Date of the she.
What is the allegation exactly?
She left her house on 5th of October 2024. She did not return to the house. On 7th of October 2024, a dead body was recovered from a river.
She belongs to the castes.
My. So I.
Tribe or caste?
Right.
Tribe.
Thereafter, she identified 3 dead bodies. Called her parents and police came to the spot. They have taken the dead body. I have been accompanied with them. FIR was lodged on 7th of October.
Body was recovered from where?
From the river bank.
River bank. Achha. So she was washed out of the river. I mean, sure.
It's my, not a prosecution.
All right.
Thereafter, on 7th of 2024, at around 10:15 p.m., FIR was lodged. I was arrested on 7th of October 2024 at 11:50 hours. 11:15 p.m. from the police station itself. The allegation against the petitioner is that I had a relationship. The dead body was recovered surrounding of my house.
Is there anything to show she left with you? Achha, let us hear them because we have understood the situation. Yes.
I mean, it's W11.
Yes.
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 Ballot, if I committed the offense,
We will hear you on the incriminating evidence.
if I committed the offense, there should be some
What is there in the evidence?
no injury upon my body, nothing simply stated that I am Keshav.
He went missing when? 5th? 5th of
5th of
24.
6:30. She left for her friend.
PM. PM.
PM.
Acha, you were arrested on 7th. She was found on 7th, you were arrested on 7th.
They got, I was arrested after an hour.
Very well. Yes. But you went with them.
Yes, I was there.
You were arrested and went with them, or you were there means what were you doing there? You were there means how did you go there? Why did you? Both of you reside in the same locality. So you were also there with the villagers. That does not exonerate you. Rather, it's the other way around.
I involved.
But even if you were not involved, you would go there, definitely. Because you had a relationship.
Total videographs was there, my
So
lord.
how is this PW11 relevant? Why?
If such offense become, there should be an injury. Because the way.
Murder.
Rape and murder, my lord.
Rape and murder.
Rape and murder.
There should be injury.
Now, where I'm occupied.
At this stage, it's too early to say. And the SCST Act is there, it's very severe.
That's it. But the
Yes.
simple fact is that the all records have been found that I could talk people for a long time. The investigating agency in the
Mr. Sarkar, let us hear them what is the incriminating evidence instead of hearing you on and on. Because they will say what is the incriminating evidence, not you. If you know the incriminating evidence, then you are a complicit in it. Let us hear them. What is the incriminating evidence? We'll hear your answer to that. Because that is what is to be considered here. Yes.
Last seen together is there. 161 statement, my lord. Hereafter, my lord.
Last seen together is there.
Yes, my lord.
She left with him or seen somewhere else?
Let me see.
Acha.
And my lord, PW9, the neighbor, he
Huh.
is the last seen together. He saw.
All right, all right.
And thereafter, my lord, after 48 hours,
Huh.
dead body has recovered on
Yes.
the river bank, my lord.
Yes.
And in the wet condition. So, my lord, the other injury is not there. So, and my lord, after arrest, my lord, reconstruction of the total crime scene has taken by the prosecution, my lord. And videographs also taken, my lord. And the in the presence of the local villagers. my lord.
Videographs regarding what?
Reconstruction of the
Acha.
crime, my lord. And my lord,
Still, it's circumstantial, Mr. Chakraborty, till now. Last seen together, yes, we can understand. Does not mean he murdered her.
but yes, my lord, the
Circumstantial
wearing
to the
chappal-
power infinity, this is.
Chappal also reading statement of the accused person.
He left with him.
Uh,
Left with him. Does not mean necessarily that he murdered at this stage and investigation is over. Charge sheet is there. 23 witnesses have been examined. What will he do?
the local people saw the present petitioner along with the victim walking on the
Going to the river.
river. Yes, yes.
Where is that
They-
evidence? Must be in the witnesses. Show us that.
Tunasa. 23. Evidence.
They worked together.
Yes, yes, ma'am.
They worked together, he and the
No.
lady.
No, no. Actually, the present prisoner has criminal antecedent also, my lord.
What sort of?
Murder, 302.
He's
Of his wife.
By giving poison.
By giving poison.
that trial is going on. Or charge sheet has been filed in that.
case, my lord.
In that case, no charge sheet has been filed. Yes.
No, no.
Acha, this PW10 says Ombika is the lady. Ombika is no more. I heard that Ombika was raped and murdered by Rabiul. I saw Rabiul and Ombika talking with each other. I asked them not to waste time during work means. He was assigned for construction of drain. Rabiul is a Rajmistri. He engaged several workers. I know Ombika Ora worked in the construction of drain under Rabiul. So they worked together. Prosecution doesn't know his case. They worked in the same construction, PW10, chief.
Contractor.
Huh. They worked under the same contractor, and rather Ombika worked under this person, the accused. একসঙ্গে দেখাটাও তো খুশির
On
হচ্ছে।
that period, they know each other, but
They know each other, there was a relationship between them, understood.
before,
They worked as construction workers in this under the same person. He adduced evidence saying that. And then how do you lend so much weight on them being seen together?
But think of this leading statement, the sleepers of the deceased girl was recovered.
Le-
That was
on
subsequently
the
identified by the mother.
Leading
mother.
statement was accompanied by something. There is evidence of the investigating officer says exactly what he said. Was it taken in writing, Justice Gawai's judgment? In the other matter, it was cited. So we are now educated on that.
Reconstruction is there, my lord. Total
Reconstruction is, I mean,
with the local people.
reconstruction is not, we do, I mean, because it is very important in a trial.
There are political reports,
Yes, that is
Yes,
what we are wanting.
Yes, yes.
they have not, which shows that he was present at the relevant time, there were sufficient calls between both
Both of them.
during the last hours, after which she went missing. So, this is one of the links or one of the incriminating evidence.
It has been exhibited that
Yes,
Call
yes,
records?
my lord.
yes, what do you have to say? These are your, yes,
My lord, my lord.
answer these. Relationship, we are not bothered. Therefore, might have even left together. Call records, how do you deal with the call records? And you are seen going with her towards the,
I had a talk with the victim 1 week prior to the incident. 1 week prior to the incident.
that is immaterial. Call records are material.
Just before the incident.
I have a relation.
Relationship just immediately before the incident, the call records are there.
It's not the stated, charge, it has been stated.
No, that call records, which is the exhibit number?
Him.
What is the exhibit number of that call, those call records? We want to see how those are proved.
But that will be
That
already
already-
in the trial court by the investigating officer.
Will be.
Yes. So we have that in our case diary.
Case diary,
We have it.
but originally it's like.
Oh, the call records are there in the case diary.
Yes, my lord, yes. Brutal case.
Kindly appreciate.
Each and everything, chain of circumstances is well proved,
No,
my lord.
one other question. What will you do? Because the investigation is over.
My lord.
Now, we are not considering whether he is guilty of murder of his wife right now because he has not been indicted there. What we are concerned with, we'll take it into consideration in bail, definitely. But we don't consider it to be much of a criminal antecedent at this stage.
My lord.
Antecedent means he had to be
My
a
lord.
known criminal in a
My lord, my lord.
Now, regarding this investigation complete, charge sheet filed long back, 23 witnesses have given evidence. If you put him to condition, he will go to the trial every day.
Kindly, my lord, kindly, my lord. 3 months, my lord, trial will cost, my lord. Any time, my lord. In this.
What do you
case, my lord-
apprehend exactly? What will he do?
my lord-
How will he tamper evidence? Everything is with you.
But actually, my lord.
There is no additional charge sheet
But-
because 23 witnesses are over.
My lord, frankly speaking, my lord, this is the other problem in the locality, my lord, happened, my lord.
Let him suffer
Three-
from the locality.
Kindly 3 months, my lord, we conclude the
See,
trial.
Mr. Chakraborty,
In
we
this situation-
bail, the only condition is
But-
whether there is sufficient reason to put a person in custody. He's still an under trial. He has not been convicted, right? So that is the only consideration of bail. Not being us liberal or conservative or nothing like that. We are not liberal or conservative. It depends on the case. But here,
My lord.
evidence is going on. A murder has been committed. This is not a case that the victim is alive. He might do something to her again. Not that. So, criminal antecedent, that allegation.
Well-
Now, all these things, and one other question, was that complaint regarding his wife's death prior to this?
Yes.
Long prior to
Yes,
this?
my lord. 161 statement. Maybe there is no case, my lord, but 161, much more, 161 of the local people is there.
But
my lord.
what is the difficulty if he attends trial every day and
My lord,
not leave the
kindly, my lord,
territorial
kindly, my lord,
jurisdiction?
3 months, I will
He's a
take
local
you to the
resident.
trial, my lord.
He's a local resident.
My lord, kindly, my lord.
We'll say give that 3 months to you, but let him be on bail. What is the difficulty? He's an under trial still.
Day-to-day basis.
What do you exactly apprehend? What will he do? If we'll give him independence, what will he
The
do?
mother of the victim, my lord, who has succumbed to injuries, but she is still alive. But
My lord,
she has given evidence, my lord, but they are
Tampering,
not only tampering, there will be threat to her life as well. My lord, kindly 3 months,
My-
if we get, my lord, we'll conclude the trial.
definitely, my lord. Kindly, my lord.
yes, anything else to add?
My bike died on 22nd of August 2024. There is no FIR has been registered against. I do not have any answer. Thank you, sir. Well, there is a direction of the Supreme Court. If the prosecution states that there is an antecedent, they have to produce the document, not on the order. They have to produce the document. They are not.
No, they say that no FIR has been filed. If they had the FIR, they would produce it.
If your lordship can see the investigation,
Yes.
charge sheet, it has been written in a communal state.
Brother-in-law of the present petitioner, my lord, first wife, his 164 statement is there, my lord. Document is there. Maybe there is no case.
His
but
brother-in-law,
164 is
what does he know about the offense?
brother-in-law,
Obviously, brother-in-law, there will be enmity because of the caste angle of the matter.
first wife,
Oh, first,
first wife.
brother-in-law.
Yeah, present petitioner's brother-in-law, first wife's brother.
We won't go into that even. We want to vitiate, don't want to vitiate that trial. Let us not go into that.
There are.
কি করবেন?
Not kind.
You are rejecting.
And that's the one.
We have considered. Learned counsel for the petitioner contends that the trial is well underway. Full stop. Already 23 witnesses have been examined. Full stop. Next para. The petitioner is in custody for Section 5 is there.
Section 5, yeah.
What is the delay?
153 days.
What is the reason?
Well, it's
Very criminal matter. What is the CRAN?
paragraph number 4.
CRAN 1 of 2020, in view of sufficient reason for the delay having been explained upon hearing learned counsel for the parties, CRAN 1 of 2025 is allowed, thereby condoning the delay in preferring the appeal. Full stop. Next para. The petitioner stroke appellant submits that the petitioner is already in custody for 300 days and the trial is well underway, comma, since 23 witnesses have already been examined. Full stop. However, comma, the total number of prosecution witnesses sought to be cited is 46 and it will take much time to conclude the trial. Full stop. As such, comma, it is submitted that the petitioner ought not to be incarcerated further. Full stop. That apart, comma, it is submitted by the petitioner that there is no clinching evidence as to the involvement of the petitioner in the alleged crime. Full stop. The petitioner admittedly had a relation with the victim girl. Full stop. However, comma, there is nothing on record to indicate even remote involvement of the petitioner at the time of the offense. Full stop. Next para. Learned counsel, the learned APP appearing for the state contends that the prosecution shall not require all the 46 witnesses, but about 12-13 more witnesses would suffice. Full stop. That apart, comma, the prosecution expresses full confidence that the trial will be over by around 3 months. Full stop. Next para. It is further alleged that there are criminal antecedents of the petitioner inasmuch as there was a complaint lodged regarding the murder of the wife of the petitioner. Full stop. And a statement under section 164 of the criminal procedure code, comma, it is submitted by the brother-in-law of the wife of the petitioner, has been taken in the said in connection with the said investigation. Full stop. Next para. Learned APP further submits that in view of the nature of the offense and the fact that the mother of the victim girl might be jeopardized, comma, as regards her safety, comma, in the event the petitioner is enlarged on bail, comma, the prayer for bail ought to be refused. Full stop. It is further contended that a video reconstruction of the event has already been made. Full stop. Next para. Upon careful consideration of the rival contentions of the parties, comma, we are of the opinion that the fact that a complaint has been lodged against the petitioner in with regard to the alleged murder of his wife comma, which has not yet culminated even in an FIR, comma, let alone a charge sheet, comma, cannot be considered to be a criminal antecedent at all. Full stop. Focusing on the present case, comma, we cannot lose sight of the fact that although the investigation is underway and the charge sheet was filed long back, although the trial is underway and the investigation was concluded and charge sheet filed long back, comma, still there is some there may be some apprehension of the petitioner intimidating or inducing the witnesses to the case, comma, particularly the mother of the victim during pendency of the trial, comma, at this stage. Full stop. That apart, comma, since the prosecution records its assurance that the trial will be over by 3 months, comma, we record such submission and express full hope and trust that the trial will be over by the outer limit of 3 months from date. Full stop. Even today is fixed. Today is fixed for that witness. Today is fixed for the autopsy surgeon's witness evidence. Full stop. Next para. That apart, comma, keeping in view the gravity of the offense itself and the fact that the trial is on the verge of conclusion, comma, we do not we are not inclined to grant bail to the petitioner at this stage. Full stop. Accordingly, you have filed an appeal as well as a connected application, or the file on appeal itself is the appeal. Accordingly, CRA within bracket DB hyphen B bracket closed 2 of 2025 is dismissed with the observation that it is expected that the trial will be over within trial shall be concluded as expeditiously as possible, comma, positively within October 31, 2025. Full stop. Next para. It is further clarified that the learned trial judge shall not grant any unnecessary adjournment to either of the parties during the trial. Thank you. প্রথমে affidavit of service filed to be kept on record. Next. Thank you. Thank you. একটা সার্টিফাইড কপি দিই। Yes, yes, absolute. ওটা ফেরত দিন, দেখিয়ে দিন ওনাকে কোনটা।
Number 5.
Yes.
I'm very good.
Yes. Yes.
I'm not doing this till the accident is convicted, for 10 years, and not 10,000, also pay the fine of 10,000.
In default? 1.
3 months.
How long have you spent? That is inconsequential.
For 24th of 24th of March 2025.
So what is the mitigating circumstance? Cited. 21 has not been examined. Yes. Yes.
Hostile by the prosecution.
Acha.
First of all, they did not support the prosecution case. All the, they are the neighbor of the
Understood. Next point.
The conviction was based on some time declaration of the mother. Time declaration of the deceased.
That is a very important piece of evidence.
Memo at page 48. PW 19, Dr. Sobi Banerjee, with the recordings, who is the doctor who recorded the time declaration.
PW 10.
PW 19 is the judgment.
Oh, judgment itself.
Judgment in a page 9.
Here it is PW 10.
That page 9. W 9.
Page 19 of the judgment. We also made the same mistake. Yes. PW 19.
Was not mentioned that the time declaration was read over and explained to the deceased.
Hmm.
And the witness admitted that the time declaration was not recorded in verbatim manner and that there was no signature of any attending nurse or staff on such documents. The witness further stated that he did not put any common question to victim to ascertain her mental capabilities to render the time declaration. Entire time declaration is very wrong.
Let us hear them. Yes.
Lordship, the case was initially started under section 498A.
Yes.
W four. W four, inner page 11.
Yes. We are there.
The last three lines.
Hmm.
He also stated that the victim was depressed due to the birth of a stillborn child. The actual fact was that is the actual reason for committing suicide.
And did not make any complaint against the accused persons.
Because there is a one allegation, there is a after marriage, there is a mental torture.
498 angle is.
None of the relative.
Yes.
Lordship, the case was initially started under section 498A and 306 of the Indian Penal Code.
Right.
Subsequently, the charge sheet was submitted under section 498A and 304B because the death of the victim occurred within the 7 years of the marriage, and the Lordship knows far better than me that in a case of 304B, the presumption of guilt is there during the time of trial. And at this stage, when the accused petitioner is who has been convicted is presenting the bail application, there is no presumption of innocence at this stage because he has already been
Conviction.
convicted.
Yes.
Now, Lordship, in the memo of appeal, PW1 Maya Shaha is the eyewitness who clearly stated that.
He was declared hostile by the prosecutor.
No, let me explain.
We will declare you hostile if you continue doing this. Yes. He is very
She stated
confident.
that
He is very
I-
confident. Must be hostile.
As she stated, I heard a commotion about 10:30, 11 a.m. and she went to saw that the victim was set on fire and the local persons gathered and took to the hospital. Now, Lordship, the death of the victim occurred. The death of the victim occurred within the house of the petitioner. So the onus of the also lies on the petitioner to show to reverse the burden burden because
PW4.
both the death occurred.
Page 11, PW4.
PW4. Yes.
Dying declaration is vitiated.
Now, Lordship, regarding dying declaration, the victim was in a burned condition. The question of taking the thumb impression may not be possible. May not be possible.
Not read over and explained. Not read over and explained. Physically, mentally fit. No mention.
This is the lacuna.
The dying declaration is
A dying
high
declaration
value.
is an important piece of evidence, and
Very important.
the person who is giving the dying declaration, it is probable that she should not meet the maker with a lie in his or her mouth. But these are the cautions which have been
Let us
stated in
grant
the
bail. He was enjoying bail, but yes, post conviction, it's a different consideration. We'll consider that.
conviction is a different.
We'll just consider whether he has a fair chance of acquittal. That is one of them. Learned counsel for the petitioner submits that the petitioner was enlarged on bail throughout the trial and was arrested only after conviction. It is contended that the prosecution case was vitiated with several lacunae. First, the doctor who took the purported dying declaration, that is PW 19, Dr. Souvik Banerjee, in his evidence, as recorded in the judgment of the trial court, admitted during cross-examination that there was no mention as to whether the victim was physically and mentally fit at the time of giving the statement, nor was any signature or thumb impression of the victim taken on the dying declaration, or any statement was made that it was read over and explained to the deceased. Full stop. Thus, comma, it is submitted that the very best piece of evidence which has sought to be relied on by the prosecution is squarely vitiated. Who is the next para? By relying on the trial court's findings as to the evidence of PW4, comma, learned counsel submits that it is an admit he had that such that the said witness, comma, who is a distant relative of the deceased, admitted that the victim was depressed due to the birth of a stillborn child, and that he did not make any complaint against the accused persons. Full the petitioner has been convicted of sections 498 capital A and 304B of the IPC. Full stop. In view of the statement made that there was no previous complaint and the victim was depressed due to the birth of a stillborn child, comma, it is argued that the suicide angle cannot be ruled out altogether. Full stop. Moreover, comma, the absence of previous complaints also vitiates the case under section 498 capital A of the IPC. Full stop. Next para, learned counsel for the state submits that in view of the victim being in a severely burnt condition when the dying declaration was taken, comma, it might not have been possible to take thumb impression or signature at such time. Full stop. Next para, however, comma, we are of the opinion that such that the very weight lent to a dying declaration as evidence also uh, compels the court, constrains the court to uh, ensure that the parameters which uh, put checks and bounds to misuse of such so-called dying declaration are put in place. So in the present case, comma, the dying declaration, it is doubtful as to whether the dying declaration could be a valid piece of evidence, comma, in the absence of any signature or thumb impression and or any reading over and explaining done to the declarant as to the contents of the dying declaration. Full stop. Moreover, comma, there is nothing in the dying declaration by the doctor to show that the victim was in a physically and mentally fit condition to give such dying declaration at all. Full stop. Even otherwise, comma, some doubt is cast regarding the reason of the offense, reason of the death, comma, since PW4, comma, distant relative of the deceased herself states in his evidence that she was already depressed due to the birth of a stillborn child and that there was no previous complaint against the accused persons. Full stop. Keeping in view the same, comma, we are of the opinion that sufficient circumstantial doubt has been created as to the conviction, comma, which entitles the petitioner to the benefit of doubt, comma, since there is fair chance of acquittal in the after the hearing of the appeal. Full stop. Accordingly, and we also take into consideration the fact that there is no allegation that the petitioner jumped bail when he was enlarged on bail during the entire period of trial. Full stop. Next para. Accordingly, CRAN 2. This is what is this?
There was a limitation.
Limitation was CRAN 1 and this is CRAN 2.
Limitation we have allowed.
At first the limitation.
This is becoming a farce. Accordingly, CRAN 2 of 2025 is allowed, thereby granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 10,000 with two sureties, like amount each, to the satisfaction of which magistrate? ACJM Siliguri. Full stop. The petitioner shall not in any manner intimidate, induce, or approach the witnesses and or tamper with evidence in any manner during the period of trial and or leave the territorial jurisdiction of his residential jurisdiction.
Trial is completed.
Oh, sorry. During the pendency of the appeal. Thank you. During the pendency of the appeal and shall not leave the territorial jurisdiction of his residential police station during the entire period of appeal. Full stop. The petitioner shall present himself as and when so required by this court to do. Full stop. আচ্ছা এই পুরো ব্যাপারটার আগে একটা করে দাও in view upon hearing learned counsel for the parties, comma, since sufficient explanation for the delay has been made out, CRAN 1 of 2025 is allowed, thereby condoning the delay in preparing the appeal. The appeal was admitted already, paperwork have been directed. The appeal also ক্র্যান ওয়ানটা যেখানে অ্যালাউ করলাম
Five has been.
সেটা সেটা ক্যান ওয়ান যেখানে অ্যালাউ হলো আর ক্যান টু যেখানে শুরু হলো তার মাঝখানে ঢোকাও দি অ্যাপিল ইজ অ্যাডমিটেড অ্যান্ড শ্যাল বি হার্ড অন দি অ্যান্ড শ্যাল বি হার্ড ফুল স্টপ ইস্যু ইউজুয়াল নোটিসেস the records be called for paperwork shall be prepared within 4 weeks from the arrival of the records তারপরে ক্যান টু এর পুরোটা Any section 5? No section 5. All right. Very well, yes. The appeal, there is no connected application. This is not against acquittal. Well, the appeal is admitted, issue usual notices, call for the records. Paperwork shall be prepared within 4 weeks from the date of arrival of the records. Liberty granted to the appellant to make an application for suspension of sentence stroke bail during pendency of the appeal.
Removal of suspension of application.
Lord, item number 7, I am for the state. My lord, there was a direction upon the state to
Yes,
serve the
sorry,
victim.
Sorry?
To serve the de facto complainant. Lord, we have served the de facto complainant, she is present. But my lord, she has no means to engage an advocate, so she has to refer to the legal services committee. Let
very
it be
good.
taken up tomorrow, my lord.
Dr. Chaudhary, please ensure that someone is.
Yes, yes.
One question, Mr. Chaudhary, unconnected. In that matter in which we have heard the death reference, which we said will pass judgment this side, were you doing it pro bono or appointed by the legal aid
My lord,
service?
I was appointed by the legal services authority. Subsequently, my lord, one junior counsel filed wakalatnama.
Acha.
So, my lord, even she needed a senior in the matter. So, my lord, ultimately, I am doing it pro bono. I will not, my lord.
No, we just wanted to
Yes.
know. Very. Learned counsel for the state submits at the outset that although the victim has been served by the although the de facto complainant has been served a notice,
My lord,
victim.
my victim, my lord, she is 3 years old. Her mother is present as the de facto.
Acha,
Mr. Ganguly is from the panel of the legal services committee. He is present.
Mr. Saurabh Ganguly?
Yes.
We will appoint him right now.
Yes. That
Well, we'll take it up tomorrow. Well, acha, Gora theke bol. At the outset, learned counsel for the state submits that service has been effected on the victim through her mother, since the victim is a 3-year-old child. Full stop. However, the victim and her family are not in a position to engage counsel due to meager financial means. Full stop. Accordingly, Mr. Saurabh Ganguly, who is present in court today, is requested to appear on behalf of the de facto complainant stroke victim. Full stop. The appointment of Mr. Ganguly shall be regularized by the High Court Legal Services authorities at the earliest. Full stop. The matter be placed in the list tomorrow under the same heading.
Great.
The receipt filed today with regard to service be kept on record. Come back tomorrow, Mr. Yes. Sorry, Legal Services, High Court Legal Services Committee, Authority. Thank you. Yes. Next.
My lord, I appear on behalf of the petitioner, appellant.
Number 8, yes. Yes.
My lord, allegation under section 376 AB 506 IPC read with section 6 of the POCSO Act, my lord.
You
My
have
lord,
left nothing, no stone unturned.
my lord, this is a totally false case, my lord. My lord, the petitioner is a biological father, my lord. My lord, in the statement of the doctor, no mark of injury in the vagina and vulva.
What was the age of the child?
My lord, 6 years. My lord, since 2015, my lord, there was a matrimonial dispute between the mother and father of the child, my lord. My lord, I am submitting the divorce petition, my lord. My lord, my appellant want to live with his wife, my lord. That's why he stayed with his wife in her house, my lord. My lord, getting no other alternative, she has lodged a false case against his husband, my lord. My lord, in the statement of the child, my lord, she has stated one incident happened with me. I cannot say how many years ago it has happened, my lord. My lord,
What
father,
incident? What incident?
what incident she said অসভ্য কাজ করেছে আমার সাথে, like this, my lord. My
No,
lord, and
the girl said, the victim said.
victim girl said. My lord, and he is in custody for more than 3 years, 7 months, my lord. My
No,
lord,
one thing, Ms. Dotto, you were residing with your wife with the child.
my lord, in her house, my lord. I am residing since 2015.
Her house does
my
not
lord.
make a difference. Yes.
My
Let
lord,
us
since
let
2015, my lord, I am handing over the divorce petition, my lord. My lord, kindly see, the wife has itself stated in the petition that since 2015 there was a dispute, matrimonial dispute between the husband and wife, my lord, and there was several amicable settlement taken place between them, paragraph number 5, my lord, but all in vain.
no. In the matrimonial suit, she also alleges POCSO. This is that case.
My lord, she has lost this petition, my lord. My lord, my lord, I am sorry to say, but the mother has some extramarital affairs with as another person. For that, getting no other alternative, she has lodged a false
Have you
case
filed a
against
written
her.
statement to this? Have you filed a written statement to this?
No, my lord, my client is at custody, my lord. How can I file, my lord? My
From
lord, he
custody,
is
written
at
statement cannot
custody.
be filed. From
My
custody,
lord,
no petition can be filed. Written statement.
he cannot appoint any
All
lawyer
right.
from the custody, my lord.
Understood. Yes, what do you say?
Just 5 minutes ago, I was appointed by the Legal Service Authority on behalf of the de facto complaint. I do not have even the copy of this application, my lord.
No, let us hear the state. What if we are
No,
not very convinced of rejection, then we'll.
she was appointed 5 minutes ago. I have been appointed 2 minutes ago. Lordship, this is the notice. Notice.
Oh, no, need not. Please, you are saying from the bar. We disbelieve you. Please come back tomorrow, Ms. Dotto. We'll keep it on the list tomorrow. Leonard,
Grateful.
copy, please. Just. Ms. Shorkar, learned counsel, having instruction to appear for the de facto complaint, submits that she has been engaged a few minutes back. Full stop. Similar is the predicament of Mr. Ganguly, learned counsel, and having instruction to appear for the state. Full stop. The state is directed to serve a copy of the application on the learned advocate for the de facto complainant. Full stop. To enable learned counsel for the de facto complainant and the state to come prepared, let the matter stand adjourned till tomorrow. Thank you.
Grateful.
Please keep it with you. File it on the next date when you take up tomorrow.
Grateful.
Thank you, Ms. Dutt. Yes.
First, I put this is my second application.
Allegation?
Allegation under section 302, my lord.
Achha.
Allegation under section 302, my lord.
We hope you don't claim minority, being a minor. No, your name. Your client's name. Yes. Take the mic up, even if you don't have a case.
Shishu.
Mr. Podar, take the mic a bit up, actually. Yes.
Well,
You're growing tall every day. Still growing. Yes, what is the mitigating circumstance? Don't have to hang your head in shame.
I'll say, my lord, 2 minutes, my lord. This is the, my lord, kindly see the written complaint.
Yes.
The written complaint. This is the written complaint, my lord.
What are the evidences of the clinical psychologist, the PW 8 and
PW 7 and 8 says that he is mentally fit. My humble submission, PW 1 is the son of the
deceased and also son of the accused, my lord. My lord, he lost this complaint, my lord. I handed over the first information report, my lord. This is the written complaint, my lord. Kindly see the PW1 deposition.
What is the age of PW1? Approximately 22 years.
My lord, 23 years, my lord. My lord, PW
copy?
Yes.
So we don't have the copies.
judgment.
Oh, what portion are you trying?
My lord, cross-examination part, my lord, cross-examination, my lord, says that, my lord, he did not see, my lord, cross-examination, my lord. My lord, I had not mentioned in my written complaint, my lord, my father is suffering from police visited. I had not, my lord, seen my father killing my mother, my lord.
There was none else. You were hitting her with an instrument.
My lord, there is no eyewitness, my lord. My humble
Need not
submission.
be.
My lord.
He saw you beating
Yes.
your wife with a bottom, whatever that's called in English.
Saw that I was.
And she died immediately
My
after.
lord, she was in a full blood condition in the house and suffering injury with a bottom. And there is a mental illness in the affair, my lord. If your lordship kindly see the, my lord.
These grounds were taken care of by the previous bench.
Last point.
Both grounds were
Yes,
dealt with by the previous.
My lord, kindly see
What, my
the
lord?
judgment. I have annexed the judgment, my lord. Internal page of the page 16, my lord. Kindly see, my lord. 16, page 16, judgment. Internal page, my lord. Page 16, my lord. This is my lord. PW10 is the investigating officer. His cross-examination, my lord. This is a relevant portion I am showing, my lord. My lord.
Internal page 16, you see.
Internal page 16, my lord. This is the portion, my lord. This portion by my lord. Recording of the, my lord, PW10 is the, my lord, investigating officer, my lord. I am showing.
No. Internal page 16 of the judgment.
Yes, my lord. Or learned judge observed, my lord.
Yes.
Observation, my lord. My lord.
Submission of the parties at the end.
Yes, my lord. Yes, my lord. Yes, my lord. My lord.
PW10, where do you find PW10?
My lord.
Exhibit 10 is mentioned there.
My lord. It will be, my lord, from page 13. Page 13 from PW10 is starting, my lord.
Yes.
Last part. PW10, page 13.
Yes.
Page 16 is the, my lord, last portion. My relevant portion, my lord. My lord, there, my lord, he did not collect the finger impression of the seized student bottom. There is no signature of his own or signature of the accused on the seized student bottom at the present. However, a wrapper of the said bottom was containing the case reference under his handwriting, my lord. This bottom was seized, my lord. There is no finger impression was obtained, my lord. Without finger impression, my lord, obtaining the matching the finger impression, whether this bottom was used by the accused, my lord. There is none seen this incident, only saying that he was holding a bottom, my lord. This bottom was.
He was hitting with
No
bottom.
hitting, my lord. Only saying, my lord, kindly see the PW1. I given the, my lord, deposition, my lord, flap, my lord, PW1, my lord, and the PW1, my lord, first flap, yes, my lord. Only seen the, my lord.
You were moving around in anger with a blood-stained bottom
Yes,
in your hand.
my lord, my lord,
Lordship, page 6.
saying that, but
Page 6 of the
this bottom was
judgment.
no finger impression, my lord, nothing, my lord.
Of the judgment.
But if you are not stated, I am moving in the blood stain, my lord. And saying that I am suffering from mental illness, but this bottom of there
Page
is
6.
Page 6, internal page 6 of the judgment, Lordship.
Yes.
Only document I have, PW1, Manoj Rai, that is the son of the appellant.
Yes.
Kindly read the 5-6 lines from top.
Yes, we have read that only.
So-
He
so-
found his mother lying dead and he was.
Now the burden shifts upon him. That how is the wife died?
Is the investigation.
Because it's his house.
Malak, see the offending of your Malak. There is no one seen the witness. Offending witness, offending Malak, offending substance must be proved, Malak. There is no finger impression. There is no signature of the accused. No signature of the investigator.
How long are you in custody?
Malak, custody since 2018 September, near about 7 years, Malak.
7 years. 7 years is the only consideration we can have.
Life
Life.
imprisonment, Malak.
Upon the statement of the boy itself.
There is a mitigating circumstance, Malak. This
After
offending
waking up,
person
he
has
saw
to be
his
proved.
mother.
But this is the post-conviction appeal, post-conviction bail application.
Well, there is no signature of the accused.
Mr. Shahpudar shows that there is fair chance of acquittal. We are not convinced of that.
So, only he also cross-examined stated, I have not seen my father killing the mother.
He was sleeping then. When he
Malak.
woke up, he saw his mother.
Only
Read out what he saw. Read out the first sentence. Read out. Let the public decide. The public is educated public in this courtroom. So let them decide.
On the incident on the date I worked at 7 a.m. found my mother lying dead on her bed, injured condition with cold blood. My father is moving around in anger with a blood-stained bottom in his hand, my lord.
That's
Well,
enough.
this saying, my lord, blood-stained
Shut. Seven.
this bottom was not seen, my lord.
And seen by the son of the appellant lordship.
My lord, this bottom.
Only the only consideration. 7 years is the only consideration we're granting. Only consideration. We'll do away with this bottom part so that you are satisfied. Learned counsel for the petitioner submits that there are exonerating circumstances which creates a fair chance of acquittal in the appeal. Push up. It is submitted that the short wooden log within bracket bottom BATTAM bracket closed, comma, which was marked as exhibit 1 was admittedly not examined for collecting any fingerprint of the petitioner. Full stop. Next para, that apart, comma, it is submitted that there is only circumstantial evidence inasmuch as PW1, comma, the son of the victim and the petitioner, comma, did not see the petitioner kill the victim. Full stop. It is contended that the petitioner was also mentally challenged at the relevant point of time. Full stop. Next para, however, comma, learned counsel for the prosecution vehemently opposes the bail, prayer for bail, and submits that the examination of PW1 is clinching. Full stop. It is contended that since it was established in the evidence of PW1 that when he woke up, he found his mother, the victim, lying dead on her bed in injured condition with a pool of blood, and his father, comma, the present petitioner, moving around in anger with a blood-stained bottom in his hand, comma, the onus shifts on the appellant stroke petitioner to establish the circumstances in which such state of affairs came into being. Full stop. Without such explanation, comma, it is submitted that the conviction was rightly handed out. Full stop. Next para, it is submitted that the technical objection as to no signature of the appellant stroke petitioner being taken from the offending weapon does not vitiate the chain of events otherwise. Full stop. Next para, upon hearing learned counsel for the parties and perusing the earlier order of rejection of bail during pendency of the appeal dated January 21, 2025, comma, we find that the mental assessment of the petitioner was done by the medical officer bracket PW7 as well as clinical psychologist bracket PW8 bracket closed, comma, as such ruling out the possibility of the petitioner being in a mentally ill condition at the time of the offense. Full stop. Also, comma, the circumstantial evidence does not afford much scope of creating any doubt as regards the conviction otherwise. Full stop. However, comma, the only consideration which we are taking into account is that the petitioner is already in custody for about 7 years. Full stop. Although a lifer, LIFER, comma, since a considerable period of custody has been spent, comma, which is about half the period from which the petitioner would be entitled to remission, comma, we are of the opinion that no useful purpose would be subserved in keeping the petitioner further in incarceration during the pendency of the appeal. Full stop. Accordingly, CRAN 3 of 2025 is allowed, comma, thereby granting bail to the petitioner on condition that the petitioner furnishes bond of rupees 10,000 with 2 sureties of like amount each, one of whom must be local, to the satisfaction of learned of the ACJM Nekliganj. Full stop. The petitioner shall not leave the territorial jurisdiction of the local police station during the pendency of the appeal and shall not attempt to induce or intimidate any of the witnesses and or tamper with evidence in any manner. Full stop. The petitioner shall make himself available as and when required for the appeal by the appellate court, by this court. Full stop. Next, appeal was formally admitted, no?
Yes, madam, admitted.
Paperwork directions given, no?
Such a one indulgence. He may not enter his house because the boy is there, the prime witness. His
Where will he live? Yes, right, is the boy is there.
boy is there.
But we have
Upon his evidence, he has been convicted. So we don't know another.
understood, but then we have asked him not to leave the territorial jurisdiction.
He may reside elsewhere or within the territory, but not
Understood.
enter the.
Yes, Mr. Sapota, that would be a, thank you. আরেকটা লাইন অ্যাড করে দিন যে as a further condition of the bail, comma, the petitioner shall not enter into or go near about the vicinity of his home, comma, although not leaving the territorial jurisdiction of the local police station, comma, during the pendency of the appeal. And we specifically clarify that the petitioner shall not, comma, in any manner attempt to contact or approach his son, comma, who was the PW1, comma, in any manner during this period.
Grateful, deeply.
We could direct him to reside in your house also for during the pendency of that. You just create a construct a room where these people will be staying.
Number 10.
10.
For the appellant lordship, the affidavit of service effected lordship.
Right.
My lord 6 POCSO, 20 years of conviction. My lord petitioner appellant has the
Willing to proceed with the statement. No need to.
My lord, the appellant has already suffered custody of more than 5 years. All through the custodial trial, he has suffered custody more than 5 years. Lordship has heard this matter, my lord, in the earlier occasions. Here, my lord, the allegations that the accused committed the offence under section 6 POCSO upon 2 victim girls. Now, lordships, the 2 victim girls, lordship, the prosecution case and the victim girls case was that the during the course of the commission of offence, my lord, the blood was oozing from the private parts. The wearing apparel was soaked with blood. There was injury in the private part of the victim girls. But lordship kindly comes to the PW depositions of the PW7, who is the medical officer. He said there is no sign of sexual intercourse or the sexual injury of any of the girls, lordship. Although the prosecution's case and the victim case is different. Now, lordships, there was a clear-cut depositions of the mothers of the victims that if the 2 lakh rupees given to the victim to them, they would not lodge the FIR. Now, my lord, from the depositions of the investigating officer PW8, your lordship will get that the wearing apparel, which was apparently soaked with blood, that has not been seized by the investigating officer. The charge sheet has been filed without the forensic report. There is no prayer for the
Forensic report was subsequently not filed.
There is no, my lord, no prayer of filing supplementary charge sheet after the
Forensic report regarding what? The wearing apparel?
Wearing not been seized, so therefore no question of the forensic report. Now, lordships, the depositions of the PW5-6, who are the independent witness, they said, they deposed that there was a admittedly dispute relating to the credit or the money. So therefore, this FIR has been lodged because to take revenge upon the.
Who said that?
The PW6 lordship kindly comes to depositions of the PW6.
Page number?
Yes, your lordship.
Page 50. Page 50.
Yes, your lordship, page 103 of the, my lord,
So there was a theft committed by these 2 girls.
that is, yes.
That was an allegation.
Allegations. Even when the accused has, lordship kindly comes to the cross, the accused had informed the respectable local people about the theft of the BGs. Since the accused has informed about the theft of the money to the people, a meeting was called for the same. The parents of the victim lodged the false complaint against the accused in order to take revenge. My lord, if your lordship kindly comes to the depositions of the PW5, who is the independent witness? He said, my lord, there is no inner chamber of the shop room, but the prosecution cases, they were taken to the inner chamber of the shop room and the offense has been committed. PW3, who is the victim girl number 2, she said she was standing outside there and thereafter she entered into the shop room, whereas the prosecution case was both were taken together into into the shop room, the shutter was closed, thereafter the offense has been committed. Now, Lordships kindly comes to the depositions of the PW7. Page 104, he is the conducting doctor, Lordship, who said on examination of VG number 1, I detected no such and such injuries. Hymen was intact. In my opinion, there was no recent forceful penetration into the vagina anal area. That these observations with regard to the victim number 2 also.
But it says, however, sexual violence cannot be ruled out.
But
sexual violence is vague, not section 6.
But now, your Lordships, if your Lordship kindly see the depositions of the PW1, PW2, who is the victim girl herself, she in his chief, she said that she was suffered pain, and my lord, the blood was oozing from his private parts, and the wearing apparel was soaked. But in the cross, she said there is no injury. She did not take any medicine, no treatment. Yes, Lordship kindly comes to the depositions of the PW1. PW2, who is the victim girl. Lordship, page 91. Page 93 is the relevant part. The leaving first 3 paragraphs, Lordship, page 93. I had suffered pain when he inserted his penis inside me and I cried. I also bled from my private parts and my wearing apparel stained with blood. The clothes of the accused was also stained with blood. Now, Lordship kindly comes to the next page. Page 94. Leaving first 2 paragraphs, I did not sustain any injury in my private part when the accused raped on me. I had shown my private part to my mother. I did not use any medicine in my private part after the incident. I was not taken separately to the doctor for medical treatment.
Yes, what do you say, Mr. Chakravarti?
My lord, first of all, my lord, on the previous occasion, my lord, kindly appreciate running page 22 of the main petition, my lord. This is a previous bail application, my lord, turned down by the coordinate bench after considering all these facts, my lord.
No, not all.
My lord, yes. And my lord, my lord, both child are 11 years old, my lord. They are sexually damaged, my lord.
Mr. Chakravarti, both children are 11.
Statement is highly corroborated.
11 years old, but they say that one of them says that blood was oozing and cloth was soaked.
My lord.
Soaked. Cross, she says no injury at all.
My lord.
11 years old, there has to be some injury, not a 5-year-old or 6-year-old. There has to be some resistance. 11 year, at least some injury. I mean, and the way it is described, and the doctor's report is absolutely, it seems to be biased.
64 statement and also the deposition of the both child, my lord.
Yes,
there is a corroboration.
But in please, 164 is followed by deposition. In deposition, cross-examination is very crucial. 164, there is no cross. So in deposition, you have to corroborate. And doctor's evidence seems to be a bit biased in the sense, she says that there is nothing to say that there is any hymen intact. Yes, even forcible penetrative hymen may remain intact. We are not on that so much. But no recent or forceful penetration into the vagina. However, sexual violence cannot be ruled out. She says this in every sentence. Again, she says on doctor, on examination of such and such VG2, detected no injury in any part. All the parts are named. My opinion was there was no recent forceful penetration into the vagina, anal or urethra. However, sexual violence cannot be ruled out. Why? This is absolutely biased, doctor.
But also, my lord, paper book is ready, my lord. So, my lord, trial may be comments. Sorry, my lord, appeal hearing may be, my lord.
Yes, you reside in the same police station, within the same police station as the victim girls.
My lord, yes, name.
But they will be under threat if you are released. What is your age? What is your age approximately?
62, 3 years old.
62 is barely judges retirement age. They do many things after that, not offenses.
Some stringent conditions, I will
My lord,
they are within the
trial-
restrictions where the girls
The
are residing.
conclusion trial, my lord.
No, this is a different test.
My lord.
But there is sufficient chance of acquittal.
But
Doctor's evidence and
lord,
wearing apparel not seized, there is no forensic report.
My lord. My lord.
Doctor's evidence clearly, I mean,
My lord,
demolishes
the
the.
paper book is ready, so my lord,
Paper book is ready in other cases.
earlier
Your
rejection is
Lordship.
clear, my lord, so paper book is ready. There is no any change in circumstances.
Learned counsel for the, we are granting. এটা দিচ্ছি, কেন- Learned counsel for the petitioner contends that there were several contradictions in the prosecution case. First up, it is submitted that on the occasion of previous rejection of bail, comma, those were not taken into consideration. Full stop. Next para. Learned counsel contends that apart from the fact that the petitioner is already in custody for 5 years and the 5 years, comma, the victim, one of the victim girls in her evidence in chief, examination in chief, comma, categorically stated that that aggravated sexual penetration happened and blood was oozing from the wound and her apparel were drenched. Push-up, she also said that the wearing apparel of the accused of the appellant was also drenched. Push-up, however, comma, in her cross-examination, she uh, took a diametrically contradictory view, but by saying that there was no injury at all. Push-up, even from the evidence of the doctor, comma, it is found that she categorically says repeatedly that there was no recent forceful penetration into any of the private parts of the victim girls. Full stop. Next para. However, comma, she supplements that with her own opinion that, however, comma, sexual violence cannot be ruled out. Full stop. Next para. It is submitted that in the absence of seizure of the wearing apparel and forensic report in that regard, comma, much reliance cannot be placed on the prosecution case. For sub next para, there was also a previous dispute between the victim girl's family and the appellant, inasmuch as some of the witnesses corroborated that there was an occasion where theft was alleged by the appellant against the victim girls from the former apostrophe's shop. Full stop. Next para, there are other irregularities sought to be pointed out by the petitioner, inasmuch as although the prosecution case was that the victim girls were taken together in an inner room inside the shop, comma, there is no such inner room as borne out by the evidence, and as per the victim girls, comma, they went separately inside the premises. For some next para, learned APP appearing for the state vehemently opposes the prayer for bail and submits that in view of recent rejection in January 2025 of a similar prayer, comma, the present renewal prayer should also be turned down. Full stop. Moreover, comma, the appeal is otherwise ready for hearing and can be taken up expeditiously. Full stop. Next para, we, upon scrutiny of the materials and the hearing the arguments of the parties, comma, we find sufficient benefit of doubt can be extended to the appellant inasmuch as there is fair chance of acquittal on several counts. Full stop. Apart from the admission on the part of the complainants that upon upon the failure of an amicable resolution regarding payment of money, comma, the complaint was lodged. Push up. Moreover, comma, from the evidence, comma, of some of the witnesses, it is found out that there might have been a previous instance where theft was alleged against the victim girls by the appellant, and as such, comma, there was a prior antecedent of dispute between the parties. Push up. Also, comma, crucially, comma, the wearing apparel were not wearing apparel of the accused.
Accused and
Victim also not seized. Wearing apparel of neither the appellant nor the victim girls were seized, comma, nor was any forensic report produced in that regard, despite the specific allegation in the prosecution case that there was blood oozing out after the offense. Pushed up. The victim, one of the victim girls, although stating in her examination in chief that there was blood oozing out after the assault, comma, in her cross examination, she completely denies the same and says that there was no injury at all. Full stop. The evidence of the doctor appears to be prima facie biased, comma, although such questions shall be gone into at length at the at the hearing of the appeal, comma, since despite repeatedly saying in case of both the victim girls that neither there was any recent forceful penetration nor was there any injury in the private parts of the victim girls, but reiterated repetitively that there, however, comma, sexual violence cannot be ruled out, comma, without any basis whatsoever. Full stop, next para, thus, comma, in view of the above mitigating circumstances, we are of the opinion that the benefit of bail ought to be granted to the petitioner, comma, more so since the matter has reached the stage of appeal and the petitioner is already in custody for 5 years. Full stop, next para, hence, CRAN 2 of 2025 is allowed, thereby granting bail to the petitioner on condition of that the petitioner shall furnish bond of rupees 10,000 with two sureties of like amount each to the satisfaction of the special court POCSO Act. Which district? Mathabhanga district, Kuch Bihar. Full stop, next para. The appellant stroke petitioner shall not in any manner try to induce or intimidate the witnesses and or approach or contact the victim girls or their immediate family in any manner during the pendency of the appeal, and shall not tamper with evidence as well. Full stop, the appellant shall not leave the territorial jurisdiction of the local police station and shall make himself available as and when so required by this court. Thank you. প্রথমে affidavit of service filed today দিকে পাবো। Yes. Connected, why connect?
Yes.
Same offense, different petitioners?
Yes, my lord.
Yes, sir.
My lord, permit me to address your lordship. My lord, I am online, my lord.
Yes, Mr. Banerjee, give us half a second, just something is.
Yes,
Yes,
my
you. Served.
With the victim are already informed.
Well.
The compliance report.
Yes, so Mr. Banerjee is leading whom?
Well.
I think about 12.
So should you hear Mr. Banerjee is the senior most of you? Yes.
Service report.
Service. Yes, Mr. Banerjee.
My lord, peculiar facts and circumstances.
Not Mr. Anirban, Mr. Shobushati. My name is.
I'm junior.
Yes. Both of you are there online, that's what you're saying. Yes.
But
Yes, Mr. Shobushati Banerjee.
I must, my lord, before I commence a very serious hearing, the previous matter, my lord, the judge's retirement age and not them not committing offense was outstanding.
Then your applications are sure to be rejected after that.
I don't mind.
No, Mr. Banerjee, what is the matter?
Yes, my lord.
Thank you for that. Thank you for that. Yes.
My lord, this is a bill in connection with the bill 376D.
Dr. Chaudhary, both of you are appearing for the state.
I am
For the state. The complainants are represented by anybody. You'll represent their interest also. Sorry, Mr. Banerjee. Yes.
Yes. 37.
We'll come back in 5 minutes.
Yes,
We'll
my
just
lord.
come back in 5 minutes. Yes.
Yes, my lord. Yes, my lord. Grateful.
Because our.
Yes, my lord, I understand, my lord. Grateful. Yes, my lord.
Yes. What is the case about? Yes.
Well, it's a 376 read with Scheduled Caste Scheduled Tribes Act. It started with that. Well, it
Pardon?
gives
With red with?
Scheduled Caste Scheduled Tribe Act.
That's very good. Yes.
Right. Well, it started with, the story goes such that a girl who goes to college regularly decides to get a lift from a boy. The boy asks the girl while she's going towards the college to come inside the car. The girl boards the car. There's another boy who's driving the car in front. The girl sits with the boy at the back seat. Then they drive. While driving towards a particular location, the boy actually puts a pillow on her face and asks the boy in front who's driving to drive towards towards the locale. Let's put it this way, towards the place of occurrence. Then the girl alights with the boy. The boy takes the girl into a house. The house is basically an emptied kind of house with not much houses around. The girl is taken inside and the girl is offered money for sexual pleasure. The girl refuses. After that, she's raped. There's one more boy who's out there. So we have three persons out there. The boy who's out there, the boy who's driving, these two boys apparently film whatever is going on. And then the other two boys rape this girl also. This girl comes back home, does not divulge, and the girl after that, I'm sorry, my lord, the story goes says that after that, the girl is again, taken back in front of the college, dropped. From there, she takes a toto and she goes back home. She does not tell anything to her mother because of the fact that her mother is a heart patient. The father is not featuring in the scene. And then the girl tells another male friend of hers, who happens to be the PW3. PW2 is the mother. So she discloses to the friend. Thereafter, she discloses to the police. After disclosing to the police comes, seizes the wearing apparels, necessary arrest takes place, and thereafter I'm taken into custody. There's a conviction. The proceedings start under the relevant provisions of SCST Act as well as 376D. Thereafter, the trial commences. I am convicted of 376D, but I'm acquitted for charges of SCST Act. Now, before your lordship, I take your lordship to the basic evidence, because this is bail in connection with the appeal and not the appeal, my lord. Four things your lordship would just keep in mind when I'm indicating. First of all, in the story, the girl does not know the boy who's driving. The girl does not know the boy who's at the house. This is number one. However, the FIR would reveal that the girl has given a graphic description of where the boys stay as well as the boy's parents' name when the FIR is lodged. This is number one, which is extremely shocking. Number two is that the girl confides in the other boy, who happens to be a friend. That boy's conduct, my lord, I'll show your lordship, clearly reflects that he had no knowledge, because he does not tell her anything with regards to what is supposed to be done. The boy does not tell the other friends. The boy does not tell her to go to a petition, go lodge a petition of complaint. The boy does not do anything. And he happens to be the best friend of the girl. This is number two. Number three is that the wearing apparels, which is apparently the most important piece of evidence, is collected in terms of the investigating officer's deposition from the house of the victim girl. Whereas the girl says that the girl has gone and given all the victim articles to the police in the police station, which changes, my lord, the character of investigation which has happened. Now, this your lordship would keep in mind because of the fourth point, that the girl was never taken to the place of occurrence. These are the primary 4 points. Now, ancillary 2 points. Ancillary 2 points is the person who has the house is never examined. The girl says that the house belongs to one Mr. X, but from evidence it belongs to Mr. Y. Actually, whom does it belong to is not ascertained. Now, the other ancillary point which comes up is, my lord, the allelic table and the DNA report, which, my lord, Mr. Arnab Shah, who's assisting me in this matter, my lord, he's going to indicate this. But primarily, the car which the girl traveled in 164, she says that she traveled in an Alto. The evidence which is collected for forensics is collected from an Omni. admittedly. So the car also changes. And from the allelic table, what we get, my lord, from the graph that we have got, my lord, the other articles which have been seized, they do not match, or they are not in conformity with the DNA of everybody. They are at variance. What is not at variance is the swab which is taken from the vagina. Pardon my language, my lord. I have to use these terms.
No.
As well as the semen that is collected, my lord, they apparently match. But they match so far as two persons are concerned, not so far as the third accused is concerned, the third convict is concerned. However, the third person is also convicted. Now, the another ancillary point, my lord, since I say it's ancillary, is because the whole allegation is that the two boys raped subsequently because of blackmailing, because of the video that was taken. There is no video on record, there is no mobile on record. This, because the moment I am dealing with a 376D, there is apparent, my lord, a disdain in everybody's eyes. But these are facts which are written so evident, my lord, which would show possibly, which would indicate that possibly there's a little more than what is meeting the eye. My lord's pleasure would be to kindly have a look at the FIR ones, which my learned friend will produce before your lordship. The FIR first.
How long are you all in custody, Mr. Banerjee?
3.5 years, my lord, 3 years, 7 months.
Since December 2021.
Right.
And I have never been released on bail despite these documents being on board, my lord. Your lordship would kindly see the last page of the third page, last paragraph, where graphic description has been given of all the accused persons. Because if nobody is known, then these details are not possible.
This is, where is the FIR? This is the complaint.
The complaint, the FIR and the complaint forms a part of the FIR, my lord.
Yes,
So we
but
refer to the whole thing as the FIR.
Third page, we don't, second page probably.
Yes, my lord. Sees, my lord, the last portion, Benito. I will not take the name of the victim openly, my lord. But on the left hand side, Ashamir Biboron, Niche Dilam.
Yes, yes.
He gives this. And she
Right.
gives descriptions. On the left, 1, 2, and 3.
Yes.
Right, my lord? Your lordship sees that all details are given. My lord,
Yes.
from here comes to PW1. Comes to PW1, my lord, kindly. Oh my. I'm sorry, my lord, I have
You
lost
don't have a
it.
copy? You can give a copy to the. Yes.
My lord, kindly comes to PW1.
Yes.
Kindly comes to, my lord. Page 2, internal page 2.
Yes.
Yeah, right in between, voluntarily says. She does not know this person.
Voluntarily.
Page 2, internal page 2. My lord,
Yes.
page 6. Your lordship sees, I'm sorry, it's my lord, in cross-examination of Jamir Hussain. Cross-examination of Jamir Hussain. I do not know how things are because we don't have
Oh, no.
paper.
That's very well. We have got that cross-examination. Yes.
Yes. Now kindly comes to the cross-examination, second page, internal page 2, it says.
Voluntarily, yes.
Yes.
Voluntarily says, I came to know the name of Firoz from their conversation subsequently. She does not know this person.
No, but from the conversation, she came to know.
But the rest is not known, my lord. Which village, what is
Right.
the father's name, nothing is there.
Hmm.
She just comes to know of the name. Whereas description is given.
Yes.
Your lordship understands. Now, my lord, from here, permit me to read out just 4 lines just after that.
Yes.
Those turned their car in opposite direction after the car proceeded a little wide. I have mentioned in my written complaint that Jamin suddenly pushed the pillow of car in my mouth so that I cannot shout. and all that glasses put up from inside, there's two glasses put up by Firoz in front side. But this pillow was never seized. And this is an Alto car in terms of the 164. And this is an Omni car where articles are being brought out from. So the vehicle which is there concerning is completely doubted. Now, stopping here for a moment, Malad, I'm sorry, I would be showing your lordship three things together. Malad kindly comes to the judgment, keeps this portion in hand, sees the judgment, Malad, sees how the lower court is dealing with it. In the judgment, page number
Yes.
34 of 51. The
34.
learned 34 of 51.
Yes.
The learned judge does not even deal with this issue. He says that this is too trivial in nature. Kindly sees PW, the paragraph number 8. Sees how cavalier this has been dealt with. PW1 in her evidence in court stated that she met Firoz and Jamir when they were in Maruti vehicle. In the written complaint filed by the VG, she did not specify which vehicle it was in, but in a statement recorded by the learned magistrate under 164, she stated that the vehicle was Alto vehicle. The learned advocate, in respect, argued that the testimony of the victim girl was unreliable and shaky, as she has stated in a statement given to the magistrate that the vehicle was Alto vehicle, whereas the seized vehicle in this case, as per seizure list prepared by the IO, says that the vehicle was a Maruti Omni van. This court is unable to hold at this point that mere incorrect description of the type of vehicle in the statement given to the magistrate, which speaks weak evidence, does not make the testimony of victim girl to be unreliable, especially when the victim girl has stated in her evidence, as also in the written complaint, that the vehicle was a Maruti vehicle. Malad, your lordship understands the difference between an Omni and a Alto.
Not sure I would if I was in her position. Actually, Mr. Banerjee, Alto Omni, we don't find it to be a very strong ground. I mean, we are
I'll tell you, lordship,
rather we
why.
concur with, because we have to see the social context also. A girl, college girl, we don't know whether she owns a car or not, or whether Maruti Alto or Omni. I mean, there may be a doubt.
Why? Because the
perception.
place from which I understand. Now, this fact gets more emboldened with the fact that the Maruti vehicle was seized from a particular place, from a particular person. That person was never examined. That person was never examined. So if the vehicle itself from where DNA samples are being taken is disputed, Manoj, your lordship would please appreciate. Now, between ocular and scientific, there is scientific evidence which is coming into play. The kind of vehicle is completely different. The person from whom the vehicle is being seized is different.
But Mr. Banerjee, there was a slight shift in the onus when the swab of the vagina and the semen matched. I mean, how do you explain that? It's your onus to explain that once that's done. We understand that, yes, there are irregularities in the recovery of the material, but even then.
Malad, this issue, Malad, comes into DNA. This issue comes into DNA.
Yes,
yes. Malad, I would respectfully ask Mr. Malad, my junior over there,
Mr. Shah, yes, DNA.
Mr. Shah, to place those DNA records before your lordship. And there's a small note that we've prepared, Malad. I would request them to produce that note. Your lordship would kindly follow the note, which we are,
whatever you give us, give a copy to them.
A copy. I'm giving you the copy.
Give at least one copy to, so that both of them. Yes. What is an off-ladder allele, Mr. Banerjee? We don't know.
Malad, that is a scale which is used. The Alimony table is used, Malad, to determine how close the proximity of the chromosomes are.
Understood. Thank you. It's a very good explanation. Yes.
This is the closest that I could go.
We understand completely. Yes.
Malad, I can assure your lordship one thing, that class 10 onwards, I did not take science. I was extremely scared of maths as well as all the.
Neither did I, Mr. Banerjee. I was one of the last two persons who got science in my school, Calcutta Boys School. So I dared not take science because I was one of the last two. So
Very well, Manoj. Then
don't-
the
you
two of
have
us.
caught me on that also. Let us go by the LLIC report or
Yes.
whatever.
So I would request your lordship to take the note once.
Yes,
To
we have
take the
taken that.
note. The note that is there, my lord, your lordship first takes up the note. Sees
Yes.
over there, we have said relevancy in the instant case. Now, kindly sees, my lord, as per the allelic table 1, a profile 3 samples of locus indel shows OL peak. That is off ladder, my lord.
Right.
3 samples of locus so-and-so shows OL, this is another one. One sample of so-and-so shows OL peak. These are all things which are saying that in the place of occurrence, which is the house, the evidence of these semens were not there. I will just put it in a nutshell. OL is off ladder. Right? So no semen is being found from these ancillary places. In bail in connection with appeal, I don't expect to argue like an appeal. But
right.
The reason why I have given from scientific evidence that whatever was there in the place of occurrence did not reveal a rape, did not reveal existence of semen.
No, your sample was taken from the car, which you were casting
One
some
is
doubt on.
car and the other one is the locale.
Achha.
At both places, car, my lord, changes character. That is the reason why I emphasized on car.
Yes, but the local sample also matched.
No, it goes OL.
Achha.
It goes OL. What is matching is what is being seized from me while I'm in custody, and, my lord, what is seized from her while she has given the articles.
So that also creates a, presumption of.
That also creates, my lord, because I understand. So far as the third accused is concerned, it does not. So far as two persons are concerned, my lord, there was an element of consensual which is evident from, my lord, the judgment, which is there in hand. That is the reason why, my lord, I'll tell your lordship, keeps this concept in mind and kindly comes to PW3 once. Kindly, my lord, this becomes extremely germane. Kindly comes to PW3, your lordship would understand what I am trying to emphasize. Malay kindly comes to PW3, running page 18. Your lordship would understand why the only friend who's hearing the story does not react.
Yes, PW3, 18.
Running page 18, internal page 3.
Right.
Right, my lord. Kindly sees from the 4th line on the top. After hearing the incident on the phone, in spite of the fact that Momita was my childhood friend, I did not rush to her house. I did not inform to the police station about this matter. After hearing about the incident, I did not have any word about the same with anybody on that date. Presently, I have 10-12 friends, including females. Some of my friends are knew about my friendship with Momita. I did not share with any of my friends that Momita had met with such an incident. I did not advise Momita to get herself examined by doctor. I did not ask her to come to my house immediately after the phone call. I'm unable to recall how long the conversation lasted over phone. When she disconnected her phone, I did not ring her back on the same date. This shows the conduct and the contents as to what actually had happened. Your lordship, please understand that the only person who knows about this whole incident, admittedly, by the PW1 is her. Now, what the way, my lord, please do not take me amiss, the way the whole thing is being covered up is that there is an IPL which has been given to her and she's consuming it. Please appreciate the person is being dropped back to the college. From the college, she's taking a toto. The toto person is not examined. Nobody from the college has been examined. Nobody testifies regarding the fact that she was picked up at all from in front of the college. Let us say for a minute that she's picked up. But one last point. This is the reason why she's never taken back to the place of occurrence. more.
How do you explain the vaginal swab matching with the semen?
My lord, this is one thing, my lord. I'll tell your lordship. My lord, kindly comes to the evidence of the doctor who's treating her. কত number ba? Treating doctor. Just a minute, my lord.
Yes.
My lord, kindly comes to PW7, which is there at page 26. Now see, sir.
Yes.
Now kindly seize, my lord, at page 27, running page 27.
Yes.
Kindly see, it is true, examination by defense.
Yes.
It is true that I have not written here the victim stated the names of the alleged offenders or the place of incident to me in a history. Right. Now says, it is true that I have not mentioned the probable age of injury which I found on the victim girl. It is true that hymen could have been ruptured if the victim girl had consensual sex. It is true that the 6 o'clock injury would always occur in case of forceful sexual intercourse, which is missing, my lord, over here. I have not mentioned that probable age of scratch marks. It took about half an hour to examine the case. I've examined her clinically. After examining the victim girl clinically, I did not refer to any higher center. It is unlikely that the scratch marks found in the victim could offer due to self-scratch or itching. This is so far as the upper portion is concerned. But the fact of the matter is that all these things are also there. So
Let
the
us hear-
fact that
Yes.
consensual sex cannot be ruled out in this case, because the kind of injury that will happen in the 6 o'clock mark is absent over here. For any forceful penetration, especially when we are dealing with a 376D. We are dealing with a 376D, my lord. With an IPL being given, with somebody being dropped off at college, and she takes a toto, the toto exam person is not examined. So if I put all the evidences together, if I sum up, my lord, in a minute, the house is, there's no reconstruction of crime.
Yes.
That's number one. Number two is the girl is never taken to the place of occurrence. Number three, from where the articles are being seized is completely shrouded with mystery, because the girl says that she's given it to the police. In the police station, the police says that we've collected from the house of the victim.
Yes.
Number
Let us
four-
hear. Let us hear the
Yes.
prosecution.
Yes, my lord. Thank
You want to add something? Yes.
Lordship, one submission I have to.
Yes.
Lordship, I am for Ekramul. The FSL doctor says this Ekramul's sample does not match with the vaginal swab, Lordship.
Ekramul is item number?
Item number 11, Lordship.
11.
Kindly see page 78, the FSL doctor's evidence.
Very well.
So I am not in the same footing. I'm in a better footing than the other two.
Very well. Very well.
That is
One
Jamid
last
and
point.
Firoz.
One last point. The
Yes.
internal garments, my lord, I'll not specify. Your lordship understands the internal garments go missing. They are not seized.
Acha.
They're seized, in fact, and never produced. So never tested, actually. They're never produced in court. And that is the reason why the mother says that this particular article is not there.
All right. Yes. You want to add something, Mr. Ghosh? You are in which item? Just tell us the item.
30.
Yes.
Yeah,
Yes.
sir.
What is your mitigating circumstance?
I'm not, apparently we're on the same, I'm on the same footing with Mr. Banerjee's client.
You are the driver or the third person who was there?
I was, my lord, behind with Momita. I was the one who apparently put the pillow on her face. So, my lord,
According to her, the first offender. I mean,
yes, my lord, yes. So, my lord, I'll just add 2 points to what Mr. Banerjee has submitted already. My lord was inquiring about the, my lord, custody of the DNA vaginal swabs. So, my lord, in that regard, kindly takes up the deposition of PW7 once. In my index, my lord, it starts from page 35.
and PW7 is?
PW7 is the doctor who conducted the examination.
Right, right.
Who
Yes.
basically collected the vaginal swab.
Right.
So, my lord, I'm reading out from page 35. The line starts at the bottom, her vaginal swab.
It's 35.
Yes, my lord, page 35 of my index.
Yes, yes.
her vaginal swab was collected by
7 lines
myself
from bottom.
and I handed over to the same to the police person. So, my lord, she says that she hands this over to a police personnel. Now, my lord, where from the vaginal swab is seized, takes up the, my lord, seizure list, page 11. Now, my lord, the IO. My lord, page 14 is important. Page 14, the seizure list.
Yes.
My lord, the second seizure, vaginal swab in respect of such and such, being handed over by LC 741 Ekadoshi Borman. So apparently, my lord, she hands over to a police personnel. This Ekadoshi Borman apparently hands over to the IO.
Ekadoshi is the victim.
No, my lord. Ekadoshi is an LC, constable.
Oh, yeah. Achha.
This Ekadoshi Borman, my lord, was not examined. So, my lord, the custody of the vaginal swabs from the medical examination to the seizure is, my lord, questionable. Firstly, this LC Ekadoshi Borman was never produced. Now, my lord, secondly, after the DNA, after this vaginal swab was collected, how did it reach to the, my lord, FSL? That is also important, my lord. Takes up the evidence of the IO. My lord, in my index, it starts from page 42. My lord, the relevant page is page 44, the second last paragraph.
After hearing, all of you will dispose of the appeal.
My lord, page 44.
44.
Yes, my lord. The second last paragraph, it says, on 30th 12/21, my lord, is with me?
30th 12, yes.
On 30th 12, I gave a requisition to the BLRO Shitalguchi for fixing up the PO and took along with him assistance to the PO where they fixed up the PO. On the same day, I sent the seized vaginal swabs and wearing apparels through Constable Shurujit Burman to CFSL for its forensic examination, but the same day it was refused by the laboratory by written explanation. So, my lord, the swab goes to the laboratory, comes back. After this, before it is resent, there is no explanation as to where was the what was the custody of these vaginal swabs. So, my lord, the vaginal swabs, firstly, their journey from, my lord, the medical examination to the IO is.
When was your specimen taken?
My lord, my semen was taken, my lord. I'll come to that too, because ultimately I say that my semen and my blood were taken forcefully at the time of 3:30. So, my lord, my semen matches with the vaginal swab, but the journey of the vaginal swab from the medical examination. It is sent, refused with written explanation. Now, my lord, next page kindly comes. Page 45.
Yes.
The first line, on 2/1/22, I resent the vaginal swab and wearing apparels to FSL through Constable Shurujit Burman. So, my lord, between 30th and 2nd, where were these vaginal swabs? Where was this vaginal swabs, my lord?
We need not go into such a detailed examination of the.
No, my lord. This is the only clinching evidence against us. The matching of the vaginal swab with our semens. Now, my lord, takes up the examination under 313, 54 onwards, my lord.
What are your ages? 20s?
Yes, all 20s.
Which page?
Page 54 onwards is my 313 examination.
Yes.
54 to 57.
Right.
Not a single question has been put to me as regards this matching of my semen with my with the lord vaginal swabs.
What sort of question should have been put?
Lord, this particular that the DNA your DNA matches, your semen's DNA matches with the victim's DNA.
Nothing in that regard.
Nothing. No 313, my lord. It vitiates the entire trial. I'll just place one judgment on this point, my lord, that at the time of 313,
it has to be put. Questions,
yes,
relevant questions all.
Otherwise, my lord, that cannot.
That is the purpose of 313.
Yes. Otherwise, that cannot be made the basis.
No opportunity of explanation.
So, my lord, these are the additional points that I.
Let us hear the prosecution then. Yes. Yes, Dr. Chaudhary.
I am looking at 11 and 12.
And my lord, the place of occurrence is also in doubt because as Mr. Banerjee has submitted, she was never taken to the PO.
Yes, that
she never
Mr. Banerjee has made that point very clear. Yes.
Make submissions only with respect to 11 and 12. So far as my lord 11, the appellant in 11 is concerned.
The samples don't match. in his
His
case.
bail was turned down on 13th of May 2025 by a coordinated bench of this court, my lord, clearly say
Yes.
that this court has carefully considered the evidence on record and the judgment of the trial court. It appears from the impugned judgment that the conviction of the appellant appears to be based on several other evidence in addition to the DNA. My lord, in view of that matter, my lord, it was rejected. Now,
And
my lord,
he was a part of the entire thing, I mean, offense. So that also goes into. Even if the vaginal swab does not match,
yes,
he was equally guilty because he was
Yes,
a part of
yes,
the entire
yes,
thing. He was
yes,
a
yes.
part of the plan,
correct, my lord.
apparently.
So 13th of May, now we are in the month of my lord, July. So, my lord, there is no change in
What about the
circumstance.
others? I mean, the place of occurrence, the girl was never taken there.
No, my lord, that they are saying, my lord, but there are, my lord, this is a pick and choose evidence. My lord, this court has to consider the evidence in totality, my lord. So they have relied on 2-3 witnesses. My lord, unless your lordship sees the other witnesses, what they have deposed, my lord, how come, my lord?
Achha, one other thing, Dr. Chaudhary, they are in 3 years and 7 months in custody. The appeal is pending. Now,
Lordship.
if investigation is long over, and how will they, what will be the harm if they are, I mean, enlarged on bail?
My lord,
And normally, bail is the rule even in, yes, these serious allegations are very serious. 376D is there. Understood. SCST released, not convicted. So if SCST was also there, it would be very difficult for us to consider even. Maybe very difficult. But 376D, yes, higher standard of proof is necessary than 376. Why should we put them on terms and grant them bail? I mean,
Lord,
this is
so
one of
far-
the questions which is germane at the
Yes,
time
yes,
of bail.
yes, my lord, is absolutely correct. My lord, so far as the
Safety of the victims and all will ensure definitely.
my lord, pre-conviction stage
Different.
different, post-conviction stage is different. So, my lord,
Post-conviction, there are certain, it plays both ways, Dr. Chaudhary.
lordship.
Pre-conviction, yes, trial is still going on. There is more chance of tampering. Appeal, we are just looking into
Yes,
documents which are already there. There is no question of tampering unless he
Yes.
had access to our records.
Yes, yes, that part is.
I mean, it plays both ways. I mean, we don't know why this is not considered. I mean, post-conviction, we say mechanically, but post-conviction, it should be rather easier because he's not an under trial. Definitely, he's a convict now. We understand that. But purpose of bail is to consider whether individual liberty should be further, withheld unless the last court of facts confirms the
My lord,
sentence.
post-conviction parameter is, my lord, he is having
Chance of acquittal is one.
My lord, that is one aspect. Another aspect is, my lord, he is convicted. So, my lord, the presumption of innocence is not available to him.
No.
So, my lord, the gravity of the offense has to be considered by the appellate court, and my lord, a fair chance of success in the appeal. That is one of the further parameter, my lord, to be taken into consideration. Now, my lord, what your lordship is saying, my lord,
He's otherwise undergoing a sentence, not that we are giving him the freedom which he
Yes,
owes,
yes.
but he's undergoing a sentence,
Sentence.
not his liberty is being curtailed. His You are rejecting, Mr. Banerjee.
Only one,
Yes.
only one prayer.
Yes.
We just request your lordship to consider one thing. The person who's appearing, my lord, who appeared right now, my learned friend indicated they were all friends. They were all friends.
The consensual side of it, you were saying.
Yes, so give us a chance. Possibly in appeal, we have a fair amount of chance of success, my lord.
Yes.
Please appreciate. These are all boys of 20 when this has happened. They are still in their 20s. The girl is married off. She's settled out. We are languishing in jail. We also have a future, my lord. These are 20s boys, my lord. They'll buy IPL if there was an element of rape, gang rape. They'll drop her off. There'll be no injuries in the thighs. There'll be no major injuries. We do not want to cast any aspersion on the person who's there. But please appreciate that there is a very, very high possibility by going through the conduct.
Lordship. My lord.
We can't hear your lordship.
Sorry.
Okay.
The other aspect of the matter, Mr. Chaudhary, we want to put a question to you that here the angle of consensuality has also been brought in. Might be, may not be, but there is no other injury of sorts. I mean, that because the doctor's evidence we have seen also, hymen rupture definitely, swabs match, but that element of no explanation as to why she went into the car in the first. That consensuality angle we also deal with.
That angle. Lord, this girl, Lord, she was a student of Shitolkuchi College. Lord, two of the accused, two of the convicts, they were also students of Shitolkuchi College. So, Lord, they
That's
were
it.
known to each other. They were known to each other. She was going to college. These accused persons were also going to college. Told her that come with us, we will drop you to the college.
The moment consensuality comes in, Dr. Chaudhary, what we have to look at is the nature of the injuries.
Now,
Because
there
she
is
was
this aspect
she was sufficiently old to resist.
was administered, Lord, some intoxicating material.
None from serological
Produced in
report.
that regard, from blood, her blood sample, something
Nothing
of
is
that
there.
sort.
Lord, that, Lord, the entire evidence has to be considered in that.
No,
Probably
no,
not.
we are pointing it out. My lord, let the state not say that. Let
No,
us say
not-
that some form of intoxication was found. There is no reference of that, my lord, in the
That is
document.
the plinth of his argument also. There is no intoxicant found from
There's no mobile
no
phone
blood
system.
sample also. We don't
There's
find any
nothing.
medical report or doctor's evidence on that
Lord,
also.
then the entire, Lord, I do not have the entire papers right now.
No,
But it
but
has to be considered from the evidence of all the witnesses,
We
Lord,
have
and
given
other
it.
things on record. What are the
We have
exhibits?
given every possible evidence which is there is.
we are also considering the age of the boys actually. I mean,
That is a different. I will
Grateful.
not comment on that. Definitely, they are young boys. They are college-going boys. Milord, even as I remember from the records, one of the boy was Milord, he had obtained permission from the court, trial court, to continue his studies. That is, that is one aspect, Milord. I have nothing
That
to
is
say on that.
our petition.
I have nothing to say
Item
on that.
30.
So, but Milord,
we have changed our mind.
Grateful, my lord. Grateful, my lord.
Deeply observed.
Learned, Mr. Banerjee, you are appearing in he's appearing in which item, Mr.
12,
Shah?
12, my lord.
12.
I'm in item number 11, Lordship.
Very well. Learned, senior counsel appearing for the petitioner in item number 12 বলছি শঙ্খ আইটেম নাম্বার গুলো দেখে বসিয়ে নিও আমি আইটেম নাম্বার বলে বলে বলছি আইটেম নাম্বার 12 ওখানটা আইটেম নাম্বার লিখো না ওই নাম্বারটা দিয়ে দিই আইটেম নাম্বার 12 as well as learned counsel appearing for the petitioners in the other two items which are taken up together, comma, since those arise out of the same conviction, comma, contends that there are several infirmities which raise a fair chance of acquittal of the petitioners in appeal. Full stop, next para, first comma, the victim girl, comma, although admitting that she did not know the other two assailants apart from the accused person with whom she sat on the back seat of the car in which she was allegedly taken to the place of occurrence, comma, gave details of their addresses and their father's name in a statement. Puts up next para, that apart, comma, although she allegedly confided with one of her other friends about the incident on the same day, comma, the said friend did not disclose the say about such incident to anyone whatsoever. Full stop. Importantly, comma, the girl was allegedly taken to the place of occurrence, comma, the offense occurred and the girl was returned to her college. Full stop. This string of incidents raises a question of consensuality as well. Full stop. Next para, although the DNA samples in case of two of the petitioners matched with the swab test from the vagina of the victim girl, comma, there is doubt reasonable if there is sufficient doubt cast on the collection of the sample, full stop, whereas the victim girl stated that she had given the given her sample to the police in the police station, comma, the police version, the prosecution version is that the police collected it from her home. Full stop. Moreover, comma, the victim girl was never taken to the place of occurrence at all. Full stop. The owner of the house where the incident allegedly occurred was never examined or ascertained even. Full stop. Next para. By relying on the DNA reports and the Alemic table, ALEMIC table, associated there with
Allelic, my lord.
allelic, ALLELIC,
Yes, my lord.
ALLELIC table associated with the same, comma, it is submitted that it has not been clinched beyond reasonable doubt as to the commission of the offense. So furthermore, comma, dwelling on the element of consensuality, comma, it is argued that the uh, victim knew at least two of the uh, alleged of the accused persons. Full stop. Next para. From the medical report and the doctor's evidence, comma, it is pointed out, comma, no sign of injury otherwise than rupture of hymen was uh, proved. Full stop. This, comma, read in the context of the circumstances, comma, brings forth the apprehension that there was actually consensual intercourse between the victim and the accused persons. Full stop. Next para, pointing out to other infirmities in the prosecution case, comma, learned senior counsel argues that whereas in a statement under section 164 CRPC, the victim girl stated that the car in which she was taken was a Maruti Alto, comma, in her evidence, she resigned from such position and changed the make of the car to Omni. Full stop. Next para. Even otherwise, comma, the
My lord, one thing, my lord.
yes,
My lord,
yes.
thing. My lord, she did not resile. The evidence was collected from Omni. She said
Acha.
Alto, the evidence is collected from another car.
আচ্ছা she
That
she
is
resigned from the position যেখানে বললাম ওখানটা কেটে দিয়ে তার আগে অল্টো পর্যন্ত ঠিক আছে the evidence was collected from a different make of vehicle being a Maruti Omni car. Full stop. Next para. This, comma, it is contended, comma, sheds doubt on the authenticity of the sample collected. Full stop. Next para. That apart, comma, it is argued that the accused persons were acquitted of the charges under the SC/ST Act and were convicted only on Section 376 capital D. Full stop. The high tests of Section 376D are not met in the present case, comma, it is argued. Full stop. Next para. uh, learned counsel appearing for the petitioner in item 12 নামটা দিয়ে দিও নাম্বারটা দিয়ে দিও that is namely Ekramul submits that the vaginal sample did not match with the sample with his semen, and as such, comma, the conviction against him is on an extremely weak footing. Full stop. Next para. Learned counsel for the state opposes the prayer for bail and submits that the appellate court, comma, at the stage of grant of bail, uh, in connection with an appeal, comma, applies different tests than a pre-conviction bail. Full stop. In the present case, comma, a competent court has convicted the accused persons, and as such, the tests on which bail ought to be granted is much higher. Full stop. Moreover, comma, the evidence cannot be picked and chosen from, but has to be read as a whole. Full stop. At this juncture, comma, a mini hearing of the appeal cannot be held while considering the grant of bail. Full stop. Next para. Upon a careful consideration of the arguments of the parties, comma, we find certain chinks in the chain of events as portrayed by the prosecution, comma, including the collection of the sample from a different make of vehicle than that alleged to have carried the victim to the place of occurrence. First of that apart, comma, the victim was never taken to the place of occurrence for a reconstruction of the event. Full stop. Moreover, comma, the in respect, at least in respect of Ekramul, comma, the vaginal sample doesn't match his semen sample. Full stop. Next para. There are other infirmities as well, comma, including the only male friend to whom the victim in whom the victim confided, having not disclosed anything to anyone at all. First up, next para, the discrepancy in the versions of the prosecution and the victim as to the place where the wearing apparel were recovered by the police also plays a somewhat important role in the entire string of events. First up, an element of consensuality, comma, at least on a prima facie footing, comma, cannot be ruled out altogether in view of the fact that the victim knew most of the alleged alleged of the accused persons, and that after the alleged incident, comma, she was dropped to her college from where she went home. First up, next para. Thus, comma, we find that an arguable case for getting an acquittal in the appeal has been made out by the appellants stroke petitioners. For some next para, we also take into consideration the young age of the petitioners, comma, who, comma, if they languish in custody during the pendency of the appeal, comma, before the last court of facts finally takes a call on the legality of the judgment of conviction, comma, would adversely affect their future as well. Full stop. Moreover, comma, the petitioners are already in custody for about 3 years and 7 months, and as such, no useful purpose would be served if they are kept in incarceration during the pendency of the appeal, comma, since all the documents and reports and as well as evidence are before the court, and the appellate court is to decide on the appeal. Full stop. Moreover, comma, we are not sure as to how soon the appeal can be disposed of. Full stop. Keeping in view the above considerations, comma, we are inclined to grant bail to all the petitioners. Accordingly, the petitioner in each of the matters bearing such and such number are granted bail on condition that each of them shall furnish bond of rupees 10,000 with two sureties of like amount each, one of whom must be local, to the satisfaction of which
Kuchbihar.
to the satisfaction of the CJM Coachbear, full stop. The sureties may be common in respect of the petitioners. Full stop. During the entire pendency of the appeal, comma, the petitioners shall not, comma, in any manner, comma, attempt to contact or approach the victim girl or her immediate family or any of the witnesses, and or try to intimidate them or induce them in any manner whatsoever, and or tamper the evidence. Full stop. The petitioner shall not leave the territorial jurisdictions of the local police stations except for the purpose of attending this court, comma, if so called upon to do so by this court. Full stop. Any other rigor you want, Dr. Chaudhary?
My lord, only thing is that if they have to go out for studies, my lord, then maybe come back to this.
Acha, very well. Acha, shall not leave the territorial jurisdiction যেখানটা বলেছি, shall not leave the territorial jurisdiction of the local police station. পেয়েছো জায়গাটা? পেয়েছো? হ্যাঁ, without the leave of this court বলে বাকিটা যা আছে।
You know, the concerned court is ACJM Matha.
কুচবিহার
CJM Kuchbihar.
ACJM মাথা,
মাথা।
তাহলে কোর্টটা হবে to the satisfaction of ACJM মাথা ভাঙা। Yes, what?
Ekramul is item number 11.
Yes, that is what is.
Gone into Ekramul is item number 12.
12 যদি কথা বলে থাকে, যেখানে 12 বলেছি 11 করো, 12 এর কথা আমরা বলিনি।
11.
Lord, one thing, Lord, my objection as well as my reliance upon the earlier rejection order may kindly be recorded.
আচ্ছা, ওটা গোড়াতে করে দাও। At the outset, comma, learned counsel for the state contends that a similar prayer for bail was rejected earlier for one of the petitioners. Which one?
Ekramul.
11.
That is
11.
Ekramul. As recently as in the month of May this year. And full stop, learned counsel for the state seriously opposes the prayer for bail in respect of all the petitioners. বলে থাকো। Thank you very much.
My lord, grateful, my
Thank
lord.
you. Yes.
Deeply observed.
Next. অ্যাপিলটাই মোটামুটি হিয়ারিং হয়ে গেল, রিটেন নোটস নিয়ে নিলে মোটামুটি অ্যাপিলটা হয়ে যাবে। হ্যাঁ, if it is আগেরটা affidavit service file to be kept on record করুন।
Lordship, before the matter will argued,
Yes,
I have been appointed by the legal aid committee, by the for
When?
de facto, today, just 5 minutes back.
tomorrow we'll take up.
Tomorrow, kindly, and I request Mr. Chaudhary to service a copy.
I'll sir.
Now he's doctor, so say doctor, otherwise we won't grant to time. What is your surname? We forgot.
Sheikh Shortcut.
Sarkar. Mr. Abhishek Sarkar, comma, having instruction to appear on behalf of the de facto complainant, comma, being engaged by the legal aid defense counsel, comma, seeks a day's adjournment to apprise himself of the facts of the case. So accordingly, the learned advocate for the petitioner is requested to furnish a copy of the application to Mr. Sarkar during the course of the day. So the matter is adjourned till tomorrow.
I'm for the appellant.
Yes.
This is application for suspension of sentence, my lord,
Right.
arising out of an conviction from section 6 of the POCSO Act. My lord, at the outset, I would submit, my lord, that there is a delay of 6 months, my lord, in registering the FIR itself.
Why so much? Registering FIR.
Registering the FIR. From the date of offense till the date of registration of FIR, 6 months delay.
Can you give us the age of the?
My lord, age is 17 years. 17 years, 3 months at the time of commission of offense.
Your age or her age?
No, age of the victim girl. My lord, I was 65 years old during that time. Now, my lord, I'll come to that, my lord. What is the clinching evidence against me, my lord, is the DNA report. Now, my lord, I take your lordship to certain timelines. My lord, the DNA sample was collected on, my lord, 22nd of March 2021. My lord, of the baby. My lord, of the baby. My lord, my DNA was collected on 24th of March 2021. And my lord, it was sent to CFSL Bhopal on 30th of June 2021. So, my lord, almost after 3 months, my lord, the samples collected from me had been sent to the CFSL lab. My lord, the CFSL lab sends it next year, my lord, 2022. Now, my lord, from the time of collection of the samples from me, and my lord, sending it to the lab, so my lord, there is a delay of almost 90 days, more than 90 days, my lord. And my lord, there is no explanation with respect to the chain of custody or keeping the DNA samples, my lord, in the police malkhana or wherever, my lord, we do not know, my lord, for a period of 90 days. My lord, I'm covered by a judgment passed by a coordinate bench of this court, my lord, that the since DNA
Copy ta diyo.
Since, my lord, DNA reported judgment. Since DNA samples,
Give the citation at least.
Yes. Citation হচ্ছে 2024 SCC online Cal 1034. Now, my lord, exactly identical facts, my lord, which I am citing.
That was the section 6 case.
Yes, my lord. Para 4. From para 4 onwards.
Yes.
But however, we are of the opinion that there are several circumstances which prima facie vitiate the conviction. First, the victim was about 16 years of age at the relevant point of time and not of such a tender age so as to unable to disclose her predicament to her near and dear ones for a period of 7.5 months. The delay of 7.5 months in lodging the complaint and registering
The complaint was lodged after the pregnancy was detected.
Yes, 6 months. Here 6 months. The delay of 7.5 months in the lodging the complaint and registering the FIR itself might turn out to be a fatal to the prosecution case. More importantly, as rightly contended by the appellant, the DNA sample was collected on September 24, 2021 and sent to the laboratory on November 1, 2021. And such inordinate delay of 38 days, particularly keeping in view the sensitivity and nature of such sample, as specifically reiterated by the Supreme Court in the cited judgment, can also be crucial in raising a presumption of the sample having been mixed up or contaminated in the said process. My lord, next, thirdly, the scientific officer who authored the report and conducted the examination was never produced as witness. As such, not only the DNA report was
Scientific officer was
not produced. As such, not only was DNA report was not
Bhopal person could not be brought probably.
My lord,
Bhopal person could not be
he
brought.
was not called on him, my lord. So the my lord, exactly identical facts, my lord, in the facts of the present case. So, my lord, I am
quoted a Supreme Court judgment also.
My lord, yes.
Rahul versus yes. That the italics shows that.
Yes, my lord.
We relied on that on this point.
My lord, the relevant paragraph in Rahul is para 38.
Citation টা দাও, রাহুল versus State of Delhi 2000
This is 2023 1 SCC 83. 2023 1 SCC 83.
My lord, para
For you,
38,
yes.
page 26.
Yes.
My lord, it is true that PW 23 Dr. B.K. Mohapatra, Senior Scientific Officer, Biology of CFSL, New Delhi, had stepped into the witness box and his report regarding the DNA profiling was exhibited as Exhibit PW so and so. However, mere exhibiting a document would not prove its contents. The record shows that all the samples relating to the accused and relating to the deceased were seized by the investigating officer on 14/2/2012 and 16/2/2012, and they were sent to CFSL for examination on 27/2/2012, well, after 11 days. During this period, they remained in the Malkhana of the police station. Under the circumstances, the possibility of tampering with the samples collected also could not be ruled out. Neither the trial court nor the High Court has examined the underlying basis of the findings in the DNA reports, nor have they examined the fact whether the techniques were reliably applied by the expert. In the absence of such evidence on record, all the reports with regard to the DNA profiling become highly vulnerable, more particularly when the collection and sealing of the samples sent for examination were also not free from suspicion.
Let us hear them. Yes.
Lordship, Dr. Chaudhary has argued at length, but the important point regarding he has raised the point of chain of custody and another point which he has raised, that is the scientific expert was not examined.
And late sending also.
Late sending. At first, I am coming to the point of the scientific expert has not been examined. Section 293 of Criminal Procedure Code is very much clear that if the report of the any expert report regarding any scientific test, whether it may be DNA or any other, in such cases the report is automatically admissible unless and until the court may summon its expert if it thinks fit, or this is the pertinent point, or if the accused demands cross-examination, the expert must be summoned. In this case, at the time of trial, this is now they are raising the point after the conviction, and during the prayer for suspension of sentence, that the expert was not examined. But at that time, the liberty of the accused to cross-examine, that prayer was not tendered before the trial court. This is the first pertinent point. And second point, if regarding the report, if they have any objection regarding the chain of custody, if they had any objection, in that case, when it was the MAT exhibit was done, at that time the objection should be raised. In that case, it would be marked, but not it would be exhibited.
This is not an admissibility objection. This is an evidentiary value objection.
Yes.
The weight of evidence.
Weight of evidence. But at that time,
yes, expert not proving it relates to admissibility. You have a point there. Read with section 293.
293, and it is very, very clear.
But this para 38 of this judgment says, and even otherwise, 90 days delay in sending the sample, not merely clean of custody.
That should be considered at the time of appeal hearing. This is a question of suspension of sentence, and this is not a case.
Time officially, we also have to consider whether they have a chance of acquittal.
Lordship is very prudent. Lordship knows that Lordship is not holding the mini appeal.
No, not that. Definitely not that. That's well settled. But 6 months after registration of FIR, 17-year-old girl, not naive baby, child, otherwise shame. 6 months after detection of pregnancy, maybe to cover up something else. I mean, we are not alleging anybody. She's the victim, after all.
You know what?
Either way, she's the victim. But
if you contact the scientist who gone through the DNA report, have no enmity with the present petitioner. No inimical relation.
no, not there. Before it went, because Supreme Court judgment says we cannot rule out tampering when it was in the police malkhana. They did not tamper. You tampered.
The chain is considered. Basis of the sentence which is imposed, not only on the basis of DNA, also on the basis of the deposition by the witnesses. And Lordship, entire evidences has to be considered regarding the suspension of sentence. The deposition of the victim and other prosecution witness hugely and categorically corroborated the incident.
How did you explain the delay of 6 months in registration of the FIR, rather?
Lordship, in our society, there is often the parents of the girls or the girl herself feels insecure, insecure, and there is a scope that they should get defamed. So this type of delay often occurs. And the delay in lodging affair, obviously, I admit, that cast cloud on the veracity of the prosecution case unless and until it is duly explained.
6 months after, when pregnancy reached, at least it was must have been detected earlier, because she must have missed whatever she had to prior to that. We need not wait for 6 months. So there were indications that there is pregnancy. Why was it lodged after 6 months? It could have lodged after that, and maybe to cover up someone else, or to avoid shame. Rather, it's the other way around. To avoid shame, registration of FIR was done. Might be, maybe may not be, but beyond reasonable doubt, question comes up.
That is not sure at the time.
You are in custody for how long?
5 years, 5 months. my lord.
The sentence is of
20 years.
20.
But now, my lord, I am almost 71 years.
Not even past the half of the sentence.
But past almost more than three-fourths of his life. 71. Let him live some time of his life outside. If we affirm in appeal, then he comes back. We'll give an invitation and he'll call him back. Learned counsel, de facto complaint. Learned counsel for the petitioner, heard learned counsel for the petitioner, the de facto complainant, and the state. Full stop. Learned counsel for the de facto complainant and the state vehemently oppose the prayer for bail. So, learned counsel for the petitioner submits that there are several mitigating circumstances which create an anticipation of the appellant being acquitted upon hearing of the appeal. So, first, the complaint was made and FIR was registered about 6 months after the alleged offense. The victim girl was about 17 years, 3 months of age at the relevant point of time, and as such, it cannot be said that she was so naive that she could not have brought the complaint to light earlier. Next para. Secondly, the DNA sample of the baby, which was the result of the allegedly the result of the offense, was taken on March 22, 2021, whereas the DNA sample of the appellant stroke petitioner was taken on March 24, 2021. However, those were sent to the CFSL Bhopal after more than 90 days on June 30, 2021. Those were returned by the laboratory the next year, that is in the year 2022. Next para. Learned counsel contends, by placing reliance on a coordinate bench judgment of this court in the matter of Muskan Tamang, that in similar circumstances, the benefit of bail had been granted, taking into consideration the huge delay in lodging the complaint and the age of the victim, as well as the fact that the scientific officer who authored the medical report, the forensic report, was never produced as witness. Also, the inordinate delay in sending the sample for a chemical examination, keeping in view the sensitivity and nature of such sample, was taken into account. The when was it sent to Calcutta? We'll continue, just give us the date in the minute. The division bench, in the said judgment, had relied on Rahul versus State of Delhi, Ministry of Home Affairs, and another, reported at 2023 1 SCC 83, which is also relied on by learned counsel for the appellant stroke petitioner, where the Honorable Supreme Court, inter alia, had held that the record showed that all the samples relating to the accused and relating investigating officer on February 14 and February 16, 2012, and they were sent to CFSL for examination on February 27, 2012. Full stop. During this period, they remained in the Malkhana of the police station, and under the circumstances, the possibility of tampering with the samples collected also could not be ruled out. Full stop. Next para, since neither the trial court nor the high court had examined the underlying basis of the findings in the DNA reports, nor had they examined the fact whether the techniques were reliably applied by the expert, in the absence of such evidence on record, it was held that all the reports with regard to the DNA profiling became highly vulnerable, more particularly when the collection and sealing of the samples sent for examination were also not free from suspicion. Full Learned Counsel argues that in the said case, even a fortnight's delay in sending the samples was taken to be a mitigating circumstance, whereas in the present case, the samples were sent more than 90 days after. For some next para, Learned Counsel appearing for the state opposes the prayer for bail and contends that Section 293 CRPC does not cast any obligation for an expert to prove his own report. An expert report, under the said provision, automatically becomes admissible in evidence. Full stop. Next para. The fact would be otherwise if the accused demanded to cross-examine the expert, which was not done, nor any objection taken during trial in that regard. Full stop. Also, the chain of custody was never challenged at the relevant juncture before the trial court. Full stop. Learned Counsel for the state submits that before being sent to Bhopal, the sample had been sent to a laboratory at Calcutta. Full stop. Next para. Uh, Upon considering the rival contentions of the parties, we find several mitigating circumstances in the present case, which present a fair chance of acquittal in the appeal for the appellant. First, the delay of about 6 months, only after detection of the pregnancy, in lodging the complaint raises a doubt as to whether the said detection was the instigator in filing the complaint rather than the offense itself. Full stop. Next para. That apart, the huge delay in the sample being ultimately sent to the laboratory which conducted the forensic analysis, the chemical analysis of the sample is a factor which cannot be ruled out. Full stop. Even if the sample was previously sent to Calcutta and thereafter to Bhopal, fact remains that they were tested much after the collection of the same. Full stop. The chain of custody in the meantime is not clear from the evidence, and borrowing the principle laid down.
One in Najan.
Yes.
On PW 17.
One second. Let's complete the sentence. Borrowing the principle from Rahul versus State of Delhi Supra, the sample being sent much later than collection, during which they remained in the custody of the police, of the investigating agency stroke police, casts sufficient doubt on the sample and regarding the reliability of the techniques which were applied by the expert. Yes, please. Yes, what is your?
Yes, Lordship, on perusal of evidence of PW 17, it appears that it was sent to blood sample was sent to CFSL Kolkata for their valued opinion, but CFS Kolkata has returned the blood sample as because they were overburdened.
We have taken that into consideration because ultimately they were examined by the Bhopal.
Blood sample to CFS.
Next para, we also take into consideration the fact that the petitioner is now a septuagenarian and he is already 5 years in custody. Full stop. We are not confident as to how soon the appeal can be disposed of, keeping in view the burden otherwise prevalent before this circuit regarding hearing of appeals. Full stop. In view of all the above considerations, we are of the opinion that the benefit of bail ought to be granted to the petitioner. Accordingly, CRAN such and such is CRAN 1 of 2025 is allowed, thereby granting bail to the petitioner on condition that he furnishes bond of rupees 10,000 with 2 sureties of like amount each, one of whom must be local, and shall not leave the to the satisfaction of the Special Court POCSO Act, Darjeeling. Full stop. The petitioner shall not leave the territorial jurisdiction of the local police station during the pendency of the appeal and shall not attempt to intimidate or induce and or contact in any manner or approach the victim or her family and or the witnesses of the case during the pendency of the appeal. Full stop. The appellant uh, shall, comma, if so called upon to do so by this court, comma, present himself before this court, and for such limited purpose, comma, the restraint as to his leaving his jurisdiction shall be relaxed. Anything else? No. Thank you.
Cran 2, my lord, not cran 1.
Oh, can 2, sir. Can 2. Can 1, section 5?
Condemnation.
Disposed.
Can 2. Thank you.
Much obliged.
Thank you.
Grateful to you.
The matter was returnable today, my lord. It's a date
Ajay,
reference
today's
matter.
second half we will be taking up single bench. We have already sent a notice to the bar. Single bench, you have sent a notice to the bar. Tomorrow we'll sit again, division bench. Yes.
Oh, my lord, it is a date reference matter, my lord. It was returnable today. Now, another accused person who has filed an
We
application
will be able to take up one single mode death reference.
was taken yesterday, my lord. But the returnable date on my matter was today. But it was taken yesterday with the another matter clubbed together. This is the order, my lord. Now, since my appearance has not been recorded in the second matter, my lord, CRA DB 42.
একটা কি অন্যদিনের রিটার্নেবল ডেট ছিল?
Now, I have an application.
Now those are tagged automatically.
Yes, my lord. And the CAN application is for the bail matter, my lord. The bail application.
You have already heard out the death reference itself and the appeals.
Yes, my lord. But since the liberty was given to file the bail application, and already my application is
That has become infructuous since you have heard the death reference and the appeals.
only the admission has been done, my
Oh,
lord.
admission was done.
Yes, my.
So what do you expect us to do?
The CAN application, if it is listed, my lord, tomorrow.
কালকে দিয়ে দাও. Tomorrow it will be listed.
Item number 29, Matt, my lord. So, my lord, perhaps today it is not possible. Tomorrow, if it is, my lord.
Tomorrow also not possible.
Oh, then.
Applications will take up. All applications will take up.
Because I am leaving and also, my lord, tomorrow my another matter there.
Happy journey. Applications will be taking up, not hearing matters.
No, application.
Applications, if we can reach, will take up tomorrow also.
If, my lord,
Ask for time.
Yes.
That is the usual practice.
Kindly. But generally, I do not need time.
No, make an exception.
Kindly accommodate, my lord. Then.
appeal, motorcycle appeal was taken up for hearing. Subsequently, Resources Company came and one fixed on Monday and another fixed on yesterday. Both the matters running in the list. Can it be fixed tomorrow specially?
No special
Very,
fixation.
very short issues.
No, you'll have another circuit too after a week. So if I can't reach, then they'll. No, sir. Yes.
Lordship, yesterday I was trying to mention this matter. The grave urgency is that the 6th of August is the.
What
next-
is it?
There's a civil revision matter for transfer of the matrimonial suit.
Did I not permit?
Yes, Lordship.
Hand it. Yes.
Great, great.
Call him, please.
Item number 1, my lord, I was also of this.
Oh,
It was a matter before the
division, yes. By your order date, by my order dated, now by the order dated July 30, 2025, comma, an order was passed in connection with the appeal, full stop. However, comma, it was later pointed out that the matter pertains to a first appeal, which is to be taken by a division bench, full stop. Accordingly, the order dated July 30, 2025 is recalled and the matter be placed before the division bench tomorrow. We'll pass the same order, but tomorrow. Yes, thank you. This remains, the order remains on record so that we can. Yes. Yes.
And last order, passed on 1st July 2025.
Well, the interim order of stay is, what about service?
I have served Lordship, but Lordship, there is a difficulty.
What?
As per the order, Lordship, the entire amount would be 91,22,154, Lordship. I have kept the check, the department has set the check of 90,90,000 because earlier registry accept the check deducting the statutory deposit, Lordship. But this time registry is not accepting deducting the 25,000, Lordship. So that, Lordship, I need some time because my check is ready, Lordship. Kindly see.
No, no, then we cannot extend the interim order if you have not complied with the preconditions.
Because the rules changed, because earlier in my case.
How soon can you do that?
Lordship, it has to, I have to send back to the department.
Then the appeal is not maintainable in the eye of law without that prerequisite.
Lordship, statutory deposit already paid, Lordship, 25,000.
But
the stay amount 90 lakhs, 91 lakhs total as a awarded amount. Kindly see the order, subject to the petition, deposit the entire award.
oh, yes.
Yes,
So that has not been done.
Lordship, earlier we used to pay inclusive of the excluding the 25,000 award statutory deposit. Now registry is saying no, we have to pay entire amount.
So you can pay that. How soon can you do that? How soon?
Weeks, Lordship. At least 4 weeks, Lordship, because I have.
And
to
what
send-
about service? You are directed to serve also.
Lordship.
Affidavit of service. Bring it tomorrow, urgent for the day. Since no affidavit of service is ready, comma, let the matter stand urgent for the day. Come prepared with that, I will consider this other submission of yours. Yes, Mr. Ghosh. Oh, you serve afresh. Learned counsel for the petitioner, appellants points out that the service has not yet been completed. Full stop. Accordingly, the petitioner, the appellants stroke petitioners are directed to serve afresh and file a further, you are filing an affidavit of service today and file a composite affidavit of service on the returnable date. Full stop. Let the matter stand adjourned till the next circuit.
Can you keep it password because the interim order is expiring today, Lordship.
Only 1 day will extend.
But I have this affidavit service with my chamber, Lordship. If your
You have it affirmed?
Yes.
Item 2 তে যে অর্ডারটা পাস করলাম রেকর্ড করো না ওটা ভেরি ওয়েল পাস ওভার
Kindly have a look at Millard's last order.
no service affected.
No, Millard, service has been affected. Mr. Bapi Sarkar appeared also.
Oh.
Millard, he indicated that Millard, one of the defendants have passed away. Millard, the
No, on all the rest, the other respondents have not.
He is representing every one of them.
1, 3, 4 and 5, 2 is not there. He has given his slip for 1, 3, 4 and 6, 5. That is a difficulty. There are others. Yes, 6, 7, 2. He,
Millard,
no, let us just.
serve afresh upon them. Millard, kindly takes the.
No, 6 we can understand what 6 is pro forma. 6 with, just ascertain from him whether, because on the still prior occasion, he had, his name had been recorded for all the respondents.
Yes.
But
Yeah, the whole-
can you please ascertain from him? We are passing it over.
Great.
Wait. A matter is going on, Ms. Singh. Please. Yes. Yes, Mr. Ghosh.
Passed over for the timing.
We are just passing it over. Passing it over. Kono order record kono pass. If Mr. Sarkar comes and clarifies, then we can just dispose of the section 5. Yes. Yes, Ms. Singh. Dakho, 2. Service has been affected.
No.
No.
but it not- I have to return the check before the company lordship and fresh check.
25,000 less.
Less.
And affidavit of service you have to file. That was the direction. Learned counsel for the petition. No, even then, if there is a direction, we will grant you. You are appearing for both. It's, learned counsel for the petitioner seeks some time to file affidavit of service. Full stop. Accordingly, leave is granted to the appellant to file affidavit of service during the course of the day. Full stop. In any event, since the respondents are represented through learned counsel, comma, the matter is taken up for consideration. Full stop. Next para. Learned counsel for the appellant seeks an extension of the interim order. Full stop. It transpires from the order dated July 1, 2025 that the order of stay was granted subject to the petitioner depositing the entire awarded amount before the learned registrar, comma, circuit bench of this court. Full stop. Next para. However, comma, it is submitted by learned counsel for the petitioner that the previous practice was to deduct the statutory deposit from the awarded amount. Full stop. When such amount was sought to be deposited, comma, the petitioner was intimated by the registrar that at present, comma, the entire awarded amount is being is to be deposited in terms of the order of the court. Full stop. It is submitted that the petitioner is ready with the check by after deducting the statutory amount. Full stop. However, comma, at least 4 weeks time will be taken to furnish a further check of the entire awarded amount. Full stop. Accordingly, the time for depositing the entire awarded amount is extended for 4 weeks from date. Full stop. The interim order is extended till September 15, 2025 or until further order, whichever is earlier. Liberty to the parties to mention the matter, mention the application for inclusion in the list before the next circuit. Yes. Let them deposit first, then we'll consider. But file that affidavit of service with, yes. দীপঙ্কর ওই আগেরটা উনি দিলে এফিডেভিট অফ সার্ভিসে ঠিক ফাইলে ঢুকিও উনি এফিডেভিট অফ সার্ভিসটা 2 তে দিলে ঠিক ফাইলে ইয়েস হোয়াট ইজ দ্য ম্যাটার
This is the matter, Millard, where we have challenged, Millard, an order of the DRT. If Millard kindly recalls, Millard, it was taken up yesterday, day before yesterday. Millard, we were only aggrieved by one observation of the DRT, wherein, Millard, we have been restrained
yes
from alienating any other property
right
in addition to the mortgage property. We are only, Millard, seeking, Millard,
Mr. Sharma was appearing
someone was appearing.
Mr. Mukesh Sharma appearing
Yes,
for the
someone was appearing. That he was trying to rely upon some of the provisions of the probably 1993 Act.
yes
Millard, if Millard kindly takes the original application, Millard, even in the schedule to that property, Millard, only one property is mentioned, Millard, which is the mortgage property.
let us see that
Yes, Millard, kindly, if Millard kindly comes to Millard, page 20, page 31, which is, Millard, the schedule to the original application. Millard would take-
description of the stocks, all these are covered by
Stocks is, Millard, we are not on that, Millard. Details of the mortgage property of the.
all right
Millard would kindly find, Millard, 27.5 decimal. So and so the description.
what was the provision which he was yes this covers the only
Yes,
the
yes. In
security
Name of defendant being title deed number so and so. So save and accept the property described in the
Nothing.
title deed. No other order.
do you have a copy of the act, Mr. Ghosh? What is 19(3)(a), that affidavit?
The properties has to be disclosed. Until and unless it is disclosed, Millard. Every applicant in the application filed under subsection 1 or subsection 2 of recovery of debt shall state the particulars of debts secured by security of interest.
B is also there, small b.
If the estimated
State
value
particulars of any other
securities,
properties.
yes, is not sufficient to satisfy the debt claim, state particulars of any other properties or
So you say there
assets.
could not be any blanket.
There cannot
or-
be any blanket. Now, beloved, because prior to this, they have initiated a SARFAESI action. In that, they have sold that property by on the strength of a section 14 order. The auction, thereafter they sold it, the money was received from the auction purchaser.
The same property.
Same property from the auction purchaser. The surplus was deposited to my account. They had procured, but they have obtained money in surplus to the debt amount. Now, after that, since physical possession could not be delivered due to certain encroachments or whatever there, the property, the amount was returned to the auction purchaser. And then they initiated this OA afresh.
Amount was returned by them to the auction purchaser.
Auction purchaser and
The balance was not taken back from.
balance was returned to me. So which shows that the amount which was secured from the property was in surplus to the debt. Let's split it in my pleadings, but I can show the document.
In view of the nature of the challenge in the present application under Article 227 of the Constitution of India, comma, learned counsel for the petitioner argues that there has been gross transgression of the jurisdiction of the tribunal which justifies the interference of this court in judicial review despite the availability of an alternative remedy in the form of a challenge before the appropriate appellate tribunal. Full stop. Next para, learned counsel submits that the petitioner is aggrieved only with clause small 4 of the impugned order, whereby the defendant stroke petitioner has been debarred from transferring, alienating, encumbering or disposing of not only the hypothecated stroke mortgage properties, but any other proper double inverted mode, any other property and assets belonging to the defendant, double inverted clause, till the aforesaid adjudicated debt amount is recovered from the defendant. For the next para, learned counsel submits that in terms of section 19 within bracket 3 capital A bracket closed of the Recovery of Debts and Bankruptcy Act, 1993, the every applicant in an application has to disclose not only the particulars of the debt and the security interest, but also the estimated value of securities if not sufficient to satisfy the debt claimed, the particulars of any other properties or assets owned by any of the defendants, if any. Full stop. Next para. Clause small c of subsection 3 capital A also provides that every applicant shall, if the estimated value of such other assets is not sufficient to recover the debt, seek an order directing the defendant to disclose to the tribunal particulars of other properties or assets owned by the defendants. Full stop. Next para. Thus, upon hearing learned counsel for the petitioner, it transpires that the provisions of section 9 within bracket 3 capital A of the 1993 Act provides a specific scheme under which assets beyond the security, the secured properties can be subject to an order by the tribunal in a proceeding under the said Act. Full stop. In the absence of any clear disclosure under clause small b within bracket of subsection 3 capital A of section 9 and or any order being sought under clause small c thereof, any and every asset belonging to the defendant cannot be the subject of a restraint order. Full stop. Next para. In the present case, by relying on the original application before the tribunal, it has been established before this court that Schedule B of the same contained the details of the mortgage property. Full stop. It is submitted by the petitioner that the said mortgage property was already sold to
101 once. Sorry for the interruption, Millard. Just I would like your lordship to refer to that document once. 101, page 101. Why Millard B and C will not come into the picture? I'm sorry, Millard, page 87, Millard. So double pagination, Millard. 101 ही होगा ना, Millard 101. It's a communication dated 6 December 2030.
Yes.
Yes, my lord, would kindly see sale proceeds amount appropriated towards loan account so and so, entitled to receive balance amount so and so. Addressed to me.
কোনখানটা ছাড়লাম?
So the D and C will not at all come into the picture.
Sold to an auction purchaser. বলিস। Has already been sold to an auction purchaser and the sale proceeds then and out of the sale proceeds, comma, a balance amount was returned to the present petitioner after satisfying the debt. Full stop. Learned counsel relies on page 101 of the annexures to the present application, which is a copy of a communication by the opposite party bank dated December 6, 2013 to the petitioner, wherefrom it is disclosed that after appropriating the sale proceeds towards the loan account, comma, the balance amount was returned to the petitioner. Full stop. Next para. Thus, comma, it is, although the petitioner submits that subsequently, due to certain difficulties in taking possession of the asset, comma, the sale proceeds were the sale proceeds appropriated by the bank were returned to the auction purchaser, comma. At the same time, comma, it is clear from the communication dated December 6, 2013, that the loan that the amount covered by the loan was already appropriated from such sale, comma, leaving a surplus amount which was returned to the petitioner. Full stop. Thus, comma, there could not have been any occasion for section 9 within bracket 3 capital A of the 1993 Act to have come into play, comma, as there was complete satisfaction of the debt. Full stop. Next para. In any event, comma, in the original application, comma, the bank did not disclose any other property than the secured property. Full stop. Thus, comma, it is apparent prima facie that the learned tribunal acted beyond, palpably beyond jurisdiction in assuming jurisdiction over all other properties and assets belonging to the defendant, despite the surplus amount having been, despite the entire loan amount having been appropriated from the sale of the secured property and the balance amount having, comma, being surplus, comma, having been returned to the petitioner, comma, which indicates that there is no scope of passing any order in connection with any other properties or assets than the secured property. Full stop. Next para. Thus, comma, the portion of the order, impugned order, whereby the other property and assets belonging to the defendant were injuncted is ex facie beyond jurisdiction, full stop, in view of such palpable jurisdictional error, comma, at least on a prima facie footing, comma, sufficient case for interference of the court under its power of judicial review within the contemplation of Article 227 of the Constitution has been made out, despite the availability of an alternative remedy. Push up. Next para. Since the opposite party bank has already entered appearance through its learned advocate, comma, but is not represented today, comma, this court chooses to give another opportunity to the bank to contest the revisional application, full stop, be that as it may, comma, in view of a strong prima facie case having been made out, comma, the impugned order being
10th January 2020.
Impugned order dated, impugned judgment and order dated January 10, 2024, comma, to the extent that the defendant petitioner has been debarred from transferring, comma, alienating, comma, encumbering or disposing of any other property and assets belonging to the defendant stroke petitioner than the hypothecated stroke mortgage properties is stayed till disposal of the application. Full stop. The matter shall be listed for contested hearing before the next circuit.
This is your lordship, the section has been recorded as 9, it should be 19.
Oh,
19th.
yes, yes. দু তিন জায়গায় 9 বলেছি, 19 হবে. Thank you.
Grateful.
You can take back this photocopy. You
Yeah,
can use it again when it's finally held. Thank you. Yes. ঠিক আছে, ঢুকিয়ে দেবেন ঠিক জায়গায়। Thank you. Yes. You're for the opposite party.
Well, I am for the petitioner.
You don't have locus standi to appear for petitioners.
Well, my locus standi may be fees for everything. I will be very happy.
No, what is the case?
My lord, on the answer, my lord, I am very sorry to tell your lordship that my junior has misplaced the brief.
Oh.
Kindly takes it up tomorrow's.
Very well,
One
yes.
prayer, my lord. Can it be written in the same position?
It by default it remains in the same position. Otherwise, we don't put in any. No. It's all right. Absolutely. Extension of interim order to be mentioned. These matters come above. On the prayer of the petitioners, the matter is adjourned for the day. Adjourned for the day. Please hand over copies to Mr. Mujumdar if he's.
I petition. I should be handing over copies.
If he has extra copy, just to help you out. You have to prepare yourself also. পড়ে যেও না। এটা তো ঠিক আছে। Yes, Mr. Chaudhary, Dr. Chaudhary. Yes.
I am for the petitioner. My lord has served, directed me to serve upon the state. My lord, I have done so. My lord, this is the affidavit of service.
Right. Where is he? What is the point in Dr. Chaudhary? Just remind.
My vehicle was confiscated by the forest authorities. And my lord, I say, my lord, that the confiscation proceedings was not in accordance with law. Why, my lord? Because confiscation of a vehicle in relation to a forest offense says, my lord, there has to be a forest offense first.
What is a forest offense?
My lord, anything, my lord, any offense.
Under the Forest Act. Yes. Here, what was for what offense you were?
My vehicle was allegedly apprehended with tea cloths. So they say, my lord, that those are illegal forest produce, my lord, illegally obtained, and my lord, I have committed a forest offense.
So isn't that a forest offense? Satisfies.
It have been a forest offense if there would have been a specific case, FIR, criminal case against me.
What has been lodged against you?
Nothing. No criminal.
But the allegation on which it has been confiscated, they have a power even before the FIR to confiscate at the time.
Satisfy your lordship.
But Dr. Chaudhary, that would be absurd because if, suppose you are going away, fleeing with the forest produce, and before the lodge an FIR, if they can't immediately apprehend you and stop.
Thereafter, they may lodge a complaint.
Yes.
In the case, there was no complaint at all.
When was it confiscated?
Lord, Lord, confiscation was passed on 2023.
23?
Yes.
No FIR till date?
No FIR.
Then you're gone.
No FIR. Lord, I will satisfy your lordship. Lord, I am
I'm already satisfied. If no FIR till date, they have to release the vehicle.
My lord. One aspect. Second aspect, in the confiscation proceedings, my lord, the witnesses, my lord, the forest department officials who had apprehended my vehicle, my lord, they were, my lord, they have deposed as a witness in the confiscation proceedings. My lord, I was called, my lord, my statement was taken on a piece of paper, my lord, and that has been considered. But, my lord, I did not, my lord, I was not given any opportunity to cross-examine the prosecution witnesses in the confiscation.
Did you ask for one?
My lord, I should not, my lord, that is part of the principle of natural justice that has to be given to me. If that has not.
Not given, what do you mean? No, I mean, no other date was fixed or something, like no opportunity.
I was asked to simply put my statement on oath on a piece of paper in the form of an affidavit.
No scope was given.
No. My lord, that statement was taken on record, that has been.
You must be armed with a judgment on that also.
Yes.
And what other point? What other point?
These are the two, my lord, main.
Yes, what is your answer to this? Oh, then let him cite the judgment first. You keep the judgment with you? Mr. Dr. Chaudhary, Dr. Chaudhary, you cite your judgments because he is also relying on judgments. Let us. Yes, what is the report? What does it say? Give the crux. Have you gone through? I doubt. So, give us the crux. What is the? You say in bold letters that the order is passed is legal, reasoned, and within jurisdiction. Let us do that. It shows the ingredients. Yes. 22. Achha, very good. So 28th of.
Only one part. 07880230. Number 50A 0128 and AS 01NC 267.
Yes.
First of all, Lordship, the FIR, the written complaint which they had lodged, that was on 8/6/2020, 26/2022. 26/2022.
Yes. FIR was registered on that.
Now, in the said FIR,
FIR.
FIR?
said written complaint.
Yes.
In the said written complaint, the complainant says that her her drugs were given to one Sahaji on for hire on behalf of Abhijit Das on 8/6/2022. 8/6/2022.
Not the complaint. The petitioner said that.
Yes.
8/6/22 for hire, on hire to someone else. Yes.
Bearing suspect dated 7/6/2022, issued by the Assistant Conservator of Forest, Dimapur Range, Dimapur Division in the name of consignor Jennifer Zimo Timber Transporter for transport of sawmill blocks 98 pieces of 18.776 cubic meter in vehicle bearing number such and such.
So they're carrying more than that.
Yes. And that apart, they were carrying more amount of ticks, and that was not hammered properly as per the. We did not bear any Bengal hammer impression. Yes. Lordship, in my report dated page number 4 is the detailed report, Lordship. Page number 4.
You have given a copy of the complaint also here?
Yes.
Or this is the proceeding under 59A3. Have you got a copy of the act, Dr. Chaudhary? Forest Act. Forest Act থাকা উচিত এখানে। North Bengal Forest Act থাকে। Yes, annexure. Page 4. Annexure I or annexure 4? Annexure 4, acha.
None of the 100 pieces of teak blocks had any government hammer impression, and that apart, the dimensions were not entirely matching with those mentioned in the transit pass.
Right.
This confirms that the presence of illegal teak blocks in the truck.
So you have filed a complaint on a forest offense. 59, huh? এটাই তো ফেরত দিতে অর্জুনকে। Yes.
59A1.
Let us come to
59A2.
Yes, 59. Let us see. So you have done this, complied with this. You have produced it before the Assistant Conservator of Forest, right? What about this cross-examination opportunity?
Hearing what notices were sent to the registered owner of the vehicle.
What is that?
Page number 27 of their PO application. He appeared for hearing on 25/7/22 and submitted his report written deposition. He also submitted the Wakalatnama notarized affidavit designating advocates Pawan Thapa and Rashmi Tamang as leaders in these cases. On 19/9/22 and 21/10/22, Rashmi Tamang attended the hearings on his behalf. And sufficient opportunity was given to the owner of the vehicle to present the case under section 59B of the Forest Act 1927 and the principles of natural justice, I think, adhered to.
All right. So what is the next step you have to do with these confiscated vehicles? What do they have to do under the law? So,
Now, in terms of section.
Mhm.
What should be section 69 of the Act?
Yes. '69, yes. Or belongs to government, that presumption comes. The vehicle, what happens to the vehicle? What happens to the vehicle?
They usually, sorry, after confiscation, they auction it.
Auction the vehicle also?
Yes. But so far, my lord, my instruction is concerned, it is not yet auction. It is still in their custody.
Yes, sir. Sorry, you are Mr. Ghosh. Sumit Kumar. Mr. Kumar, you have to add anything else? Ms. Sharkar, you are appearing for? Yes, Mr. Dr. Chaudhary, yes. What do you have to say on this?
Now, my lord, similarly, identical facts was before coordinate bench of this honorable court, but extensively considered, my lord, all the arguments.
Give a copy to them also so that they
Yes,
can
yes.
deal with it.
My lord, may come to para 15. Page 4, para 15.
Yes.
My lord, says, commission of a forest offence and imposition of punishment, therefore, is imperative as per section 55 of the said act. The same, that is section 55(2) of the said act, provides confiscation as an additional measure to any other punishment to be imposed in case of a proved offence. The observation of the court in the case of Abdul Wahab Supra is worth noting at this juncture. When the court has held that commission of an offence is one of the requisite ingredients for passing an order of confiscation, and an order of confiscation should not be passed automatically. Next, my lord. On the other hand, section 59A of the said act, as amended vide the West Bengal Amendment Act, has empowered the forest officer to confiscate in case of forest offence believed to have been committed. Therefore, it is not a conclusive proof of the forest offence having been committed, but belief of the officer regarding commission of such offence would be sufficient for him to pass an order of confiscation. It is noteworthy that the provisions under section 55 of the said act have not lost force with the coming into effect of the West Bengal Amendment to incorporate section 59A as mentioned above. The Honorable Apex Court in Sujit Kumar Rana's case Supra has held that indisputably, having regard to the phraseology used in subsection 2 of section 59A, there cannot be any doubt whatsoever that the commission of a forest offence is one of the requisite ingredients for passing an order of confiscation. Next, my lord, para 20 with respect to the that cross-examination part. Para 20, my lord. Next page.
You are represented by an advocate. You did not take this point. You are not permitted to cross-examine. Neither did you ask for any
My
cross-examination.
lord, that option was never there because I was.
Could have asked.
My lord, there is a concept, my lord, that if the cross-examination is done, my lord knows better than me. My lord, the person has to be there first. Second, my lord, what
You have
happens?
to ask for it.
My lord, what-
Cross-examination is not for the asking. I mean, somebody may not want to cross-examine. This is not a civil suit. So you had to ask for cross-examination. If you are not given opportunity, not being given opportunity, you are represented by an advocate. There is no reflection that you asked for cross-examination. And you may choose not to cross-examine. One may choose always in a civil suit even or in a criminal proceeding also not to cross-examine. I may choose. You did not exercise any option of cross-examine. You did not ask for it.
There are two limbs. If Millard takes that view, my lord,
And belief is the only thing which is German under 59.
no, my lord, no. My lord, because this court, my lord,
Gopal has been
distinguished. Gopal Sarkar was relied upon by the state. My lord, that was.
But that is the language of 59A with due respect to the learned judge. 59A is all about the belief.
Yes, but 59A does not, my lord, makes 55 obsolete.
Let us come to 55 once.
Yes. Lord, forest produce, tools, etc., when liable to confiscation. all timber or forest produce, which is not the property of the government and in respect of which a forest offence has been committed, and all tools, boats, carts, and cattle used in committing any forest offence shall be liable to confiscation. Such confiscation may be in addition to any other punishment prescribed for such offence. So, my lord, the basic requirement is, my lord, registering a case for commission of forest offence. Because the person who is committing the forest offence, he should be, my lord, dealt with first in accordance with the law. My lord, deprivation of the property, my lord, is an additional punishment given with my lord, subsequent to the main punishment. So, my lord, the person who is committing the offence, my lord, he is not apprehended, no case is registered against him, nothing. Only, my lord, the property is, my lord, seized, and, my lord, the forest department is only dealing with the property. So, my lord, my right to property, my lord, that is a constitutional right, my lord, cannot be, my lord, dealt with in this manner, my lord, the way it has been done. My lord, I have only relied upon the coordinate bench judgment because that considers, my lord, all the Supreme Court judgments in this regard. My lord, Sujit Kumar, Rana, Abdul Wahab, everything, my lord, was considered, and thereafter, my lord, this judgment was passed. My lord, state relied upon Gopal Sarkar. Gopal Sarkar was distinguished.
Sujit Kumar Rana's case, the court holds that there cannot be any doubt that commission of a forest offence is one of the requisite ingredients,
Yes,
definitely.
yes.
But then we have to obliterate 59A from the statute book. Confiscation was proper. You may say retention of the vehicle was after that. I mean, we have to go into a territory which is not there in the statute.
So,
That is a
the
difficult.
basic, what I am trying to, my lord, point out, the basic thing is commission of forest offence. Now, my lord, how will you understand there is a forest offence? Somebody have committed the forest offence, so he has to be apprehended.
You may have a point if you say that even after 2 years, if they have not taken any steps for
Yes.
in furtherance of the
Yes.
of the complaint,
Yes.
then some doubt may be cast. But
That
at the point of confiscation, it will be absurd if you interpret that they cannot confiscate your vehicle, which is loaded with the forest offending timbers.
My lord, that is what they say. My lord, they
That
have
is the
to-
belief,
my
that
lord,
is the
they
only
did-
thing.
They did not file. My lord, that has to come on record somehow. If some, my lord,
That is what we are saying. Their subsequent action may invalidate their previous. But at the point when it was confiscated, that was only
my
59A.
lord, it
had
was
to-
my lord, how it happens. My lord, first forest vehicles are apprehended.
Yes.
It is taken by the range officer, beat officer, whoever. My lord, thereafter that is reported to the senior officer, that is the authorized officer. My lord, my lord, generally the DFO of the division is the authorized officer. My lord, is reported to the DFO. Then the DFO issues a notice to the owner of the vehicle saying that
Yes.
I am initiating a confiscation proceedings. I am calling you, come on so and so date and give your evidence. And thereafter, my lord, it is considered the prosecution witness, my lord, the forest department officials are examined, the owner of the vehicle is examined, and thereafter a order of confiscation or not to confiscate is passed. My lord, this is how.
Please come to 59A3.
My lord.
59A subsection 3.
My lord.
Now, this stage has reached in your case, wherein timber or forest produce, which is the property of the state, is produced before an authorized officer.
Lordship.
Under subsection 1, and the author is satisfied. You are given a hearing, he was satisfied that a forest offence has been committed in respect of such property. He may, whether or not a prosecution is instituted for the commission of such offence, order confiscation. So, this is irrespective and independent of section 55. And section 55 has to be read circumscribed by this.
My lord, the thing
So,
is,
irrespective of, because yes, 55 says a forest offence has been committed, read in conjunction with this, that can be held by the authorized officer himself. And he has given you a hearing, come to that observation, come to that finding. So therefore, I mean, that stage has gone. I mean, there is a satisfaction recorded.
my lord, this question was already raised before the coordinate bench. The coordinate bench has negated the argument, and this judgment was not carried in.
Coordinate bench, did the coordinate bench say that there had to be a prosecution before a criminal court?
Yes.
Where is that?
My lord, that was my argument.
Yes.
That was my argument, and the court held that. My lord, para 7, kindly take up.
No, what is the finding? Ultimate finding. Let us see.
Ultimate finding, vehicle was released, saying that these two infractions are there. No criminal case shows that there was no forest offence, and no cross-examination opportunity was given. So, my lord, taking into consideration these two infractions, my lord, the vehicles were released, and this judgment was not carried in appeal before the Supreme Court. Still holds the force. It was passed on 2nd of September 2024, almost a year back. But I have checked up in the Supreme Court website, my lord, there is no such case.
No, but it was set aside on the ground of lack of cross-examination only.
Yes, two points were there, my lord. Commission of forest offence and no cross-examination of the prosecution. Milord, same, Milord, I would say same authorized officer. That was also the
Okay.
same authorized officer. But I'm carrying all the Supreme Court judgments as well, but I did not want to trouble
Does
you.
any of the Supreme Court judgments dilute 59A? 59 is a West Bengal
No,
amendment.
That is not there. But Milord, Gopal Sarkar is on 59A. This is the Gopal Sarkar. Milord, how the court has yes.
This was the West Bengal Act which was being considered. There are several other statutes also. Yes, Gopal Sarkar, state of West Bengal, right? Has to be the West Bengal.
Gopal Sarkar was dealt with, Milord.
Is satisfied the person. Gopal Sarkar clearly holds the Supreme Court, Dr. Chaudhary.
Milord, how
The power of confiscation is independent of any proceeding of prosecution.
My lord. Now, Milord, the coordinate bench has dealt with Gopal Sarkar. Milord, kindly
I'll
come.
deal with the coordinate bench.
Milord, kindly come to para 17 once, Milord, kindly.
Yes, I'm there only. Para 17 is the only paragraph I'm looking into.
It
Let
says-
us read it. Yes, please read it. Let us
In
read
the
it.
judgment of Gopal Sarkar Supra, as relied on by the state respondent, the court has held that the power of confiscation is independent of any proceeding of the prosecution for the forest offence committed. That satisfaction of the forest officer regarding forest offence having been committed would not be dependent upon whether a criminal prosecution for commission of a forest offence has been lodged against the offender or not.
Clear.
The court reiterates, as was held earlier also, that confiscation proceeding is separate and distinct from that of the trial before the court of commission of an offence. In the same, however, the court had no occasion to deal with the provision under the Parent Act, but has only dealt with the West Bengal Amendment Act of 1988. Therefore, on the basis of the discussion as made above, the proposition of law as held therein may not be applicable in case of the present petition.
You convince the other court. Difficult to convince this court.
But kindly appreciate, Milord, fundamental questions, Milord, are there, Milord. The cross-examination point is also there. Same
Supreme
authorized
Court
officer,
judgment is-
Milord, may see same officer, Milord, doing the confiscation proceedings in a similar manner in all the matters, Milord.
The line of distinction of the Supreme Court judgment is that section 55 was not considered.
Yes. But that was actually not raised before the Supreme Court. Supreme Court was only dealing with 59A, West Bengal Amendment. So that was the point of, Milord, distinguishing the Gopal Sarkar's judge. Milord, this is very absurd, Milord, that they are alleging I have committed forest offence or someone using my vehicle has committed forest offence. But they have not taken any step, Milord, to apprehend that person, to prosecute that person in accordance with the forest act. Milord, only concerned with the vehicles. And Milord, Milord, what else should I say, Milord? The law says something, Milord, that has to be done in the way, Milord, the law says.
Law says clearly 59A4 is also law.
At the same time, law also says that the offender
55 does not deal with the apprehension at all, confiscation. It just deals, let us see, the capture of 55 is very clear. Forest produce when liable to confiscation. When all timber forest produce, which is not the property and irrespective of the forest office has been committed, shall be liable to this rather, although the caption is otherwise, this deals with what can be confiscated. See the tenor of this section, all timber such and such, which is not property and all tool, etc., shall be liable to confiscation. Such confiscation may be in addition to any other punishment prescribed for such offence. So this does not mean that confiscation will come after all the other punishments are exhausted. Does not say that. This is in addition to this, confiscation will happen. That apart, other punishment will also be given. So scheme of section 55 is not contrary to 59A. Rather, it supplements it. Because what 55 says is, these are the things which can be confiscated. And this confiscation will be in addition to prosecution. And 59A4 is precisely the same. It says that where the authorized officer confiscated, authorized officer is satisfied, irrespective. So read that irrespective of that 4, let us come to 4 once again. 59A4.
Yes.
What is that? Whether or not a prosecution is in 59.3 actually, 59.3. Whether or not a prosecution is instituted, that read with 55 gives a completely different interpretation that the learned court and the judge said. I mean, 55 read with 59A3 makes it very clear that confiscation is over and above prosecution. And 59A3 says precisely that whether or not prosecution is instituted, confiscation can be done. And 55 says this is over and above in addition to other punishment. So how does it mitigate 59A?
But well,
So we'll have to, I'll have to refer this to a larger bench and.
let us assume one situation, that this is a constitutional court. Now, my lord, kindly appreciate the situation. The Forest Act is a very stringent law. My lord, I admit that. Forest Act is for the conservation of the, my lord, environment, the forest, the ecological balance, everything has to be taken care of. Now, my lord, the Forest Act prescribes that if there is any offense, my lord, the offender has been brought to book. Now, my lord, why the Forest Department, my lord, without taking any step?
I can take note of your grievance and I can direct them to proceed with the criminal prosecution against you over and above this. I will take note of your grievance. That why did they did not do it? They should have done it. Dr. Chaudhary, you are absolutely right. We'll just direct them. We'll grant your prayer partially. We'll say confiscation remains, and they are directed to immediately ensure that a FIR is raised.
I raised this code, if you not do it.
NDPS case, same thing, confiscation power is there. And also in separate power is there to proceed with the criminal.
In addition, I mean, the interpretation with utmost, I have utmost respect for the coordinate bench.
Lord, then let it go before the.
It has to go, but you suffer in the meantime.
But that is.
That is the difficulty. That is what we are thinking. But we have to distinguish this. Dr. Chaudhary, with deepest respect, this is a. Whatever, I'll try to couch the language as soft as possible, but it has to be referred. In fact, this judgment does not.
But not carried in appeal also.
Right.
Now, it's
No,
almost
definitely
like
not. Basis of the
This
discussion.
one, 2024.
Also, Janet. Lord, one aspect,
Yes.
though, my lord, I have already completed. My lord, this petitioner, he is the owner of the vehicle. My lord, he is the owner. My lord, he lodged, he is a resident of Nagaland. My lord, on 20th of that month, effective on 20th, effective, on 20th of June 2022, my lord, he lodged a complaint before Dipufar police station, Nagaland, saying that his vehicle was given to so and so person, names are there in the FIR. But my lord, after 8th of June, my lord, he lost all contacts with those persons.
Yes. You have also lodged an independent complaint on that.
Yes.
So you proceed with that. I mean,
Was after 12. After 12 days, my lord.
after?
12 days. 12 days.
After this confiscation?
Yes.
No, not after confiscation.
Before
after
confiscation means,
Yes.
then it's, I mean,
On
not to
13th
cover up this.
Yes, no, my lord.
If it was before the confiscation, then yes, not to cover up.
After the seizure was made, after 12 days, this complaint was made.
7 days after seizure. 13th seizure was made, 20th the complaint was raised. And he says since 8th he is unable to trace the person or contact with the person who has taken.
Not before the seizure, my lord.
So that is annexed as page 23 of my application.
These are in 13. That is in 22. So, what is after the-
Now I'll differ with this and refer it to a larger bench. Learned counsel for the petitioner argues that the vehicle of the petitioner was confiscated under the Indian Forest Act 1927 on the allegation that it was carrying teak, in contravention of the provisions of the Indian Forest Act, which comprised of forest produce and came within the purview of a forest offence. Learned counsel submits that for a forest offense to be established, comma, there has to be a the registration of an FIR and a proper investigation before a criminal court. Full stop. In the present case, comma, in the absence of the same, comma, it could not be said that the vehicle of the petitioner was carrying product within the purview of a forest offense. Full stop. Learned counsel places reliance, comma, in support of such arguments, comma, on a coordinate bench coordinate bench judgment of Muhammad Rehan Alam versus State of West Bengal and others, reported at 2024 SCC Online Cal 8393. Full stop. In paragraph number 17 thereof, comma, the learned coordinate bench distinguished the principle laid down in State of West Bengal versus Gopal Sarkar, comma, reported at 2002 1 SCC 495, on the premise that the Supreme Court, comma, while passing the said judgment, comma, had only considered the provisions of Section 59 capital A of the 1927 Act, comma, which is a West Bengal amendment, comma, without taking into consideration the interplay between the said provision and Section 55 of the Parent Act. Full stop. On such premise, comma, the learned coordinate bench was pleased to observe, comma, inter alia, comma, that since there was since a forest offense had not been proved, comma, the confiscation itself was bad. Full stop. Learned counsel submits that the said judgment of the coordinate bench was never taken up in appeal. Full stop. It is further highlighted that Section 55 of the 1927 Act clearly provides that confiscation may be in addition to any other punishment prescribed for the offense, while reiterating that the confiscation can only be in respect of forest produce or tools, comma, boats, comma, etc., in respect of a forest, in respect of which a forest offense has been committed. Full stop. In the present case, comma, it is argued, comma, no FIR has yet been registered, comma, nor has any criminal trial taken place to establish whether any forest offense was committed, comma, despite the confiscation taking place in the year 2022. Full stop. Or 2023 or 2022? 2023. Full stop. Next para. Learned counsel next argues, comma, also relying on the judgment of Muhammad Rehan Alam Supra, comma, that since the petitioner was deprived of the opportunity to cross-examine either the complainant or any other witness of the case, comma, the very process of confiscation is vitiated. Full stop. Next para. Learned, you are appearing for the state. Learned AG appearing for the state hands over a bunch of documents. Have you given a copy to them? Yes, it has to be given to them. Give a copy, because in any event will be hands over a bunch of documents, including a complaint lodged with regard to the alleged forest offense committed, comma, in respect of which the vehicle of the petitioner was confiscated, comma, dated June 20, 2022. Push up. Next para. It is argued on behalf of the respondents that upon such confiscation, comma, due procedure was followed in adherence to the principles of natural justice, and confiscation of the forest produce and vehicle was lawfully ordered under Section 59 capital A within bracket 3 vide Office Order number 285 within bracket capital C bracket close stroke 15-5 dated April 28, 2023. Full stop. Next para. It is submitted that the owner stroke petitioner of the vehicle was represented by counsel during the hearing, and as such, comma, there was no violation of natural justice in any manner. Full stop. Next para, it is submitted by learned counsel for the petitioner in reply that uh, the petitioner herself had hired the had you had rented out the I mean that the petitioner's vehicle was hired by a third party, comma, prior to the sometime prior to the confiscation, and as such the petitioner had no involvement in the forest offense, comma, even if any. Push up. In fact, comma, the petitioner himself has lodged a complaint in that regard against such third party. Push up. Next para. Upon a careful consideration of the arguments of the parties, comma, the scope and interplay of Section 55 of the 1927 Act and Section 59 capital A of the said Act, comma, as amended in West Bengal, is to be looked into. Full stop. On a thorough reading of the two provisions conjointly, comma, this court does not find any contradiction between the same. Full stop. Rather, comma, the two sections complement each other. Full stop. Section 55, comma, although carrying the caption within double inverted forest hyphen produce, comma, tools, comma, etc., when liable to confiscation, comma, provides for the things, the articles which are liable to confiscation for their involvement in a forest offense. Subsection 1 of the said sections provides that all timber or forest produce which is not the property of government and in respect of which a forest offense has been committed, and all tools, comma, boats, comma, carts and cattle used in committing any forest offense shall be liable to confiscation. Full stop. Next para. Subsection 2 of Section 55 stipulates that such confiscation may be in addition to any other punishment prescribed for such offense, comma, thus clarifying that confiscation is not the only action which can be taken by the authorities in case a vehicle or other a vehicle is apprehended uh, uh, which is involved in commission of forest offense. Full stop. Next para. Thus, it is clear from the scheme of Section 55 that apart from confiscation, comma, there can be other penal modes adopted for the commission of the forest offense itself. Full stop. A plain reading of Section 55 does not, comma, in any manner show that as per the said provision, comma, confiscation can only be resorted to after the authorities exhaust all other penal measures before the criminal court for the purpose of addressing the commission of a forest offense, but that confiscation is an additional measure which can be taken over and above the other penal measures. Full stop. The same scheme is reflected in Section 59 capital A within bracket 3 of the Act as amended is in West Bengal. Full stop. Subsection 3 of Section 59 capital A stipulates that where any timber or other forest produce which is the property of the state government is produced before an authorized officer under subsection 1 and the authorized officer AO capital is satisfied that a forest offense has been committed in respect of such property, comma, he may, comma, whether or not a prosecution is instituted for the commission of such offense, comma, order confiscation of the property together with all tools, comma, ropes, comma, chains, comma, boats, comma, vehicles and cattle used in committing the offense. Full stop. Thus, comma, insofar as the remedy of confiscation being in addition to prosecution otherwise for the forest offense, comma, Section 55 within bracket 2 and Section 59 capital A within bracket 3 overlap each other. Full stop. Two key phrases, KEY, key phrases of Section 59 capital A within bracket 3 are to be considered in the present context. Full stop. The first expression is double inverted, authorized officer is satisfied, double inverted clause. Full stop. Thus, comma, it is clearly indicated that the satisfaction of the authorized officer, comma, of course, comma, upon giving a hearing to the concerned parties, comma, is the prerequisite of confiscation. Full stop. The other key phrase is double inverted, whether or not a prosecution is instituted for the commission of such offense, double inverted clause, comma, making it independent and additional for confiscation to take place, irrespective of whether a prosecution is instituted or not. Full stop. Nothing in section 55 of the Act militates against the provisions of section 59 capital A within bracket 3. Full stop. Rather, comma, section 55 also reiterates that confiscation may be in addition to any other punishment prescribed for the offense, and merely states that the articles which can be confiscated have to be done in respect of a forest offense being committed. Full stop. Next para, nowhere in section 55 is it stipulated that a forest offense, the commission of a forest offense has to be proved beyond reasonable doubt, or a criminal prosecution initiated and or a decision being arrived at by the criminal court on the forest offense as a prerequisite of confiscation. Full stop. Thus, comma, there is no repugnancy between sections 55 and 59 capital A of the 1927 Act, rather, semicolon, rather, comma, the two provisions work in tandem, comma, providing a scheme where, irrespective of and independent of a prosecution being instituted for the predicate forest offense, comma, the confiscation of the vehicle carrying the produce, which is a part of the commission of the offense, can be done. Full stop. The only prerequisite is that a hearing has to be given to the concerned persons. Full stop. In the present case, comma, we find that a complaint was lodged on June 20, 2022 by the concerned officer with the nearest police station, comma, thus raising a presumption that the ball was set in motion by the respondent authorities for initiation of an investigation into the predicate forest offense as well. Push up. Next para. On a bare perusal of the order impugned before this court, judgment impugned before this court, comma, it is found that the learned district judge, comma, acting as appellate authority under the said act, comma, clearly took into consideration all the aspects of the matter. Full stop. Next para. In the order of the authorized officer, which was under challenge before the appellate authority, comma, dated April 28, 2023, comma, it has been clearly recorded that hearing notices were sent to the registered owner of the vehicle, that is the present petitioner, to appear for hearings on several dates, comma, including July 25, comma, August 12, comma, August 29, comma, September 19 and October 21, 2022. Full stop. The petitioner, in fact, appeared for hearing on July 25, 2022 and submitted his written deposition. Full stop. He also submitted Vakalatnama and notarized affidavit designating learned advocates to contest the case on his behalf. Full stop. On September 19 and October 21, 2022, the advocate of the petitioner very much attended the proceedings, hearings on his behalf. Full stop. Nowhere before the authorized officer was the objection taken by the petitioner or the petitioner's counsel that an opportunity of cross-examination was required to be given to them, or they had been deprived of such opportunity. Full stop. Rather, comma, the petitioner was represented by qualified professionals and had submitted his written deposition without there being anything on record to indicate that any opportunity of cross-examination, comma, which was an option for the petitioner, comma, was even sought. Full stop. Thus, comma, on the ground of lack of opportunity of cross-examination, comma, the present challenge does not stand on its own feet. Full stop. Next para. Coming to the other aspect of the matter, comma, as discussed above, comma, this court is of the clear opinion that the judgment of the Supreme Court in Gopal Sarkar Supra takes into consideration all facets of section 59 capital A within bracket 3 of the 1927 Act, within bracket as amended in West Bengal. Full stop, as such, comma, with utmost respect, comma, the learned single judge, comma, in the matter of Muhammad Rehan Alam, comma, proceeded on proceeded contrary to the clear proposition laid down in the by the Supreme Court in Gopal Sarkar's case on an erroneous yardstick, inasmuch as Section 55 was not specifically considered in Gopal Sarkar. Full stop. Next para, as per the above discussion in the present judgment, comma, even if the Supreme Court had specifically considered Section 55 in so many words, comma, there would not have been a material change in the outcome of the decision of the Supreme Court, comma, since Sections 55 and 59 capital A operate in conjunction with and supplement each other. Full stop. Thus, comma, I do not find, thus, comma, again, comma, with deepest respect for the erudition of the learned single judge delivering the judgment in Muhammad Rehan Alam Supra, comma, of the opinion that the said judgment was par inquirem in spirit, inasmuch as it violated the principle clearly laid down in Gopal Sarkar on a yardstick which is not a relevant one for the purpose of distinguishing a judgment of the Supreme Court. Full stop. Next para, be that as it may, comma, since I differ with the conclusion arrived at by the learned single judge in Muhammad Rehan Alam to the extent that in view of Section 55, comma, before a vehicle is confiscated, comma, a criminal proceeding has to be initiated. Full stop. Next para, accordingly, I referred the matter to the Honorable the Chief Justice for the purpose of constitution of a larger bench to decide the following question for reference. Colon দিয়ে নিচে কোয়েশ্চেনটা ফ্রেম করা italics-এ, whether, comma, in view of the clear provision of Section 59 capital A within bracket 3 of the Indian Forest Act, comma, 1927 within bracket as amended in West Bengal, bracket closed, comma, read in conjunction with Section 55 of the said Act, comma, a prior criminal prosecution is necessary for the purpose of confiscation of a vehicle under the provisions of Section 59 capital A, question mark. Since the matter has been referred to a larger bench, since the matter has been referred to a larger bench on the above limited question, comma, the revisional application is kept pending, comma, subject to the outcome of the said reference. Thank you.
Before my Lord Justice Rao, this point was challenged. With regards to the provision of 59A is a violation unless it is the criminal prosecution has been initiated. My Lord, I have argued that has been affirmed, my Lord. So there is a two distinct parallel proceedings.
So Justice Rai versus Justice Rao. Justice Rai versus Justice Rao. Justice Rao was pointed this judgment. Gopal Sarkar was must have been pointed. So just what the view did Justice Rao take? No, but Justice Rao, how could he distinguish coordinate bench judgment without referring?
That I think it was before the my Lord Justice Rai. This Justice Rao has my Lord has.
Why didn't you cite that then it would be par inquirem on another count also? Need not. Why should we doubly castigate something? Let us see the larger bench will decide.
That time we will refer this.
Yes.
Great.
Thank you.
This is.
Next.
Milord, in item number 8, Milord, Mr. Sarkar is appearing.
File ta debe.
Mr. Sarkar is appearing at.
Yes, where is he?
Milord, he is not.
No, on the last occasion also we grant no further adjournment. Sorry. We'll dismiss for default unless you start. You are Mr. Shaha. You are Mr. Romodip Shaha. You are the advocate on record. You start the matter.
In depth, Milord, I am not aware with.
Then you should not have come. Should not have come. This is the second occasion when adjournment is sought. You are trying to avoid this bench or what? Then
due to some personal difficulty, my lord,
Whatever it may be a personal difficulty, you must be ready in the matter. This is the second occasion you were asking for time. No, not every day, sorry. Not so lenient. What is the challenge about?
We preferred an appeal, this revisional application challenging an misappeal which has been preferred by the respondent, my lord, and
Was there any direction for service, or this is the first time?
no, my lord, this is a very initial stage.
Initial stage. What is the challenge against? Misappeal means?
And injunction application has been granted in favor of us, my lord. We are the plaintiff in the very initial suit, my lord.
Yes.
Then, my lord, and appeal has been preferred, my lord,
By
the
them.
respondent. Yes.
Yes. What sort of suit? Suit
My
for?
lord, for the partition and the injunction.
Acha.
And,
What injunction? Ad interim injunction
ad
granted?
interim injunction.
Injunction application was kept pending by the trial court.
Yes, my lord.
Main injunction application was pending in the trial court.
No,
Ad interim
not
was granted.
pending, my lord, that has been granted, my lord. Then the
There are two sorts of injunction. Main injunction application is disposed of, and
main injunction is the pending, my lord.
that is what you are saying.
It
So ad
has been
interim
pending.
injunction was granted.
Yes, my lord.
So ad interim injunction of what nature? What injunction? Restricting them from doing what?
My lord, in depth, my lord, I'm not
Acha, very
aware, my
well.
lord, and
Then they
that has
preferred an
been
appeal.
rejected. In the appeal, my lord, that has been rejected by the court, my lord, and we are preferring this revisional application challenging the rejection order of the injunction application. Ad interim injunction.
On what ground? Let us see.
The order is in page number 80, my lord. 6 March.
Well, let him come tomorrow. On the prayer of the petitioner, the matter is adjourned for the day.
Great.
This means that I am against you, Brian Fishy. Yes, I tried my level best but could not find out anything in your favor. So let Mr. Sharkar come. Yes.
I am coming to your lord's court first time, my lord.
No, you have come many times. I've seen you many times.
Sir, regarding this issue,
Acha.
I am challenging the order dated 28/4/2025, Miller, wherein Miller, this
What sort of amendment has been allowed?
that page number 10, Miller.
You are the defendant or the plaintiff?
In the
You are the defendant or
civil suit, I am the defendant. Here I am the
defendant? Why don't you say that in your cause title always mention defendant, petitioner, and so the plaint was allowed to be amended at what stage? Before trial, before evidence.
for trial.
What is the nature of amendment?
When they have changed the date and months, Miller.
Let us see that amendment.
Paragraph 5, Miller.
Acha. Yes. Let us see paragraph 9 of the original plaint. You have not annexed the, yes. Where is the original plaint? You have just annexed the amendment application. How do you know what was there in the original plaint? You have come up against the amendment being allowed, amendment of plaint. You have not annexed the original plaint. Very good. What is the suit for?
Suit, ejectment suit.
What are these dates? What do do you have a copy of the original plaint? How did you draft the petition? How did you draft the petition? How did you have the full cause title?
Please give me opportunity, my lord. I'll file the supplement.
No, need not. Just hand over a copy of the plaint. How did you draft the cause title? How do you draft the cause title of the revisional application unless you have a copy of the plaint? You did not draft the plaint, the revisional application.
I did.
Where did you get the cause title, the addresses?
They have sent me from that.
Come back tomorrow with the plaint. Learned counsel for the petitioner seeks a day's accommodation for producing the plaint, original plaint of the suit. Accordingly, let the matter stand adjourned till tomorrow. Next. Opposite party, your expression says so. Yes.
Malad,
Yes.
in this matter, in this
Yes.
section 24 application, I am for the petitioner, Malad.
Right, Mr. Dattu, what is the matter?
In the court below, I am the defendant.
All right.
Malad, in the meantime, on 28th of July, there was a date in the lower court. And the thing is that that day, Malad, subsequent some development have occurred. That's why, Malad, I want to incorporate those development in this petition.
What sort of development, Mr. Dattu? How does it? How is it material for section 24?
Because of the reason, Malad, that is a relevant point in this petition also, that I take 2 points. This is a matrimonial suit between two doctors. I am for the here my client is working
Husband.
husband is working at RG He's a specialist doctor in medicine. He has the night duty, and the wife is she's also.
Did not mention the hospital too much.
Malad,
affords a ground for divorce probably now. Anyway,
Malad,
so you work in RG yes.
And the wife is working at North Bengal.
She's also a doctor.
She's also doctor, but she's specialist in community medicine.
Whatever, yes.
She doesn't have the night duty. I have the night duty.
All right.
That's why, Malad, I just want the transfer of the case on this ground that I am in Calcutta, and in Calcutta in Shialda Court, section 9 application is going on.
Your section 9?
Yes, Malad, Lordship.
Special marriage. Mr. Datta, it should be the other way around. They should be clubbed by sending your suit to them.
Yeah, exactly, Malad. That's why I can club it out. Or the thing is that, Malad, I have also taken the other point. That is, my lord, the fairness. Want of fairness, my lord, of the local.
Suffering any stay?
No, there is no such stay. That's why, my lord, I pray for adjournment for this week, that I will incorporate those papers with this. And
on the prayer of the petitioner, the matter is adjourned till the next circuit. Full stop. It is made clear that pendency of this application shall not prevent the learned trial judge from proceeding with the hearing of matrimonial suit number 132 of 2024, pending before the learned additional district judge, Dinhata, Kuch Bihar. Thank you.
Grateful, Malad.
Thank you.
Yes. Opposite party, why?
You are appealing because the petition is not there. What is their case? What is their case, Mr. Dhar?
They have impugned the order dated 5th of March 2025 under.
Mr. Mujumdar, you are for the petitioner. Same junior.
No.
Different junior. So you created terror in your chamber or something like that. But you are so amiable. Always juniors are absent. No, should I put it tomorrow? I mean, should I pass it over? I can pass it over.
I did tell you, Doctor. The learned trial judge.
Yes.
Disposed of an application under section 24 of the matter.
The crux of our allegation is that they were affidavits were filed, but there were no supporting documents in it. The order says so. And we had filed certain documents, they had filed certain documents, and the trial judge, without looking into those documents, just on the basis of the petition and the WO, decided the quantum to be paid.
Is it reflected from the order itself?
Yes, sir.
Show me that portion you get in.
The order says that we have filed our affidavit of assets and liabilities.
No, don't get intimidated. You're for the opposite party, you're for the other side. Why did you let him take your copy?
He has asked for it. He is briefless time.
Should not have.
This is
If the DSGI is briefless, then I mean, what will happen to the
Union of India.
Union of India, right? No, don't take it back.
Very obedient method.
He's very good. Only one weakness, and we all know that. But since it's post lunch, so no difficulty.
I know his difficulty very well.
It's post lunch. He has had his lunch. Now he has. Yes. He says yes.
Always informed.
Always informed. That's very good.
Let us take
Yes.
internal page 17. Below the last paragraph,
17.
the certified copy of the order.
Certificate copy, Lord Chair.
No.
It's marked
Acha,
17 on top.
oh, acha, you have given a photocopy also, marking it. Very well. Page 17, yes. Yes.
Into the question as regards the income of the applicant, as because section 24 lays down that the first consideration would be the applicant does not have income sufficient for support and the necessary expenses of the proceeding. The applicant in her application has stated that she is devoid of income and sufficient means for her support and the necessary expenses of the proceeding. The applicant has filed her affidavit of disclosure of assets and liabilities, and from such he appears that she has stated that she is unemployed. The husband has filed his affidavit of disclosure of assets and liabilities, and appears it is stated that the applicant has earnings, should have been earnings, my lord, has earns rupees 30 to 40,000 per month. The husband has filed printout of screenshot of a Facebook profile and other photographs, but from such it cannot be held that the applicant is owner of any gym having sufficient income. At this stage, there is no cogent proof that the petitioner has sufficient income to maintain herself. Therefore, I hold the petitioner does not have any income sufficient to support her. Next, I look into the income of the husband. The husband OP has filed his affidavit of disclosure of assets and liabilities. The OP husband has stated that he has a part-time job and earns rupees 6,000 per month. The affidavit of disclosure as framed by the Honorable Supreme Court and of India requires that the cogent document should be filed in support of such employment. The husband OP has not filed a single document issued by any employer and has also not filed any details of the bank accounts maintained by him. The husband OP has left the declaration as to liquid assets and cash in hand blank. It appears that the husband OP was required to bring forth such documents and information to allow this court to determine his income. Such raises an adverse inference against the adversary.
But this is right, Mr. Mujumdar. Adverse inference has been drawn against you because you said you have income, but you did not produce any supporting document, nothing.
Should have given the husband to produce the documents.
What is the alimony which has been granted?
10,000.
Is there a child of the marriage? Mr. Mujumdar, I can remand it.
That is my
I can direct to give you opportunity, but in the meantime, you have to pay an ad hoc sum for her to survive.
Actually, to be very honest with the court, he works as a part-time event man.
You.
And we have
Event managers can be of different ranges, Mr. Mujumdar. You also won't know.
No, he's not owning the event management.
No, maybe.
But he's just
working for them.
For a part.
Understood. No regular income, maybe.
Somewhere around, that is 6,000, my lord, but let us.
No, 30,000 to 60,000, 40,000 you have disclosed. Oh, achha. That is your statement about her income.
No, my statement that she earns 30 to
Yes, your statement about her income, that is what. What have you stated in your affidavit that you don't have 6,000 you have stated? Some disclosure had to be there.
Yes, my lord, I do agree.
Something in between, Mr. Dhod will direct because. No, if yes, what do you say? No, because here, Mr. Mujumdar is right in a sense that instead of drawing adverse inference, one opportunity should be given to them to produce supporting documents. But in the meantime, definitely because their cases, they have only 6,000 per month and you own a gym. Despite the
The entire family is,
So let us.
you work or work out in the gym?
I am unemployed, I'm unemployed.
Employed in the gym.
No, no, I'm unemployed.
He earns 6,000. That is his disclosure.
6,000
Alex, the Facebook
Why not
shot.
believable? He earns 6,000.
and they have, he has engaged seniors, 6,000 rupees.
Mr. Majumdar. Yes, Mr. Majumdar. Yes, absolutely.
Didn't finish.
Absolutely. This is sufficient.
But is there any proof that I am charging any fee?
No.
So let that be for this.
Inference, I'm
File affidavits on that.
I'm
So, in the meantime, pay some ad hoc amount, Mr. Majumdar. What would be a reasonable amount according to you? We'll have a bidding.
No, my lord, whatever lordship thinks reasonable, I don't want to bargain with the court, my lord.
Are you enjoying any other order from 125 or something?
Yes, sir.
125, what is the quantum you are getting?
1,500, that also not being paid.
1,500. So we'll direct a limited period for during which he'll pay this amount. Till then, get that 1,500.
And he also owns a vehicle, four-wheeler.
You have given the number in your affidavit.
Okay, we have annexed the paper document.
Here or there in the
Here
affidavit? There you have given in the trial court?
There we could not get hold of it. We only got hold of our Facebook screenshot that she is owner of the gym. She says she's owner of the gym. Her counsel says her father is the owner of the gym. One of them is saying false.
Facebook presumption is false. Learned senior counsel appearing for the petitioner contends that the petitioner husband.
And one thing, my lord, the signboard of the gym bears her phone number.
Maybe she is operating it, I mean, for her father. We don't know. I mean.
Same thing inherited.
As a learned senior counsel appearing for the petitioner husband contends that the learned trial judge, while granting an alimony of rupees 10,000 per month, refused to take into account the specific allegation of the petitioner in his affidavit of assets and opposition to the and written objection to the alimony application, that the opposite party wife is the owner of a gym having sufficient income, gymnasium having sufficient income, full stop. In support of the same, certain screenshots, printouts of screenshots from the Facebook profile of the opposite party were also produced before the trial court, which apparently indicate that the name of the opposite party is appearing as the owner of the gym and her phone number is given in the signboard of the gymnasium, subject gymnasium. Push up next para. Learned senior counsel further argues that since the learned trial judge was of the opinion that although the affidavit of assets was filed by the petitioner husband, no supporting documents were filed, an opportunity ought to have been given to the petitioner to furnish such supporting documents instead of drawing adverse inference outright on such technical ground and passing the impugned order. Push up next para. Learned senior counsel further argues that if given an opportunity, the petitioner would be able to substantiate the allegations made in his written objection and affidavit in opposition, as well as furnish further documents in support of the affidavit in opposition, affidavit of asset. So next para, learned counsel for the petitioner opposite party wife submits that the quantum of income disclosed by the petitioner husband in the court below is not credible. Push up next para. The opposite party husband has stated that, as a petitioner husband has stated in the trial court in his affidavit, that he has a part-time job as an event manager, which is not commensurate with the monthly income disclosed by him. Moreover, it is contended that the learned trial judge did not commit any jurisdictional error in drawing adverse inference against the petitioner husband due to non-production of any document in support of his affidavit of asset, in line with the judgment of Rajneesh versus Neha of the Supreme Court. Next para. Upon hearing learned counsel for the parties, it transpires that the learned trial judge, without giving an opportunity of furnishing further documents in support of the affidavit of asset of the petitioner husband, comma, drew adverse inference outright against the petitioner husband. Full stop. Next para. It is well settled that where a view is taken on a technical ground, comma, which is curable, comma, an opportunity for rectifying such drawback has to be given to the party concerned, to the affected party. Full stop. Thus, comma, this court is of the opinion that the learned trial judge ought to have granted an opportunity to the petitioner husband to furnish cogent documents in support of his affidavit of asset, comma, in view of the learned trial judge being of the opinion that merely due to absence of such documents, comma, the averments made on oath in the affidavit in opposition of the husband were being disbelieved. Full stop. Accordingly, comma, next para. On query of court, comma, learned counsel for the opposite party wife submits that she has been granted alimony to the, maintenance to the tune of rupees 1500 per month under section 125 of the Code of Criminal Procedure, which is not being paid by the petitioner husband. Full stop. Next para. But Mr. Mujumdar, I'll direct you to pay all the arrears of alimony regarding that 125 as a condition of the.
I did not know this.
No, obviously you did not know. I'll put it in my order so that it's easier for you to convince you. In view of the above discussions, comma, CO number 11111 of 2025 is disposed of by setting aside the impugned order bearing order number
29 dated March 5th, 2025.
29 dated March 5, 2025, passed in matrimonial suit number 74 of 2020 by the learned
Additional district.
74 of 2020 by the learned additional district judge, fast track court at Siliguri, and remanding the alimony application to be reheard and considered afresh by the learned trial judge upon giving opportunity to both the parties to furnish further documents, comma, if they do so deem fit, comma, in support of the respective affidavits of assets stroke disclosures. Full stop. Next para. The learned trial judge shall fix specific dates for such furnishing of documents to both parties and adjudicate the alimony application afresh upon consideration of such documents, comma, if any furnished by the parties, comma, preferably within an outer limit of 2 months from the date of communication of this order to the learned trial judge. Full stop. Next para. However, comma, the above order is subject to the precondition that the petitioner husband clears off all due arrears of alimony, arrears of maintenance in terms of the order passed in favor of the petitioner, opposite party wife under section 125 of the Code of Criminal Procedure within 3 weeks from date, and thereafter goes on paying current maintenance in terms of the said order. Full stop. In the absence, in default of such payment within 3 weeks, comma, regarding which the petitioner husband shall satisfy the trial court by furnishing the appropriate receipts or other documents, comma, the above the present order shall stand automatically recalled without further reference to this court, and it will be deemed that CO number 111 of 2025 stands dismissed. Full stop. The parties shall act on the server copy of this order without insisting upon prior production of a certified copy.
To extend 3 to 4 weeks.
4. 3 বদলে 4 করে 4 weeks. Yes.
For the petition.
Well, I am appealing for the preemptive opposite party.
Right.
My lord, this is a case wherein I have filed an application for preemption on 2 scores, my lord. One being the non-notified co-sharer.
You have lost in both the courts.
My lord, trial has not been conducted. My lord, they have filed an objection that the trigger, it has not been triggered. The preemptive right has not been triggered.
You have come out directly against the first court's order.
My lord, district judge has upheld the order of the trial court in that regard, my lord. My lord, kindly takes the plaint, my lord. That is that.
No, what is your point? Just
lord-
formulate your points and then we'll
Yes,
look at.
my lord, 2 points, my lord. The district court and the trial court has held that I have not made the statutory deposit within the time frame as required under section 8. That is wrong, my lord, because since I am a non-notified co-sharer, my lord, there is a larger bench's decision that I would be governed by Article 97. So my period will be within 1 year as a non-notified co-sharer. This is one point. And I'm also an adjoining land owner having the longest boundary.
No, did you deposit at all the
Deposited, my lord.
within 1 year?
My lord, within, I would say, my lord, within 3 months. My lord, because I have filed it on the day, I have,
Court's observation was that you had to file it within what time?
my lord, court says that not specified, 3 months only was considered. That was specified under.
But you see, you are deposited within 3 months.
My lord, now what has happened is,
Yes.
kindly takes, that is on fact.
Achha, what is the other point?
Another point, my lord, I am also the adjoining landowner.
That is the premise.
4 months is there.
No, your preemption application was rejected on that ground.
My lord, that was not even considered by the trial court, that my longest boundary,
No, your preemption was rejected on the ground that
I have not made the deposits.
only on that ground.
Yes, my lord. So, my lord, this is all matters of trial. Because when
No, your trial was held because
No,
of.
my lord, because erroneously held, my lord, because these are facts that has to be framed by way of issues. Even if they are disposing of by preliminary issues, if it is a question of law only. Now, my lord, I would say this is a mixed question of law and fact, and the court could not have done so. My lord, they have relied on the judgment of the Honorable Supreme Court in Barasat, my lord, Barasat Eye Hospital, wherein no deposit was made. And I completely distinct myself. My lord, I have made the deposit before the concerned revenue department. I have deposited the challan. That challan was to be endorsed by the judicial department and given to me. In the meantime, my lord, the holidays intervened. On the date treasury was opened, I deposited the amount. On the date court opened, I deposited the challan before the court. My lord, my plaint is at page number 148, my lord.
No, how did the appeal court proceed?
My lord, appeal court said that it is rightly held. They have also relied upon the same judgment of Barasat. And saying that because no trial has been conducted, my lord, because if I am the adjoining landowner, I have to prove it by evidence. My lord, in a prima facie view, this
No, you have
orders
taken
have been
both
passed.
grounds, non-notified co-sharer and adjoining.
Yes, my lord. So, my lord, if non-notified co-sharer is there, I have 1 year time.
So outer limit should be taken because
Outer limit.
it may very well be allowed on that ground only.
Yes, my lord. So, my lord, they have not even considered that non-notified shareholder, the limitation is 1 year. That is not even reflected. That is the error in law, my lord.
You want to cite something or?
My lord, Nerul Islam,
This is
my
the
lord,
point.
division bench judgment, I would distinguish it from the Barasat I have. This is the Supreme Court judgment on Barasat.
Have you got an extra copy of the Land Reforms Act also? এখানে আছে আমাদের Land Reforms Act.
This is the judgment I am relying, the larger bench in Nerul Islam, my lord.
Land Reforms Act that one. Yes, Justice Bhattacharya's judgment.
My lord, in the judgment of Nerul Islam, my lord.
Mr. Roy appeared. Sir Parthopratim Roy is dismissed, Sir Parthopratim. She is bound in any event. Thank you.
My lord, he has appeared for one of the petitioners.
Yes.
So, my lord, the question was framed whether the period of limitation begin to run when such period end for the preemption application under Section 8 of West Bengal Land Reforms Act at the instance of a co-sharer on whom notice of transfer as contemplated under 5.5 of the Act has not been served. This was the question framed, my lord. And my lord, it has been answered in the last page, my lord.
97.
1 year.
Yes, 1 year.
So, my lord, if that be considered, my lord, I have deposited.
And from your preemption application, just you are placing that. Going to place that, I stopped you actually. So show me that both grounds were
148, my
taken.
lord. Page 148 is my plaint. My lord, relevant paras are 6, 7, and 8. At page number 151. 6, I am said that I am the non-notified co-sharer, and 8, I have said that I am the longest boundary owner.
You don't clearly say, yes, para 8.
Yes, my lord, 8. 7 is the.
Also
description and-
contiguous.
And
And
my lord,
Barasat Eye Hospital, any particular portion you want to say that?
Barasat Eye Hospital, I want to distinct. My lord,
Yes,
because
any,
it says that it is, in that case, my lord, it was regarding the longest landowner, longest boundary. And
yes.
my lord, in which the deposit was never made. So that is not applicable in my case, my lord. I am covered by the decision of Nurul Islam, my lord. Wherein 1 year was the time I was provided by the statute under section 8, my lord. My lord, and my deposit would show from page 167, my lord. I have deposited on the day I have filed the preemption application. But until it is approved by the Sreshtadar and the Chief Administrative Officer of District Judge's office, I cannot make that deposit, my lord, before the treasury, because they have to give me an account detail. And they have given me, my lord, after the next day, the holidays have begun. And right on the date of opening, I have filed it before the court by a put up.
Does Barasat say it has been rejected? I have forgotten.
My lord, it says it cannot be triggered if it is not done within the, if the deposit is not made, that means there is no case at all under section 8.
Yes, that is different from rejecting the application on that ground.
That was after trial, my lord.
Yes.
That have rejected, my lord.
That is
because
what
it was
we are,
beyond
because the language
limit.
of section 9 is also that on the deposit, the municip shall give notice. It is in limbo. It remains in hibernation till the deposit is made. But here your application has been rejected outright. What is the finding of the trial court? I'll once.
My lord, kindly see the certified copy, my lord.
Yes.
First is.
No, the misappeal we have I've seen. The
Trial
trial
court is, my lord, at page number 182, my lord.
Now, in these matters where there is a judgment of both courts, please annex the certified copy of both. This is a photocopy of the trial court. Trial court, both
My lord,
courts.
even after that, I have given certified copy also, both courts.
Subsequently?
No, my lord, at the time of filing. 2 certified copies are there, my lord.
Oh, acha. No. Trial court is there. No, only misappeal I find. Trial court certified copy is not there. Must be with you. Yes.
My lord, for the convenience, my lord, at page 182, my lord, it starts.
182, yes.
My lord, kindly sees, they have referred to the 2 judgments, Barasat and followed Barasat.
Oh, they took a point of maintainability.
Yes, my lord. That it's not triggered, my lord. And not even considered my longest boundary in this case, my lord, by the trial court.
But when this order was passed, you had already deposited.
Yes. But they say that I did not deposit within 3 months.
Yes, Mr. Burai.
I turn to, I am on the basis following in view of the judgment delivered in the Abdul Watan only, after considering the Bharsha Hospital, application for preemption you can be filed along with the concession amount. That was the precisely the Honorable Supreme Court says after considering Abdul Watan only. The judgment, I'll settle your lordship. Now, my lord, first thing is we are on the basis of the short deposit. Why short deposit? My lord?
Not short deposit, late deposit. He made the entire deposit.
Late deposit cannot be regularized.
We have not.
We have to make the full concession amount within the period of limitation. Bharsha Hospital said it can be enlarged, but you have to file deposit within that period of limitation. Subsequently, it was considered in Abdul Watan only. Abdul Watan only, yes. That you have to file this application along with the concession amount. That was not there. Apart from that, my lord, we are saying that there is no concession amount deposited by the petitioner. Who was before your lordship?
These are matters of trial.
Who is before us?
And there is a partnership form, whether it can be made. Right?
That's a different ground you are taking. That is not the ground on which it was.
Now, it's short deposit. Now, if that be so, then 4 persons are claiming to preemption on the single deposit. That was considered by our honorable court and it was held. It cannot be done in that way. A riot. Well, apart from that, it is on the, I am on the majority of the ground, I have said short deposit. But short deposit not on that fact, This point also one it is short deposit. Per person, filed a single application. That is why presently I want to. অংশটি খুলুন না একটা যেটা আব্দুল মতিন মনির পেজ there's some marking minor, forgiving minor, and both side 6.3. This is reported in refer করা আছে 2022 Supreme Court 2022 Supreme Court page 2175. They are not here. I own that. Some markings are there. Why not really forgive me? Why not? All the judges have made a compilation for the purpose of.
This is Barasatai Hospital.
No, Abdul Moti.
Oh, acha, yes. Yes.
Yes, sir.
This has considered Barasatai
Yes.
Hospital.
6.3 মানা খালি গন্তে 6.3 এটা তো জসেবেরটা ভালো ছিল এটাও দিন প্লিজ
What does 6.3 say? Read it out.
We are of the view, can you go?
6.3.
It is not. We are of the view, it starts with the.
This is 33.
Yes, yes.
33 of the earlier judgment has been. Yes.
View that the impugn order and the view adopted would make a weak right into a speculative strong right, something which is neither.
That was held in Barasatai.
Yes, after that, not judicially interpreted. 6.3, after that, therefore, the deposit of entire concession money with additional 10% self-concession along with preemption application is a statutory and mandatory requirement.
That we have done, my lord.
Read the entire sentence.
Requirement, and it is precondition before any further inquiry as contemplated section 9 of the act is held. So you have to deposit along with your application the entire concession money.
Yes.
Whether this application was filed along with the.
But in the at the same time, it is stated and it is a precondition before any further inquiry is contemplated.
My lord. We have done it on the same day, my lord. My lord, 167, my lord, 167, page 100.
We'll come back to you. Please don't. Both cannot argue together.
My lord, page 167 is
Take
my
your
challan.
seat. Take your seat. Let them finish. Yes. Let us come to the provisions of the Act, Mr. Section 9(1) is very clear. On the deposit mentioned in subsection 1 of section 8,
Yes.
the munsif shall give notice of the application to the transferee.
Several judgment, my lord knows better than us, my lord. That initially it is there is no stringent condition mentioned in the original Land Reforms Act. Unlike non-equal tenancy act, the deposit of the entire concession money is not mandated. Subsequently, when the Barasatai Hospital came for the first time, so far where it was held, no, whatever the concession money mentioned in the deed itself, that will be, you have to make the deposit to consider your application for preemption.
Language of 8 is also clear. I mean, may apply for transfer of the said portion on subject to the limits. Transfer of the said portion on deposit of the consideration money.
Yes, this. So that was subsequently when this order court says that.
But then how, where will section 9 within bracket 1 go? The munsif may after such inquiry as he
said that section 9 is only if you said that imputed price has been indicated in the consideration amount for execution.
You have taken a point that it was a short deposit.
Short deposit. Now I have to show to your lordship that this application was filed without any challenge showing the consideration deposit of consideration amount. Even assuming this point I am raising, 4 persons can maintain a
short deposit can only be taken later on. So section 9(1) says on the deposit mentioned in subsection 1 of section 8, munsif shall give notice of the application to the transferee. Then on such notice, transferee or any person interested may appear and prove the consideration money for the transfer and the other, if penny properly paid by him in respect of the lands, such and such. The munsif may then On such notice being served, transferee or any person interested may appear within the time specified and prove the consideration money paid for the transfer, if any property properly paid by him in respect of the lands. If you do that, the municip may, after such inquiry as he considers necessary, direct the applicant to deposit such further sum, if any.
Yes.
They have made a deposit within 1 year. They have taken a ground of contiguous owner also.
Initially, this 1 year, that is 1 year from the date, according to my learned friend, the consideration for the purpose of.
Where has it been held that the application will be dismissed without this?
You should consider on that, my lord. Can you consider 33?
Mr. Rai, a judgment cannot be taken to be precedent for something which can be derived from the ratio laid down. That is settled.
Right.
Has to be exact, unambiguous, clear.
Yeah.
That is only the precedent portion will only be the unambiguous law laid down,
Yeah.
not something which can be deduced from that. That is well settled. We have to deduce.
Each one has been interpreted by oral appeals court in a manner, my lord. May I read out that?
Barasat Eye Hospital was placed before us. Barasat Eye Hospital. Abdul Batim only quotes Barasat Eye Hospital.
That. In the present case, after that, my lord, you are fine, my lord.
Which para?
33 is 6.3, my lord, got it?
6.33 is a continuation of the quotation from.
Yes, after that, my lord, 33.
Oh, no. Acha, 6.3.
Middle portion. Therefore, deposit.
No, 6.3 is a part of the. How does 31 become 6.3? We don't. No. 1 minute. Barasat 33 is a continuation of Barasat Eye Hospital being quoted.
Yes,
And
after that.
6.3 is
The original.
Present case. After that,
6.3 is the Abdul Matin's paragraph.
yes. In the present case, my lord, got it? That
In the second sentence, actually,
Yes.
yes. In the present case.
In the present case, admitted the preemptors had not deposited the entire consideration amount with additional 10% consideration along with the preemption application. The aforesaid aspect has not been considered either of the first appellate or by the High Court in this case. Now, so far the submission of the way of the monumentally believe that the said consideration mentioned in the deed in favor of the venue is another outsider matter. If over the same matter, kindly turn to the ordering portion. Paragraph 9, here, my lord, paragraph 8. So far as the submission on behalf of the preemptors that the contention of non-deposit of the entire consideration with additional 10% of the sale consideration by preemptors was not raised before the courts below and has been raised for the first time before this court, and therefore the same not be considered permitted to be raised now. It is to be noted that the said condition would go to the root of the matter on the materiality of the preemption application, as without complying the statutory requirements as mentioned under section 8, said that the same is not maintainable. In admitted position, the preemptors had not deposited the entire sale consideration with additional 10% the sale consideration along with the preemption application as regarded under section 8 in the instant case. Here also, my lord, if you can turn to the order. I'm drawing appeals court order. It is annexed here also.
But then, Mr. Rai, suppose I have 1 year limitation. Today, on the second month, I file an application for preemption without that consideration. It's rejected on that ground. Very next day, I'll file another application for preemption if it's within the Limitation Act.
Then where do you have to file that?
No, if they can file another application with the full consideration money, if it's within the limitation, fetter is limitation. Fetter is limited, only fetter. We'll interpret this Abdul Mati, let it be set aside in the
My lord, and we have also paid it, my lord. That is not the fact
These
that we have
state
not
statutes
deposited.
are not properly explained before the Supreme Court, Mr. Rai, and I know I am on camera, but this is, unacceptable. These are, with utmost respect, this is not the correct interpretation of section. We lead Barasat Eye Hospital, both Supreme Court judgments together and interpret it.
Here. So one
Cannot be triggered, true, but it will be an absurd interpretation. Suppose if I take back and file tomorrow within limitation, I can do that in the present application as well. Only the,
Only one thing, attention. Pay your lordship is related to the parties for possession. On the face of the record, I have raised the materiality point.
Nativity of 227?
No.
There.
There I have raised the materiality point from the basis it was held with the not deposit coupled with the application, so it was rejected. This followed by my lordship that in view of their statement made in paragraph 8, the 1 year.
No, they say they have deposited also.
Yes. I'm not.
On the time of filing, my lord, on the day of filing. That I can show, my lord, from my document. My lord, 167, my lord. Page 167.
When the petition was filed and when the
Yes.
These are the two things.
When was the application filed and when was the deposit made?
My 16th.
Which are the two things?
16th, my lord. 16th of October, I filed the application. My lord, kindly takes 167 now when I've made the payment.
167 is payment, yes.
My lord, 167 kindly sees there is a signature of the chief ministerial money. Unless he signs.
State Bank is 22nd November.
Yes.
2nd November, my lord. That is not, my lord. First, I have
22nd
to
November.
deposit this challan.
Oh,
to the-
second, yes.
My lord, first column, my lord. Once the junior division sanctions my amount, he signs and gives me a number where I
Yes.
have to deposit. My lord, after that, I have deposited, my lord. Now, I cannot deposit before the court gives me a number on which I have to deposit. So, on 16th, I have made this challan to the court. I have returned this back on 17th evening. My lord, since 18th to 2nd November, the treasury was
So
closed.
16th you got this challan?
I deposited to the office of the junior division, my lord, Munsif. I have to first get the sanction from the Munsif to make the deposit, my lord.
Yes, you got that sanction on 16th of
16th,
October.
I deposited to the court. On 17th, this challan was endorsed and returned back to me, my lord. Evening. My lord.
16th you deposit the amount.
No, my lord. The challan to the court.
That is what we are saying.
Yes, my lord.
Challan you deposited on 16th, right?
Yes,
And
my
you
lord.
filed the
After that,
application on
16th only.
16th.
With the challan, unless the preemption number is there, my lord, they will not enter it in the register and give me the account details where I have to deposit. After I have filed it along with my plaint, they have given my plaint number in the first column, my lord, and then it was forwarded to the office of the district judge, central administrative officer, my lord. Chief administrative officer, my lord, he has signed and returned it to me on 17th. My lord, there was a Dasera vacation from 18th to 2nd November. On 2nd November, I have deposited in the...
Dasera vacation of the bank?
No, my lord. Treasury, my lord. I have annexed that too, my lord, at page 168. 18 November on that year, my lord, the vacation started, my lord. Page 169, my lord, Durga Puja Maha Chaurasti, 18th October. It opened on 2nd November, my lord. On the 2nd November, I deposited it in the treasury. 17th, the court reopened, I deposited by way of put up. But my challan before the court was on the date of filing.
16th you filed the application, 16th you deposited the challan.
Yes, my lord.
And then?
It was returned back to me on 17th evening, my
by
lord.
the administrative officer of the court. Returned back 17th.
The treasury was closed, my lord.
17th,
did not have deposited.
18th you could not.
Till 2nd it was closed, my lord. 2nd it reopened after Dasera vacations, my lord. On the first day of opening of the treasury.
Saturday, Sunday, treasury is closed.
Closed, man.
28th, 29th. No, 30th it opened. Let us come to page 169. 18th, 19th, 20th. The 20th. After 20th, it opened on 21st, 22nd, 23rd it opened.
No, my lord, it did not open, my lord. Actually, the date was not given here, but my lord, it's open on 2nd. There is a long vacation, my lord, in pujas.
But this does not say that. You don't.
I understand that, my lord. Even I was of the same doubt, but they said that the treasury was closed. My lord, 2nd it opened, I have paid that amount on 2nd itself. Courts was still closed, it opened on 17th.
Have you stated that anywhere? That
Yes, my lord.
it was where? In your division?
Divisional application. But even when taking the worst case scenario, it's within 1 year, my lord. And 4 months also, if it is considered, it's within 4 months.
Acha, 1 year elapsed when?
My lord, 1 year elapsed.
But still then.
Yes.
Still there, still there.
We'll affirm the order and say that you can file your application tomorrow with the entire. We'll give you liberty to withdraw the.
But my lord, I have another claim also.
Then, yes.
My lord, that longest boundary is.
This is a compliance, sufficient compliance. This was filed along with.
No,
without the check.
it
Will constitute the challan to be a.
that
they-
is, can consider what is the
My lord,
judgment
can
by
you-
your lordship,
my lord, can-
7-1 application. Party, in a Premises Act.
Premises sin is different from this.
This is
In-
deposit of money,
No.
deposit of money in a court treasury. If my
Premises
lord,
sin is act.
yes, same thing, my lord, you needed to file an application if you want to deposit any money. Why is, I put this question to myself.
Challan is required, Mr.
Challan is required, you have to deposit at.
7-1, we have held that 7-1 does not require an application. But a challan is required all the same.
Challan.
No, in fact, we have held also that the application is filed to facilitate the deposit because of
There is.
obtaining a challan.
Now one can consider whether this deposit was meant.
Here there is no scope for further application. 7-1 has a scope of an application for, here they have,
Now, my lord, can when it was filed and.
they have obtained the channel, deposited on the same date as the application. It was returned on the next date, 16th.
Yes, that is the proper passing of the challan.
Yes, it was
17th
returned
is
to
what
them on
you get it.
17th
Now one can consider the why the appeal court have held. One can turn to page 21.
of the appellate court.
Yes. My lord is looking CO number 114.
How many COs are there?
Two COs are there.
I'm looking at 113 actually.
Oh. No. No, it's not one.
দুটো চলছে একসঙ্গে নাকি 12-13
My lord, it's same preemptors. my
12-13
lord,
টা
two
বলতে
lakh.
দেখাতে হবে তো, বুঝতে
Two
পারছি।
days. Two days of there.
12-13 দুটো দেখিয়ে দাও বলছি তো তাই দাও 13 ফাইলটা দিয়ে এখানে না এই সাইটে ফরেস্ট একটা থাক এখন থেকে পরের দিন লাগবে You are pressing from 113, Mr. Rai?
My lord is looking down 113 is there.
113, yes.
Yes. Yes.
Do you have the corresponding pages or can you look into that? Because I've been marking.
Almost.
Same. Almost same. Or my lord can look 1 and 3, my lord, because my lord is marking though.
113, I'm looking, yes.
No, my lord is looking 114.
113.
3.
Oh, 3. Then I can. Can you turn to page 27?
Yes. This is the appellate court's order.
Yes, my lord.
Yes.
Learned lawyer, my lord, can you go?
Hmm.
I'm skipping over the middle portion. But
Yes.
The application of preemption arose on 17/7/2023. And so there no option are to conduct the period of limitation from the admitted date of cause of action. It has already been discussed earlier. The right of preemption triggered only a deposit of the consideration money together for the sum of 10% that amount. When means unless the consideration money along with the statutory amount, no application of preemption can be filed in the present case. There is no situation when the application of preemption was filed with deficit amount, along with the making deposit the rest amount within the statutory period. So there appears no legal infirmity with the impugned. Because my lord, Barshad Hospital, if you file that with a short consideration.
No, but that has been precisely, Abdul Motin's precisely deprecate this. So you are proceeding on a premise which is contrary to Abdul Motin and relying on that judgment. The court says that they could have deposited a deficit amount and paid for making deposit
That is
rest.
the Barshad.
That is
Initially-
clearly categorically against Abdul Momin.
That is the Barshad initially, it was held subsequently.
They did actually, they did the right thing as per your cited judgment. That would be contrary to law. If they did that, that would be contrary to this. Your Abdul Momin. That part deposit I'll make later. But court relies on that they could have done this. It's a wrong yardstick apply. They did the right thing. How can you get a challan, Mr. Rai, unless you file an application? A challan cannot be in thin air. In the trial courts, for getting a challan sanctioned, there has to be something on board.
They have endorsed the number, my lord, and corrected the amount also, my lord. Otherwise, I could have found an amount that was wrong.
Because you see that if you see the challan, in the challan, the number of the miscase is also given. So the date of obtaining the challan was the same as that of the application. What was the page number of the
My lord,
challan?
167.
167.
No, challan filed on.
See challan 1610.
1610.
Yes.
Challan file
If you hypertension rate, then people won't be able to file any preemption application.
I'm only.
No, you're fair on that. I'm not saying that.
I am not saying on that.
We are only on law. You are right.
Now one can consider it the other way. I have said short deposit. My lord, kindly consider today, my lord.
Barasat did not say, Barasat was rather incorrectly interpreted in the subsequent.
But
with
this-
the utmost respect.
This thing has been completely messed. So our preemption proceeding.
Barasat says it cannot be triggered. That is the exact language which is in conformity with section 9(1). No notice would be served means won't be triggered.
Ours is the kept in limo, it cannot be considered the registered in the records. Now, my lord, one thing, my lord, I am submitting before your lordship. Now, this is the point which can argue before your lordship in that way also, whether the passes unregistered firm can be turned to a raya for proceedings.
But that point was never taken.
That is what
For the first time in this second round of litigation.
second round of litigation.
This case, misappeal also did not take this point.
So
take that ground of maintainability.
That is one, my lord, misappeal order 40 rule 22, my lord knows. That was in my favor. I can argue it was in my favor. Today, my lord, whether I can.
If you could not take it there, that same principle applies in 227 also. That was also in your favor.
Yes, in my favor.
So you cannot argue that here. This is a new point.
New point on the non-majority.
They have not filed a W also, my lord, to my
Touching to the root of the case.
Unregistered is a mixed question.
No, my lord, I bowed out to your lordship.
Why?
Because Rayat, my lord, definition of Rayat.
No, unregistered or not?
Unregistered. According
But
to
they're
their.
individuals, my lord, partners have filed.
Yes. Then my lord saying they're individuals.
So as individuals they can file.
Then what are the partnership firm, how can it be done? Well, can you consider?
Partnership firm has been named here, is a party. It would be rejected as regards the partnership firm, granted in their individual
Then the
favor.
partners will remain. Then the partners will remain, even assuming the 4 partners are individual in nature.
Yes.
Then my lord, a single deposit can be maintainable.
Did you take that point also?
We have said short deposit, my lord. My lord, can you consider today, my lord is making.
Short deposit, then the court has to be clear on that. Why short deposit? Court did not consider that ground at all.
Today, my lord, even if my lord, on the face of the record, I can satisfy your lordship, the application is expressly illegal, is not maintainable. Whether my lord is.
It's not a question of deposit simpliciter then. Then that inquiry has to be done under 9(1).
No consideration, my lord.
You are the opposite party, you have appeared on notice.
No.
You have taken that point that inquiry
up.
has to be
They
undertaken.
have appeared so much.
Section 9(1) cannot be obliterated from the statute book.
Yes, that is, absolutely, you have to file the deposit the interconsideration.
You have appeared here, you have taken the point, now an inquiry has to be done.
Inquiry, but to the extent that what is the amount, constitution amount, according to us, according to my learned friend, this is the constitution amount.
Mr. Rai, the moment you take out a maintainability,
There,
the moment you take out a maintainability petition after appearing, it squarely comes under this inquiry under
yes,
section.
provided
9(1).
they have raised the point, this is the deed.
Why should they raise?
Because I have, when they raise this point, what is the actual constitution amount, then I
It is
have,
a consideration. It's
then I have.
not
to
a
do.
consideration issue. Therefore, deposit the challenge within. The other point which you are raising, we won't permit you to raise it. It will be open to you to raise. But since the deposit is challenge within simultaneously with that.
হ্যাঁ, এই দেখো 16 তারিখে যদি জমা দিয়েছি না টাকার কথা বলছেন না জজ সাহেব বলছে 16 তারিখে জমা দেওয়া হয়েছে চালানটা 16 তারিখে জমা দিয়েছে তো পাস হয়েছে 16 তারিখ 16 তারিখ ঠিক আছে
Unless the challan is passed, you cannot make the deposit. Challan was passed on 17th.
that is too technical, my lord. I am not on that. Whether my lord can considering the other way. My lord is relating the parties to another proceedings for continuing on the if my lord's hold.
No, we'll allow the revisional application.
Yes, that is why. Kindly turn to the application for preemption once.
And we record that you are taking a point also regarding the partnership maintainability at the instance of the partnership. Alternatively, individual if they claim,
Also short deposit.
then they have to no the maintainability also with that fort can file.
Kindly turn to page 148 once first.
No, it's a question of maintainability of the application. If 4 persons can file a composite application,
Then each.
no, then it's one application. They can seek for a joint transfer in their favor.
No, that cannot be. You have to comply with that provision.
4 of us,
Four of
we
us.
apply as a body and we say 4 different persons. And we say that let there be a joint transfer in our favor. None of us shall supersede the other. No, nobody is the first applicant. We are asking for a common joint transfer in our favor.
This is a joint
Then it's a single application for preemption.
subject to action. This is the individual person. Rayat cannot be termed to.
Let us see how they have couched their
Yes,
application.
Mankali 148. That is why precisely and drawing page 148.
Yes. Their
who are the
descriptions to be
partners.
partners, Charles.
Now, my lord, can you turn to who have purchased the property? This partnership firm. Can you turn to paragraph 5, page 151?
Paragraph 1 itself, they say that it's a family business. or
Family
not?
all brothers.
And how this firm is there? Can you turn to paragraph 1?
Yes.
It is not an unregistered partnership notarized. Then, my lord, whether it comes in the definition of right once. This is a partnership firm's property has been used for the purpose of claiming to be the co-share of the property. Now, this whether this partnership firm unregistered partnership 69(2) is there.
No, PMT, you are a partnership firm also.
None. I am individual, my lord, Sanjay Agarwal. Page 148. Can you turn to page 148, my lord will find.
They say that the preemptees through their partnership firm has purchased the land. Second paragraph, that preemptee should be preempted.
Yes, preempted. Bajrang is preempted. Continue actually, my lord. Now one can turn to.
They go on repeating that in second paragraph 4 also. Anyway.
Now one can consider whether done once for the sake of argument, my lord can turn to definition of wrath once.
Yes.
Section 2.
Person or an institution holding
Yes.
land.
This institution have been, it is not a person by an institution, whether unregistered, this is came up considered with the honorable court. Hell, this unregistered body cannot be termed to be an association institution under the West Bengal Land Reforms Act.
Then the
Forget it.
partners individually, do they want?
Then matter how the partnership property can be used for the purpose of individual application.
Asset of partnership.
Yes. How they have any right to the assets of partnership?
Partnership purchased.
Partnership purchased.
But this is a new point, Mr.
On that application, I have not disclosed any defense over me.
27 against miscellaneous appeal, we cannot take this. We
No,
can
this-
permit you to take it before the trial. You can remand it, but this ground has to go, this short deposit ground.
Short deposit, I'm candid because I need to argue. That's why, for the sake of argument, I have to say. But I have also some reservation regarding the.
No, that I understand, but you cannot take a point for the first time. They are taken by surprise.
No,
In the second point.
Pilot can. It is the point regarding maintainability. If your lordship, it appeals to your lordship that on the face of the record it is not maintainable, whether your lordship relegate the parties to another 3 rounds of litigation. I'm not asking for adducing any evidence. It is their application, their documents, they are relying upon.
Point was never taken.
That I am
Not even considered. They were not heard on this point. For the first time in
Why-
227, how can?
better whether my lord can consider it that way.
227 is not a root jurisdiction.
Perversity.
It's a supervisory jurisdiction. Therefore, paid that you receive granted. And in the prayer portion, they say grant right of preemption of the preemptors,
Preemptors.
not in the name of the partnership firm.
Sir, if you want to say that I am the preempted individual body, then you cannot utilize the assets of the partnership firm. If you say that partnership firm is applying for preemption, then being an unregistered body,
Because partnership firm, unregistered partnership firm can purchase property,
yes,
but cannot litigate.
you cannot enforce your right. And precisely, my lord, that came up subject to question. Agradut Sangho, better my lord knows better than us. This 2006 volume 1 says
Give a copy to them also. If
yes, I have supplied. Paragraph 41, my lord. Paragraph 43. Forgive me, paragraph 38.
This is on a different.
No, this is unregistered society. That is why, my lord, it is held, my lord. Paragraph 38 once, my lord, from this section. It's absolutely clear how the properties of a registered society should vest and in whom the vest. The judicial pronouncement of Supreme Court in such and such, which I referred to above somewhat detailed. Namely, I have dealt with the
Para
portion of
43.
38, my lord. I beg to be corrected, my lord. Paragraph
Yes.
30, at the top, my lord.
Yes.
Which I have referred to above somewhat detailed. Namely, I have dealt with the proportion portions of the said judgment of the Supreme Court which have direct and most material bearing upon the question. I am dealing with the and point or points in issue leaves no manner of doubt that a registered society under the Society Registration Act can alone claim in its legal existence simply by virtue of registration under the
This is governed by section 69. Not
no, that is
registration.
it is 69 my lord, if you are to enforce your right, then it is regard to registration under section under the Partnership Act.
No, but Mr. Rai, then you say their premise of their claim goes because that they are not the owners of that
Of the property.
in their individual capacity.
If they want to say that we are the partners, we have right of the individually, or the partnership property is not correct.
Neither co-sharers nor contiguous owners because the purchase itself was in the name of
Yes.
the part. This is a new point. You can take that point in the trial court. We'll keep it open. But they will be taken by absolute surprise. 227 for the first time shocks the conscience.
It's
a very good point. Very good point. Probably their application will be rejected on that. They should have taken that point instead of this.
that. Kindly later, so we can apply
This question.
questions.
No, this has to be decided first.
Yes.
By the trial. We'll not only keep it open, we'll direct the trial court to decide.
Yes.
We'll let you take this point before the trial court.
Yes.
The other point
Thank
is
you.
very valid.
May I have a lordship leave to otherwise?
You have a flight today? When?
6:35.
No, stay back for 1 hour at least.
My lord, for 2 days today, otherwise, my lord, there is high chance of something there. No.
But I may change my mind midway. Mr. Mukherjee will not let you go. Mr. Mukherjee will never let you go if I say that. No, I'll do that. I'll allow this revisional application
That's the point, my lord.
on the ground, particularly on the ground of Chalan and
One
this-
thing, my lord, so but if your lordship
Yes.
takes up the Barshata Hospital once,
Yes.
what is fallen from your lordship, my lord will find the
Yes.
same Barshata Hospital judgment. Sampati na, Barshata Hospital. Barshata Hospital. Hey. Barshata.
It was held to be a speculative right, strong right. Otherwise, it's a weak right. So you cannot give a part deposit and wait for eternity to
Yes,
put the.
speculative. That is
But ultimately, it was held that it was not. It could not be triggered.
yes,
That is the language of section 9 also.
triggered. But,
No notice would be served.
but
The language is not. No notice will be served is somewhat like not entertained. Entertained has
but
been
that was interpreted some other way by because
entertained.
it was held that precondition for deposit the interconsideration is not the mandatory provision under the Original Land Reforms Act. Severalist judgment, my lord.
Precondition is not.
Mandatory because there is no penal consequence for non-depositing the interconsideration amount. Unlikely to non-agricultural. Yes.
No, section 8.1. Section 8.
Sovereignty has been decided by the Supreme Court after that, my lord. Barshata Hospital. What is my lord referred the
Section 8.1 says a portion of share is transferred to any person. Any co-sharer may within 3 months or such and such other apply to the munsif having territorial jurisdiction for transfer of the said portion of land to him. Now this subject to the limit on deposit of the consideration money.
Yes.
So whether on deposit qualifies transfer or application, that is one of the questions.
The transfer that is subsequently.
That is transfer because of section 9.1.
No other because Severalist judgment, my lord, when it was
Yes.
there is no option to refund. There is no provision for refund
Right,
of the money.
right.
But now after amendment of the Original Land Reforms Act, there is
Is a provision
to
for
refund.
refund.
That is why it was held that on the premises the Severalist judgment was
Yes,
delivered.
section 9.1 dilutes section 8 to that
Yes.
extent. On the deposit,
But you have to
munsif shall
raise that
give-
question. After depositing the said amount, you have to raise
No,
the-
not even inquiry. It starts with on the deposit mentioned in subsection 1
Yes.
of 8, munsif shall give notice of the application to the transferee and shall also cause a notice to be affixed.
Yes.
Does not say it will be rejected.
That is precisely, my lord. So
Notice is issued later.
Yes.
Notice is always subsequent to the filing of the application, right? So notice will not be issued forever if they choose to not.
That is why, that is something, it is the point of limitation on the
And
face
that
of
has
it.
been the consistent view of Calcutta High Court.
No, initially, subject to question, it was held, that once you are, according to me, this is the concession amount which actually passed between the parties, and deposit the amount and file the application for preemption. If I did not file any amount, then the application will be kept in limbo.
Yes.
No notice. But
Yes,
if
that
I
is what
deposit
I'm.
some amount, according to me, that is the concession
No,
amount.
it is not that. They have deposited the amount. It is.
No, they cannot. As of this day, they cannot. Now, what is following from my lordship, that your lordship will find in Barshat Eye Hospital, paragraph 34. As we have discussed above, once the time period to exercise a right is sacrosanct, then the deposit of full amount within the time is also sacrosanct.
Now, if it was on 16th of October, it would be within 3 months also. Contiguous is 3 or 4? Forgot.
4. Contiguous is
4. So it would be within 4.
No, 1 day. 1 day it is.
According to them, the cause of action is
17.3. 17.7.
Using 4
months. Not day, number of days.
Deposited or filed.
Not number of days.
If my lord held that the passing of the challan.
Month may have 28 or 31 days.
So therefore, if your lordship held that the passing of the challan is a date for depositing,
yes,
then my lord, they are within time.
Yes,
but
only if I hold that.
Actually deposited, then that is.
No, the challan. I'll hold the challan to be.
That is then if my lord hold, then I have no
Otherwise,
cause.
it will be ridiculous. The right will.
Then my lord, after passing of the challan, if somebody did not deposit that amount, my lord can consider that way also. Our challan has been passed.
Challan, passing of the challan is the starting point. That is what I said at the inception.
Yes.
Passing of the challan is starting point. If they don't deposit after that,
Yes,
never
yes.
culminates.
Yes,
Never culminates. And
So
if they
that is
deposit
not-
beyond limitation, then because they are also arguing this, the treasury was closed for that period.
That my lord is there, my lord. I don't know because the court is of the opinion that 1 day they was there, my lord. I'm not on that. If my lord's hold, that is the date of right to apply for preemption in this file.
Or I can do this. I can put it one step further. I'll set it aside. I'll remand it and direct the first court to consider whether it was 16th. 16th is the date of challenge. That is the initiation of the deposit. I'll say.
No, this is a passing of the challan.
Passing of the channel is the initiation of the process of deposit. This is the
Yes.
language I'll use, and it culminates in their actual deposit.
Actual deposit is.
And the court will see whether the entire interim was covered by the holiday of the treasury.
Yes.
That I can direct the trial court to, because that's a factual question. 227 court should not go into that.
Yes. And the other portion, my lord, so we can make
No, that I'll keep open. Learned an interesting question. Yes, an interesting question has been raised in the present case. First up, both the courts below rejected the application under Section 8 of the West Bengal Land Reforms Act 1955 filed by the revisionist petitioners for preemption on the dual ground of contiguous ownership and unnotified co-sharer, non-notified co-sharer. Next para, learned counsel for the petitioner argues that the learned courts below failed to take into consideration the fact that simultaneously with the filing of the preemption application on October 16, 2020, where is the challan again? 167.
166.
October 16, 2020. This is 2025. 2025.
23.
2023, comma. The petitioner, comma, in a bid to deposit the entire statutory deposit, comma, applied for a challan, which has been annexed at page 167 of the revisional application. Full stop. The challan was sanctioned and handed over to the petitioner on the next day, that is on October 17, 2023. Full stop. However, comma, since the treasury, comma, where the deposit was to be physically made, comma, was closed between October 18 and November 1, 2023, comma, the challan, the deposit could not be made before the treasury before November 2, 2023, when it was actually made. Full stop. Thus, comma, it is argued that the deposit was made well within time. Full stop. Since the cause of action pleaded in the preemption application is what is that date of July 17, 2022. Sorry, July 7, 2022, 3, comma, the filing of the application for preemption as well as the deposit ought to be construed to be October 16, 2023, comma, which was within the limitation of period of 4 months as stipulated under section 8 within bracket 1 of the 1955 Act on the ground of contiguous ownership as well as within the limitation period of 1 year on the ground of non-notified co-sharer. Full stop. Next para. Learned counsel places reliance on the division bench judgment of this court in the matter of Nurul Islam versus Estarun Bibi, reported at 2017 SCC Online Cal 11063 for the proposition that if an application for preemption under section 8 is filed on the ground of non-notified co-sharership, comma, Article 97 of the Limitation Act 1963 applies and the period of limitation shall be construed to be 1 year. Full stop. Next para. It is further argued that the learned courts below misconstrued the judgment rendered in Barasat Eye Hospital and others versus Kaustubh Mondal, reported at 2019-19 SCC 767, comma, since in the said judgment, comma, the Supreme Court observed that there cannot be any speculative litigation without the deposit of full consideration, and as such, the application for preemption would not be within double inverted triggered unless the entire amount was paid. Full stop. Read in conjunction with the provisions of sections 8 within bracket 1 and 9 within bracket 1 of the 1955 Act, comma, it is argued, comma, the deposit, comma, even if not made simultaneously with the application, comma, has to be made within the limitation period. Full stop. Next para. Learned counsel for the opposite party, preemptive stroke opposite party, opposes the revisional application and cites Abdul Motin Malik versus Subroto Bhattacharjee. Isn't it a reported judgment?
Yes, yes, Abdul reported. It is reported, my lord.
2022 7 SCC page 140. Reported at 22. Thank you. 2022 7 SCC 147, where the proposition laid down in Barasat Eye Hospital was considered by the Honorable Supreme Court. Full stop. Upon such consideration, comma, it was observed by the Honorable Supreme Court that deposit of the entire sale consideration with additional 10% of the sale consideration has to be made along with the preemption application, comma, which is a statutory and mandatory requirement, and it is a precondition before any further inquiry as contemplated under section 9 of the Act is held. Full stop. Thus, comma, the proposition sought to be advanced by the petitioner, comma, it is argued, comma, to the effect that a deposit could be made later as well, comma, is not tenable in the eye of law. Full stop. Next para. Learned counsel for the
Yes. For Barasat Hospital, what is followed for lordship, that has been quoted.
Thanks. Learned counsel for the opposite party also places reliance on Barasat Eye Hospital Supra, comma, where it was held that to give a discretion to the preemptor, comma, without deposit of the full consideration, comma, to file the preemption application, comma, would give rise to speculative litigation, whereof where the preemptor, comma, by depositing smaller amounts, comma, can drag on the issue of the vendee exercising rights in pursuance of the valid sale deed executed. Full stop. Next para. In the said judgment, comma, the Supreme Court further held that the requirement of exercising the right of preemption within the stipulated time in respect of the very provision was held to be sacrosanct, that is, there can be no extension of time granted even by recourse to Section 5 of the Limitation Act. Next para. Learned counsel for the preemptive opposite party next argues, by placing reliance on a division bench judgment of this court in the matter of Usharani Kundu versus Ogrodut Sangho, reported at 2006 1 CLJ 627, that an unregistered club cannot acquire or hold immovable property as a living person. First up, by placing reliance on the definition of double inverted with the riot in section 2 within bracket 10 of the 1955 Act, comma, learned counsel argues that riot means a person or an institution holding land for any purpose whatsoever. Push up next para. In the present case, comma, it is an admitted position that the petitioners claim to be the partner of an unregistered firm and has filed the preemption application in such capacity. Push up learned counsel for the preemptive opposite party argues that although a partnership firm, comma, even if unregistered, comma, can purchase and acquire property in its own name, comma, such a firm cannot litigate in a court of law, comma, in view of the bar under Section 69 of the Partnership Act. Full next para, as such, comma, the partnership firm could not come within the ambit of double inverted institution as defined in Section 2 within bracket 10, comma, to claim a right of preemption in the capacity of a riot. Full stop. On the other hand, comma, in the event the petitioners claim the right of preemption in their personal capacities, comma, the very right is defeated, comma, since the purchase was made in the name of the partnership firm. Full stop. The partnership firm, comma, since unregistered, comma, could acquire a valid title in the property, but the petitioners, comma, in their individual capacities, comma, could not claim ownership of such title to the said property which belongs to the partnership firm. Full stop. If that be so, comma, it is argued, comma, the preemption application is not maintainable at all, comma, since the petitioners, comma, in their individual capacities are neither contiguous owners nor co-sharers, comma, non-notified or otherwise vis-a-vis the concerned plot. Full stop. Next para. Learned counsel appealing for the petitioner in reply submits that, we'll put it on your mouth, that was not taken in there, submits that the last limb of argument of the preemptive opposite party was never urged before either of the fora below, and as such cannot be taken for the first time in an application under Article 227 of the Constitution of India. Next para. Insofar as the first ground is concerned, comma, a composite reading of the judgments of the Supreme Court in the matter of Barasat Eye Hospital Supra and Abdul Matin Malik Supra, comma, it transpires that the Supreme Court held that a preemption application cannot be triggered, comma, in the sense as contemplated in Section 9 within bracket 1, which envisages that a notice can be issued on a preemption application only upon full deposit being made as per the stipulation in the statute, comma, would prevent the application from being triggered. Next para. In Abdul Matin Malik Supra, comma, the Supreme Court places reliance on the proposition laid down in Barasat Eye Hospital and observes that deposit of the entire sale consideration with additional 10% of the sale consideration along with the preemption application is a statutory and mandatory requirement, and it is a precondition before any further inquiry as contemplated under Section 9 of the Act is held. Full stop. In the said case, comma, it was observed, comma, the preemptors had admittedly not deposited the entire sale consideration with additional 10% of the sale consideration along with the preemption application, which aspects were held not to have been considered by the first appellate court or the high court. Full stop. Next para. In paragraph 8 of Abdul Motin Supra, comma, it was held that, sorry, in paragraph 8 of the of Abdul Motin Supra, comma, the Supreme Court observed further that insofar as the submission on behalf of the preemptors that the contention of non-deposit of entire sale consideration with additional 10% was not raised before the courts, এটা ছেড়ে দাও, এটা sentence থেকে কেটে দাও। Full stop. Next para, in Abdul Motin Supra, comma, the Supreme Court proceeded accordingly to dismiss the preemption application. Full stop. Next para. It is conspicuous that in paragraph number 9 of Abdul Motin Mullik Supra, comma, the Supreme Court observed that faced with the decision of the Supreme Court in the case of Barasat Eye Hospital Supra, and in the light of observations made by the said court in the judgment of Abdul Motin Supra, comma, that along with the preemption application, the preemptors have to deposit the entire sale consideration with additional 10%, and only thereafter the further inquiry can be conducted. And therefore, unless and until the same is complied with, the preemption application would not be maintainable, comma, it was held that the High Court is not justified in permitting the preemptors to subsequently deposit balance sale consideration with additional 10%. So next para, a distinction has to be drawn with a case where a part deposit is made along with the application and the entire deposit, the balance deposit is made subsequently. Full stop. In such a case, comma, it would be an occasion to hold that the preemption application was not filed with the statutory deposits and accordingly could not be triggered and no notice could be served. Full stop. The Supreme Court, comma, although observing that the Supreme Court, comma, in Abdul Motin Mullik Supra, comma, although observing that the statutory deposit has to be made along with the preemption application, comma, does not categorically record a proposition of law that unless such deposit is made, comma, the preemption application will be dismissed outright. Full stop. In the facts of the case of Abdul Motin Mullik Supra, comma, the Supreme Court had dismissed the preemption application because the deposit was made, balance deposit was made much subsequently. Full stop. However, comma, the Supreme Court itself, comma, in the self-same judgment, categorically relied on Barasat Eye Hospital and also observed that unless along with the preemption application, comma, the preemptors do not deposit the entire sale condition with additional 10%, comma, the further inquiry shall not be conducted as per section 9 of the Act, comma, 1955. Full stop. Thus, comma, from the self-same judgment of Abdul Motin Mullik, comma, two divergent propositions can be construed. Full stop. It is well settled that a judgment is a precedent for what it holds and not something which can be derived therefrom. Full stop. The proposition in Abdul Motin Supra was rendered in the light of Barasat Eye Hospital, where the Supreme Court held merely that a preemption application shall not be double inverted mode triggered unless the entire deposit is made. Full stop. In Abdul Motin Mullik as well, comma, the Supreme Court observed not that the preemption application shall be rejected outright, but in the proposition part of the judgment, comma, the Supreme Court held that unless the entire deposit, statutory deposit, is made along with the application, comma, further inquiry cannot be conducted as per section 9 of the 1955 Act. Full stop. Thus, comma, relying on the actual ratio laid down in Abdul Motin Mullik, comma, shorn of the factual conclusion arrived at by the Honorable Supreme Court in the said judgment, comma, we have to read the same in the context of sections 8 and 9 of the 55 Act. Full stop. Section 8 within bracket 1 provides that an application shall be made for preemption on the ground stated therein for transfer of the plot of land, comma, subject to the limit, on deposit of the consideration money together with further sum of 10% of that amount. Full stop. The question which arises as to whether the expression double inverted মধ্যে on deposit of the consideration money together with further sum of 10% double inverted clause qualifies the transfer or the application itself. Full stop. Such question, comma, however, comma, is answered in section 9 within bracket 1 of the 1955 Act in clear terms, which does not provide the sanction of dismissal of the application if the entire deposit is not made simultaneously with the application, but that the munsif shall give notice of the application to the transferee only upon the deposit being made. Full stop. Next para. As such, comma, the proposition of Abdul Motin Mollik, which, comma, as per the Supreme Court itself, comma, followed the judgment of Barasat Eye Hospital and read in conjunction, comma, the proposition which can be distilled from both the judgments is that unless the statutory deposit is made, comma, no further inquiry under section 9 within bracket 1 of the 1955 Act can be initiated. Full stop. Thus, comma, the application for preemption will remain in limbo until and unless the entire deposit is made. Full stop. Such an interpretation also is in consonance with the scheme of section 9, which provides that in the event a dispute is raised as to the actual consideration amount, comma, such dispute has to be inquired into by the munsif and a decision being taken only whereafter the assessed amount can be paid. Full stop. Such scheme would be frustrated if we construe Abdul Motin Mollik's judgment to have held that the entire consideration has to be deposited simultaneously with the application, since in a case where a subsequent dispute is raised as to consideration money, comma, the proposition of Abdul Motin Mollik, comma, if construed strictly, comma, would also interdict such amount from being deposited subsequently. Full stop, comma, thereby negating the entire provision of section 9 of the 1955 Act. Full stop. Next para. In view of the above interpretation, comma, we are of the opinion that the only fetter, I am of the opinion that the only fetter for taking out an application under section 8 of the 1955 Act is that the entire deposit has to be made within the limitation period vis-a-vis the grounds taken in the limitation in the preemption application. Full stop. There can be 3 scenarios in such context. Full stop. Next para. First, comma, if there is a single ground on which preemption is sought, comma, the limitation period will be defined by such ground, and unless the entire statutory deposit is made within the limitation period simultaneously with the application for preemption or subsequent to the same but within the limitation period, comma, no notice would be issued under section 9 within bracket 1 as per the proposition laid down in Abdul Motin Mollik Supra. Push up. Next para, the second scenario could be that a preemption application is founded on several grounds, comma, in which case it should be the largest limitation period, comma, available from a collective perusal of all the grounds taken in the application for preemption, comma, which should be the defining outer limit for depositing the entire statutory deposit. Full stop. Next para, unless such amount is deposited within the limitation period, comma, it will be open to the court taking up the preemption application to reject the application for preemption on the ground that the entire deposit has not been made within the statutory limitation period. Full stop. Next para. A third situation may arise when the deposit is made simultaneously with the application for preemption, when, of course, comma, the only scope of inquiry will remain in respect of the consideration amount, which can only be taken subsequently by the preemptee opposite party, and thereafter an inquiry can be held. Full stop. Out of the above, comma, in the present case, comma, the second scenario is applicable inasmuch as the preemption application was filed on two separate grounds. Full stop. However, comma, I find from the records that the challan was sought to be obtained and applied for on October 16, 2025, comma, which, comma, incidentally was the date of filing of the preemption application, as well as barely, comma, although barely, comma, within the limitation period for filing an application under Section 8 of the 1955 Act on the ground of contiguous ownership. Full stop. Needless to say, comma, the application and the the application for the preemption application and the application for challan were made much within the limitation period of 1 year on the ground of unnotified co-sharership. Full stop. It may be, I am of the clear opinion that the deposit within double inverted, as contemplated in the 1955 Act, is not a solitary act of merely depositing the amount physically. Full stop. Since, as per the paraphernalia which are observed by our district courts, comma, the deposit has to be made in a treasury, comma, we cannot be oblivious of the fact that such deposit has to be preceded by a proper challan being obtained from the court, comma, which is not issued unless there is some application or matter on board. Full stop. Hence, comma, it would be impossible for a proposed preemptor, Mr. Raikan, preemptor it would be impossible for a proposed preemptor to make the deposit physically before the treasury unless the application is actually filed and a challan obtained. Full stop. Thus, comma, the initiation of the process of deposit is the date on which the challan is applied for, comma, which culminates in the date when the actual deposit is made. Full stop. The same is a continuum and cannot be dissociated from each other by isolating the date of actual deposit as the only date which is to be considered as the date of deposit. Full stop. In the present case, comma, the petitioner has contended that the challan was applied for on October 16, 2025 and was sanctioned on the very next date. Full stop. However, comma, from the day thereafter, that is October 18, 2023 till November 1, 2023, comma, the treasury was closed, comma, the deposit was made on the very first opening working day of the treasury thereafter. Thus, comma, the entire period during which the treasury was closed must be deducted from the period when the deposit was not made. Full stop. Hence, comma, the relevant date would be October 16, 23, when the challan was applied for, and November 2, 2023, comma, when the deposit was made. Full stop. In the circumstances of the case, comma, if the petitioner is correct in submitting that the treasury was really closed from November 18, 2023 till November 1, 2023, comma, the deposit would be valid, comma, since the physical deposit of the money with the treasury on November 2, 2023 would relate back to the date of application for the challan, that is October 16, 2023, which is simultaneous with the filing of the preemption application and well within the limitation period for preemption on the ground of contiguous ownership. Full stop. However, comma, the 227 court is not the appropriate forum to decide on facts whether the treasury was actually closed on the relevant dates, and such consideration had to be made by the learned first court. Full stop. Next, the learned court of first instance. Full stop. However, comma, the outright dismissal of the preemption application by both the courts below on the ground that the deposit was not made in time is not tenable in the eye of law, comma, in the absence of any adjudication on the considerations as indicated above. Full stop. Furthermore, comma, since a new objection of maintainability has been raised, inasmuch as the preemptee argues that the petitioners, comma, in their individual capacities cannot maintain the preemption application since the property was acquired by the partnership firm, comma, alternatively, the petitioners cannot apply for preemption as partners, comma, since the firm is unregistered, comma, the said question is also required to be adjudicated by the court of first instance. Accordingly, comma, in view of the above observations, CO number 113 of 2025, Y2,
My lord, there are
two land,
two
two,
land,
two,
two
to sell
deeds.
deeds, right? Accordingly, CO 113 of 2025 and CO 114 of 2025 are allowed, comma, thereby setting aside the orders impugned therein respectively, being
My lord, in 113 is order dated 23/2025.
dates will be same, but the numbers of the appeal and the
Only numbers of appeal is different. My lord.
numbers of appeal.
Two
What are
and
the
three.
numbers?
One is
2 and 3, and the other miss case?
My lord, in 113 it is miss appeal number
3 and
of
79,
24.
and the other one 2 and
Yes, 2 of
78.
20, yes,
2 and 78. Very well. Respectively, the judgment and order passed in judgment and order dated March 20, 2025, passed in miscellaneous appeal number 3 of 2024, thereby affirming the order dated December 18, 2023, passed in miscellaneous bracket preemption bracket close case 79 of 2023 by the learned civil judge junior division at Jalpaiguri. Ageta passed by the learned district judge at Jalpaiguri, miss appeal. And the judgment and order dated March 20, 2025, passed by the learned district judge at Jalpaiguri in miscellaneous appeal number 2 of 2024, comma, thereby affirming the order dated December 18, 2023, passed in miscellaneous bracket preemption bracket close case number 78 of 2023 by the learned civil judge junior division at Jalpaiguri. Push up the matter is hereby remanded to the court of the learned civil judge junior division at Jalpaiguri to re-adjudicate the issue of maintainability on the grounds as indicated above. Full stop. For further clarification, comma, the learned civil judge junior division at Jalpaiguri shall decide as to whether the treasury was closed between November 18, 2023 and November 1, 2023. Full stop. In the event the petitioner is able to prove such dates, comma, the issue of maintainability on the ground of deposit, the statutory deposit being made subsequent to the preemption application shall be turned down. Full stop. Otherwise, comma, the said issue shall be upheld with regard to the ground of contiguous ownership. Full stop. In such case, comma, the learned trial judge shall grant liberty to the petitioner to file a fresh application for preemption under Section 8 within the period of limitation of 1 year from the date of cause of action, only on the ground of unnotified co-sharership. Next para. That apart, comma, liberty is granted to the preemptive stroke opposite party number 1 to raise the objection as to maintainability before the learned civil judge junior division as to the preemption application not being maintainable on the alternative grounds that if the petitioners have applied in their individual capacity, the preemption application would not be maintainable, comma, since the property in question was acquired in the name of the partnership firm and it would not entitle the petitioners in their individual capacity to claim preemption under any of the grounds of Section 8, or if the petitioners claim as partners of the said partnership firm, comma, in view of the partnership firm being unregistered, comma, whether the preemption application is barred under Section 69 of the Partnership Act. Full stop. If such question is raised, comma, the learned trial judge shall grant opportunity to both parties to argue on the same and decide the question of maintainability on such issue as well. Full stop. In view of the long pendency of the matter, comma, it is expected that the issue of maintainability of both counts, comma, if raised, comma, shall be decided by the learned trial judge at the earliest, comma, preferably within 2 months from the date of communication of this order to the learned trial judge. and thereafter proceed with the hearing of the preemption case subject to the outcome of the maintainability issue. বলুন।
My lord, may I just indicate, my lord, on certain places, my lord had indicated the
Din,
date
din,
as
din.
2025. It ought to be 23.
Yes, yes, 25 was playing in my mind. অনেক জায়গায় 25 করে গেছি 23 most well my officers are too competent, they have done it already. Yes, they know my হ্যাঁ 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 হ্যাঁ
Section 5 allow for section 5 at a long time. কারণ এই দুটোই ইনফরমেশন চেক অ্যাপ্লিকেশন নিয়ে দুটো রেস্ট করে ফেলতে এই রকম সেকশন মধ্যে আগে ড্র করতে তারপর মেন
একটা নেট খুঁজুন যে এটা কি মায়াঙ্ক ভান্ডারি Mr. Devorshi Dhar is there. Mr. Mukherjee, can you please inform Mr. Devorshi Dhar in a matter where he was appearing? এটা কি মজুমদার ছিলেন যেটা আছে Mr. Mujumdar, DSGI was on the other side. Mr. Dhar, we are joking about Mr. Dhar. So just inform Mr. Dhar, there was a Section 5 application also. I'll add a line that the Section 5 is allowed in one line. Because we have decided the revisional application on contest, but Section 5 was formally not allowed. Please inform him, anybody of you can inform him, Mr. Datta, any one of you, that I have formally allowed this Section 5 also.